Test, test. Test, test, test for Mr. Johnson, speaker, test.
The Judiciary Committee will please come to order, a quorum being present.
Be happy to.
Without objection, the Chair is authorized to declare recess at any time pursuant to Committee Rule 2 and House Rule 11, Clause 2. The Chair may postpone further proceedings today on the question of approving any matter or measure or adopting an amendment for which a recorded vote for the ayes and nays are ordered. I want to thank everyone for coming. I know some people are here for the arbitration bill, others for bills about preventing gun violence, and still others about intellectual property. We are going to start with the arbitration bill, so it may be some time before we get to the gun violence prevention bills. That said, I do want to recognize the gentleman from California, Congressman Carbajal, whose bill we will be marking up today, and I want to thank him for joining us.
Mr. Chairman, could I just raise you mentioned the schedule for today's hearing. I just had a question on the schedule.
Sure.
Going forward, not so much about today. When will the committee get a chance to question Mr. Horowitz on his report that was released 2 weeks ago?
I'm not sure which report you're referring to, but...
I'm referring to the scathing report on the former FBI Director, James Comey.
The Ray report. The answer is I don't know.
Do you anticipate us having an opportunity to question
I don't know
the
that
inspector?
either.
You don't know?
I don't know. We haven't discussed that.
You don't know that the
sir.
Judiciary Committee is going to get an opportunity to question the Inspector General of the Justice Department, who issued a scathing report on the former FBI Director?
We will do that at an appropriate time. Pursuant to notice...
And I'm asking when that appropriate time is.
Pursuant to notice, I now call up H.R.
Mr. Chairman, if I could just, one last point.
No.
It would seem
Pursuant
to me...
notice, I recognize the gentleman out of order, and he asked this question, that's it.
But the chairman of the Judiciary Committee is not going to schedule the Inspector General to answer our questions.
H.R. 1423, the Forced Arbitration and Justice Repeal Act, the FAIR Act, for purposes of markup, and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 1423, to amend Title IX of the United States Code with respect to arbitration.
Without objection, the bill is considered as read and open for amendment at any point. I will begin by recognizing myself for an opening statement. H.R. 1423, the Forced Arbitration Injustice Repeal Act, or the FAIR Act, would restore access to justice for millions of Americans who are currently locked out of the court system and are forced to settle their disputes against companies in a private system of arbitration that often favors the company over the individual. Nearly a century ago, Congress enacted the Federal Arbitration Act to allow merchants to resolve run-of-the-mill contract disputes in a system of private arbitration that would be legally enforceable. The system that Congress envisioned was to be used voluntarily and only between merchants of equal bargaining power. However, over the past 40 years, the Supreme Court has issued a series of decisions that have expanded the use of arbitration far beyond Congress's original intent, creating the very unjust system we see today. Private arbitration has been transformed from a voluntary forum for companies to resolve commercial disputes into a legal nightmare for millions of consumers, employees, and others who are forced into arbitration and are unable to enforce certain fundamental rights in court. Many companies use forced arbitration as a tool to protect themselves from consumers and workers who seek to hold them accountable for alleged wrongdoing. By burying a forced arbitration clause deep in the fine print of a take-it-or-leave-it consumer and employment contract, companies can evade the court system, where plaintiffs have far greater legal protections, and hide behind a one-sided process that is tilted in their favor. For example, arbitration generally limits discovery, does not adhere to the federal rules of civil procedure, can prohibit class actions, which it almost always does, and deny the right of appeal. Worse yet, arbitration allows the proceedings, and often even the results, to stay secret, thereby permitting companies to avoid public scrutiny of potential misconduct. For millions of consumers and employees, the precondition, whether they know it or not, of obtaining a basic service or product, such as a bank account, a cell phone, a credit card, or even a job, is that they must agree to resolve any disputes in private arbitration. We used to refer to contracts like these as contracts of adhesion, in which one party with all the power dictates the terms to the other party in a take-it-or-leave-it contract. The next time you apply for a credit card, try crossing out the term in the fine print requiring you to agree to arbitration and see if you still get the credit card. You will be denied without a moment's hesitation. These are classic contracts of adhesion, which were once thought to be disfavored under the law, but which now seem to be standard operating procedure in the corporate world. For individuals who have no choice but to agree to these contracts, that means that their ability to enforce civil rights, consumer, labor, and antitrust laws are subject to the whims of a private arbitrator. An arbitrator is selected often by the companies themselves. These private arbitrators are not required to provide plaintiffs any of the fundamental protections guaranteed in the courts, and their further employment can depend on building a good reputation with the companies that hire them. And for many companies, arbitration has become a virtual get-out-of-free-jail card to circumvent the basic rights of consumers and workers. We have a bedrock principle in this country, and that is that all Americans deserve their day in court. We make a mockery of this principle, however, when individuals can be stripped of this fundamental right and be forced into private arbitration proceedings without the safeguards our judicial system affords. Yet that is where we find ourselves today. During an oversight hearing on arbitration in the Antitrust, Commercial, and Administrative Law Subcommittee, a panel of leading academic experts and practitioners and people affected by forced arbitration testified in support of ending this shameful practice. For example, Deepak Gupta, a prominent public interest attorney, testified that forced arbitration has eroded countless fundamental rights established by Congress by rendering them virtually unenforceable. As he explained during the hearing, quote, "The presence of a forced arbitration clause often means that Americans will have no effective method of asserting their rights or getting justice under federal laws that could otherwise have been enforced in court. Consumer protection or antitrust laws, for example, or prohibitions on sex or race discrimination. If Congress passes laws that cannot be enforced in the real world, what good are those laws?" Close quote. H.R. 1423, the Forced Arbitration Injustice Repeal Act, or the FAIR Act, reverses this disastrous trend by prohibiting the enforcement of forced arbitration clauses in consumer, labor, antitrust, and civil rights disputes. Importantly, the legislation does not preclude parties from agreeing to arbitrate a claim after the dispute arises, which will ensure that arbitration agreements are truly voluntary and transparent. I applaud the gentleman from Georgia, Mr. Johnson, for his leadership on this legislation, which currently has 216 co-sponsors. This measure is also supported by a broad coalition of more than 70 public interest, labor, and advocacy organizations, including Public Citizen, Consumer Reports, the Communications Workers of America, the Leadership Conference on Civil Rights, and the American Association of Justice. In addition, 84% of Americans across the political spectrum support ending forced arbitration in employment and consumer disputes, according to recent polling data. It is up to Congress to end this secretive and unfair practice. I urge my colleagues to support the FAIR Act and to restore access to justice for millions of Americans. I now recognize the ranking member of the Judiciary Committee, the gentleman from Georgia, Mr. Collins, for his opening statement.
Thank you, Mr. Chairman, and welcome back to September. Arbitration gives consumers a simpler, cheaper, and faster path to justice than does the judicial system. That is what the evidence showed in the last time the Judiciary Committee performed oversights of the arbitration system during the 111th Congress. That is what the evidence showed earlier this term when we renewed that oversight in the Subcommittee on Antitrust, Commercial Law, and Administrative Law. In fact, the evidence in favor of preserving access to arbitration has only increased over time. Companies are continuing to improve the fairness of arbitration agreements and have long been following improved arbitration protocols to help assure due process is given to claimants against them. The market has resolved problems in the consumer credit arbitration considered during the 110th and 111th Congress, and a string of new Supreme Court decisions has demonstrated the court's confidence in the arbitration system. Even the Consumer Financial Protection Bureau's 2015 arbitration study highlighted problems consumers would face if they had no access to arbitration, but instead had to only rely on flawed judicial class actions. The study emphasized the rise of pre-dispute mandatory binding arbitration agreements in the consumer settings did not come out of nowhere. It stems directly from the repeated abuses of class actions that have plagued the judicial system in recent decades. That is not to say the arbitration system is perfect, but the arbitration system is generally good and should be preserved. Unfortunately, that is not what the Forced Arbitration Injustice Repeal Act would do. Rather than preserve and strengthen arbitration, it would wipe it out for enormous numbers of consumers and employment disputes, as well as many civil rights and antitrust disputes. What that would do is not end injustice, but it actually would promote injustice. In far too many cases where everyday consumers and employees are denied rights to arbitrate, rights that their contract guarantees them to, it means that they will be shut out of the judicial system entirely. If their claims are small enough, they can go to small claims court. That may be an option. But in 46 states in the District of Columbia, small claims courts only take claims worth $10,000 or more, or $10,000 or less. 30 of those jurisdictions, limits are set at $5,000 or less. Millions of claimants with case worth amounts not much higher than those ceilings will never be able to pay courtroom lawyers enough to take care of their cases in ordinary trial courts. Maybe if the claimants could qualify as plaintiffs in a class action lawsuit, they could join in those cases. Millions of people, however, will not be able to do so. Even those who join a class action lawsuit often expect to get nothing in return but a postcard telling them they've won a few dollars and cents on a coupon. Meanwhile, the class action plaintiff trial lawyers will reap multi-million-dollar shares in fees from the recoveries they dole out to plaintiff's case members at mere pennies on the dollar. If you ask me, it would be better to call this bill the Forced Class Action Injustice Guarantee Act. Rather than wipe out arbitration, we should be considering ways to make it better. And while we do that, we should do everything we can to reform all the abuses out of the class action system. Senate Judiciary Committee Chairman Graham suggested that we do just that at the Senate Judiciary Committee's hearing on the arbitration earlier this year. He was exactly right. The worst result Congress could deliver for the American people would be to wipe out their access to arbitration while leaving them no alternative but an unreformed judicial system. It is amazing to me, again, coming forth with a bill on something that we could probably find some common ground. Instead of going to those grounds, we go to something that really is, again, an overreach that does not need to happen and will actually penalize many people in the process. Before I close, Mr. Chairman, I'd like that the letter from the National Association of Home Builders, the Institute for Legal Reform, National Retail Federation, and the Consumer Banking Association be entered into the record.
Without objection.
And with that, I yield back.
Thank you, Mr. Collins. Without objection, all other opening statements will be included in the record. I now recognize myself for purposes of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 1423, offered by Mr. Nadler of New York. Strike all after the enacting clause and insert the following.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered as base text for purposes of amendment. I will recognize myself to explain the amendment. This amendment makes no substantive changes to the bill and simply makes a technical correction to the bill's short title. Therefore, I urge all members to support it. I yield back the balance of my time. I now recognize the ranking member of the full committee, Mr. Collins, for any comments he may have on the amendment.
And I appreciate the chairman. I accept his amendment in nature substitute. The only question I can still go back on it as we continue in this, and there'll be some discussion and amendments as we go forward. Again, is it worth throwing out everything to when we could fix what needs to be fixed simply to seemingly force folks, out of the judicial system or actually into where they can't get the help that they need? It is a balance that needs to be struck. This is going to be a good debate on it. Hopefully we can find that and move forward on something that would actually work. With that, I yield back.
I thank the gentleman. For what purpose does the gentleman from Georgia, the sponsor of this legislation, seek recognition?
Move to strike the last word.
With that, gentleman is recognized.
Thank you, Mr. Chairman, for holding this important markup. My bill would restore fairness to the American justice system by reasserting individuals' rights to access the court system and to a jury trial. The FAIR Act would ensure that men and women contracting with more powerful entities aren't forced into private arbitration where the bigger party often has the advantage of choosing the arbitrator in an unappealable decision. Arbitration clauses have permeated American life in recent decades. They've seeped into our cell phone contracts, our medical paperwork, our employee handbooks. Their opaque language, written by well-paid corporate lawyers, is often not understood by people who aren't trained attorneys. These clauses are hidden in updated terms and conditions, incorporated into mid-year employee reviews, and implicit in purchase contracts, and they all prevent us from having our day in court. Pre-dispute forced arbitration is a private process that subverts the purpose of the Seventh Amendment by preventing contracting parties from using the American court system when a dispute arises. It was created as an option for contracting business-to-business relations. Unfortunately, the United States Supreme Court has allowed big business to impose forced arbitration clauses on consumers and others of unequal bargaining position in take-it-or-leave-it circumstances. In these cases where the more powerful contracting party can choose the judge, the jury, and the law applied, consumers and employees are put at a distinct disadvantage. There's no requirement in an arbitration proceeding that testimony be under oath and under penalty of perjury, and even worse, the private nature of the proceedings means that it does not create a public record and is not appealable. Repeated anti-consumer activity by companies never sees the light of day, and individuals remain incapable of holding more powerful entities accountable. This needs to change. When a loyal employee who happens to be a reservist or a National Guards person gets deployed and thereafter fired for getting deployed, they can't take their former employer to court, and something is wrong with that. When a sexually harassed employee is forced into a private proceeding where her harasser gets to pick the judge, something is wrong with the American system, and the entire process is private. And when American consumers need a legal education to understand what they're signing, something is wrong with our judicial system. The deck has been stacked against everyday Americans in favor of big business for far too long, and the pressure on the meek and powerless has only become greater as powerful corporate interests have realized that they can avoid accountability by incorporating arbitration clauses into every interaction they have with consumers. The FAIR Act would make the system work for everyone the way that our Constitution intended. Finally, I'd like to take this moment to recognize the victims of forced arbitration who are in the audience today, men and women who've been deprived of their rights because of arbitration clauses. Thank you for being here and for your bravery in telling your stories. It has resulted in us getting to this point where we are marking up this bill. And it has 222 co-sponsors as of today. I'm very proud of that. And we're here to ensure that what happened to you cannot happen to other people in similar situations. And thus, we are restoring justice to the American judicial system. And with that, I yield back.
For what purpose does the gentleman from Florida seek recognition?
Move strike last word.
Gentleman's recognized.
Thank you, Mr. Chairman. And on this issue, I'm with the Democrats. Matter of fact, I think I'm the only Republican in the Congress who's a co-sponsor of this bill along with my Democratic colleagues. And I don't say that to bring discomfort to my colleagues in the majority. I say it to perhaps bring more comfort to my colleagues in the minority that this is an issue where we ought to have broader agreement. It is my belief that the number one threat to our liberty is big government. It is also my belief that the number two threat to our liberty is big business, when big business is able to use the apparatus of government to wrap around its objectives. And in this case, I'm convinced that big business's overutilization of mandatory arbitration clauses impairs people's access to something that is fundamentally American, and that is having a judge and jury make a decision regarding your dispute. As a matter of fact, I think this may be the most America First bill to have been brought forward in the House Judiciary Committee this Congress, because the ability to go before a jury of your peers, to go before a judge, is so important to us thematically as a country that it has been baked into our Bill of Rights. And I'm well aware of the Supreme Court precedent that has created space for mandatory arbitration, but that doesn't mean it's consistent with our values. Why I think this is so unfair really relates to the frequency with which the various litigants will be before arbitration panels. And I've litigated before arbitration panels, I've litigated before judges and juries, and here's kind of the deal. Before a jury, for most of the juries, they're unbiased, right? So they're gonna see the plaintiff and the defendant one time, and they're gonna make a decision on the facts. But when you go before an arbitration panel, that arbitration panel is gonna see that Fortune 100 company multiple times that month, dozens of times that year. And they're gonna see the complainant, the plaintiff, the person that's aggrieved, once. So that creates a fundamental inequity in the resolution of these disputes that is not consistent with our American beliefs and principles. And that alone is a reason to disfavor these things. Now, I hear the arguments that my Republican colleagues make, and they make them absolutely in good faith, that in a number of cases, arbitration can be cheaper, it can be faster, there can be less discovery, and even in many cases, plaintiffs can do better with ultimate awards in arbitration than in court. Now, I don't think that data takes into account all the settlements that occur in court that are likely higher because of the equity of that venue, but irregardless, if people want to choose arbitration, they still have that right. It is not accurate to say that this bill cuts off access to voluntary arbitration where both litigants, where the group of litigants all want to go before an arbitration panel to resolve a matter that might have a lower amount in controversy. But it is just unfair to continue to allow business to become so large in some circumstances and then to use the power they have with government officials to be able to undercut the claims that people make and that they legitimately make. My friend, Mr. Johnson of Georgia, correctly stated that the ickiest environment in which these forced arbitration provisions come to bear deal with sexual harassment. One of the ways we've been able to beat down the scourge of sexual harassment is to out it and talk about it and destigmatize the victims that step forward. But in these arbitration panels, oftentimes there is mandatory secrecy, there is constrained discovery, and so the very antidote to the challenges we face are cut off by the people who create the grievance in the first place. And so I appreciate the gentleman for highlighting that. I've met with constituents from my district who had valid sexual harassment allegations that they deserve to have resolved. And when they were forced to these arbitration panels, they did not feel as though there was fairness and equity. And look, not everybody likes the outcome they get, right? But at least before a judge and a jury, we have a tried and true method to have greater confidence in that. Mr. Chairman, I thank you for bringing this bill up. I thank the sponsors of it. I would yield.
I just want to say that it takes a lot of courage to step away from the herd, to separate yourself from the pack, and do something that you know is in the best interest of society, and it is in keeping with our Constitution, our 7th Amendment, which guarantees a right to a jury trial in cases where the amount in controversy exceeds $20 or more. So I appreciate the gentleman's work on this bill. I appreciate your co-sponsorship, and I look forward to working with you on other matters.
And it is my hope, Mr. Chairman and Mr. Johnson, that the Senate will take this bill up, and I make you the commitment that I will personally endeavor to encourage the President to sign it if it makes it to his desk, and I yield back.
I move to strike the last word. Move to strike the last word. Thank you, Mr. Chairman. I would like to say something I have never said publicly before. Mr. Gates is right. And I thank him for his eloquent words. Mr. Chairman, buried deep within the fine print of everyday contracts, forced arbitration deprives American consumers and workers of their day in court when they attempt to hold corporations accountable for breaking the law or violating the rights of workers or consumers. This private system lacks the procedural safeguards of our justice system, is not subject to oversight, has no judge or jury, and is not bound by laws passed by Congress or the states. But it's become a requirement of everyday life. Consumers and workers must surrender their rights to corporations through forced arbitration clauses, which are unilaterally imposed by companies before disputes arise. And when forced arbitration is combined with non-disclosure agreement, it effectively silences the victims of rampant corporate misconduct. Few instances of this silencing effect are as stark and disturbing as the experiences of victims of sexual harassment and assault, who are routinely exploited by forced arbitration. During the subcommittee's hearing on forced arbitration, Gretchen Carlson, an advocate and former Fox News commentator, characterized forced arbitration as a tool used to, and I quote, to cover up systemic sexual harassment, end quote. And while she, along with many others across the country, have come forward to tell their stories, there are still countless others who are left behind. As Ms. Carlson explained, because of the secrecy that surrounds forced arbitration, it is impossible to know exactly how many women were sexually assaulted or harassed and came forward. What we also don't know is how many women chose not to come forward, but to stay quiet or quit because they knew they would be forced into arbitration where their voices would be silenced, end quote. This shameful, humiliating, and corrupt system has isolated and silenced people who are ultimately deprived of their right to hold wrongdoers accountable through their day in court. Forced arbitration has also eroded the fundamental rights of our nation's men and women in uniform, veterans, and their families. These brave Americans have sacrificed much in service to our country. They have fought to protect the fundamental idea that we are a nation of laws and institutions that guarantee the rights and prosperity of every American. Since the Second World War, Congress has strengthened the rights and protections of service members and veterans through laws like the Uniformed Services Employment and Reemployment Rights Act, or USERRA, which guarantees that service members can take military leave without fear that they will lose their job back when they return home. These laws are essential protections that guarantee every veteran and active duty service member, including the Reserves and National Guard, the right to be free from workplace discrimination on the basis of their military service, and the right to their day in court to enforce these protections. But for too long, arbitration has eroded these fundamental protections by forcing service members' claims into private systems set up by corporations. A coalition of military service organizations representing more than 5.5 million current and former service members notes that countless employers have used forced arbitration clauses in contracts as a barrier to justice by funneling wrongful termination and discrimination claims into private, costly arbitration systems set up by the same employers. For example, Lieutenant Commander Kevin Zoiber, who testified in support of the FAIR Act earlier this year, has served in the U.S. Navy Reserve since 2008. But in the fall of 2012, he was called into active duty for a deployment to Afghanistan. Kevin notified his employer and conveyed his desire to resume work upon his return. But on his last day of work before his deployment to Afghanistan, following his farewell party, he was fired by his employer for serving his country. When he tried to hold his employer accountable for violating his rights under USERRA, his company forced his claim into arbitration, citing an arbitration clause in Kevin's employment contract that he was required to sign at the beginning of his employment, waiving his constitutional right to a jury trial. As Kevin testified during the hearing, and I quote, "No service member who was asked to leave his family and friends to fight for our country should ever have to worry about fighting for his job when he returns home," end quote. But protections for service members, Kevin states, and I quote, "are routinely undermined by arbitration agreements that require service members to pursue arbitration in the specific location that the employer chooses, even if the service member is deployed or lives across the country, or that impose significant fees or costs on service members. This outrageous practice is nothing short of a corporate takeover of our nation's system of laws, and the American people have had enough. The overwhelming majority of voters, including 83% of Democrats and 87% of Republicans, support ending forced arbitration. It's time to act. H.R. 1423, the FAIR Act, does just that. This important legislation ends the use of forced arbitration in everyday consumer, employment, antitrust, and civil rights disputes. It's supported by a broad coalition of groups dedicated to advancing the rights of women, service members, veterans, consumers, and hardworking Americans. I thank Chairman Nadler for holding today's markup of the bill, along with my colleague, Congressman Johnson, for his leadership over the past decade. I urge my colleagues to support this bipartisan measure, and I yield back the balance of my time.
Gentleman yields back. Are there any amendments to the amendment in nature of a substitute?
Mr. Chairman,
Gentleman from Ohio, for what purpose he seek recognition?
have an amendment at the desk.
Gentleman, the clerk will report the amendment. Gentlelady.
Reserve a point of order, Mr. Chairman.
Point of order is reserved.
Amendment offered by Mr. Jordan of Ohio to the amendment in the nature of a substitute. Page 6, strike lines 16 through 25, and make such technical and conforming changes as may be appropriate.
The gentleman will explain his amendment.
Thank you, Mr. Chairman. The legislation doesn't really get rid of all forced arbitration because it keeps a safe harbor for union contracts. Current contracts force employers into arbitration over employment disputes, opening a faster, cheaper path to justice for employees. Research has even shown, as Mr. Gates mentioned in his comments, that employees obtain more favorable judgments in arbitration than they do in the court. And in court, of course, the average employee stands to be seriously outgunned by an employer who has far more resources to hire more costly courtroom counsel. The bill mysteriously yanks those benefits out of the hands of non-union employees. Meanwhile, what happens for union employees? Well, pre-dispute mandatory binding arbitration contracts negotiated by the unions with employers or other unions are left untouched by the bill. Mr. Chairman, this is a bill entitled the Forced Arbitration and Justice Repeal Act, but it really should be titled the Forced Injustice Guarantee Act because the bill enacts injustice between union and non-union employees. Non-union employees get handed over to the plaintiff's bar and may never be able to afford their day in court that we all want to see happen, as Mr. Gates and others have talked about. Union employees get all the benefits of forcing arbitration with their employers and don't have to make the same kind of sacrifice. My amendment can cleanse the hypocritical treatment of that's contained in the bill. I urge my colleagues to support the amendment.
Gentleman yield.
And reserve the balance of my time. Well, actually, would yield to the ranking member of the committee.
Thank you. I appreciate you yield. Look, I think all we're doing is cleaning up this. I mean, I know there's going to be discussion here to say that collective bargaining is fair and open and everybody gets a part. Well, tell that to the line worker who has no except to trust that his leadership is taking care of him in these positions. And look, you can make the argument how you want and say it's clean, it's neat, and it's right, and this has all been fair and above board. For those of us who've been a part of a union, not how it was when I was younger in a grocery store chain, when it comes down to choices, the unions will have to pick. And so there are arguments here that we need to look at, and I think your amendment strikes that balance. Let's make everybody play by the same rules. You know, we've heard this a lot up here that we should make it even. Well, let's make this even. You know, if you're just depending on collective bargaining, be the clear and transparent here, I think we've got a long hurdle to climb on that one. So with that, I yield back to the gentleman.
I thank the gentleman for his comments, and they're right on target. And I think about my... Yes, I would yield to the gentleman from Florida.
I thank the gentleman for yielding, and it would seem to me that what's good for the goose should be good for the gander. If forced arbitration is infirm as a requirement upon litigants, you know, with big business, it just would seem that it would similarly be infirm as it relates to big labor. So I would just hope for some intellectual and consistency and honesty from my colleagues in the majority, and I think we could take Mr. Jordan's amendment and make a really good bill even stronger. And I yield back to the gentleman from Ohio.
I yield back.
Gentleman yields back. Does the gentleman from Rhode Island...
Mr. Chairman.
Does the gentleman from Rhode Island insist on his point of order?
I do not, Mr. Chairman.
The gentleman does not insist on his point of order. The gentleman for... Oh, well, let me... well, I recognize myself for the purpose of opposing the amendment. This amendment is a distraction from the true issue here. There are a little over 60 million workers who make up a majority of non-union private sector employees who are subject to forced arbitration clauses. Those employees are told that if they want to get a job or keep their current job, they must sign away their right to their day in court and submit to a forced arbitration agreement. In most cases, they do not have a choice. In contrast, the collective bargaining process provides protections that are unavailable to many non-union workers, such as rejecting unfair employment terms. Additionally, in a collective bargaining, both the company and the union are represented by counsel and can agree to arbitration before the dispute arises on an informed basis. And the two parties at arbitration are two institutions, a large corporation and a union, not a large corporation and an individual who has comparatively little power. The collective bargaining process can also involve agreement over other important protections, such as truly neutral arbitrators, better procedures, and transparent decision-making. This is completely different from forced arbitration of non-union employment disputes, where a single employee is forced to accept an arbitration clause buried inside the fine print of a stack of confusing paperwork on a take-it-or-leave-it basis. There is no agreement. There's an agreement between the union and the employer in a collective bargaining agreement, which may involve arbitration, but that's a voluntary agreement between two parties, not a take-it-or-leave-it agreement between one party and one helpless individual. Even when workers are aware of the clauses buried in the fine print, it is not possible for them to know that they may be victims of sexual harassment, wage discrimination, or other illegal behavior later before they begin their employment. The FAIR Act will help to fix the unjust system and protect American workers, and it reaches against forced arbitration where it is necessary to reach. And therefore, I oppose the amendment.
Would the gentleman yield?
The gentleman yield? Who seeks? I'll yield to the gentleman from Georgia.
Yes, thank you. Collective bargaining by unions on behalf of employees levels the playing field against an employer who is rich and powerful. And so collective bargaining comes to an agreement between two parties of equal bargaining position. And when those equal bargaining positions agree to arbitration as the means to settle collective bargaining disputes, that is entirely in keeping with the premises of the original Arbitration Act, which the U.S. Supreme Court has contorted out of its natural boundaries so that it applies to parties of unequal bargaining strength. So that's the difference between the collective bargaining of employees versus individuals who have no ability to bargain with the employer. It's just a take it or leave it employment situation. So for that reason, I oppose the amendment, and I'd ask my colleagues to do the same.
You yield back.
And with that, I yield back.
And I yield back. Does anyone else seek recognition?
Mr. Chairman.
Gentleman from Georgia, the ranking member, Mr. Collins.
Thank you, Mr. Chairman. I move to strike last word.
Gentleman is recognized.
You know, it's really interesting what was just said by my friend from Georgia. He said that and again, this is why this argument sometimes devolves into this discussion. We go to the rich and powerful business, and we don't think anything about the powerful and very successful union organizations who have collective bargaining. Let's discuss this. Let's don't just all of a sudden go to the bad, that the big bad business is the problem here, while at the same point saying there's not at least an inequity inside the union side here. I mean, we can't keep going down this path because it's in some areas, if you think about this, for the new employee coming in, they have no choice but to join the union to get the job. So before they ever get there, that has been decided for them in their ways, and so they have to get the job. They have to agree to join the union. They are being, placed into that format. So I think what we got, just be careful here. It's okay, and I made this comment to the chairman just a few minutes ago. This is a bill, and I think it's reflected from Mr. Gates' point of view, from others in this, that there is a workable solution for this bill. But for those in the audience who believe, anybody that would actually believe that, this is not holding the unions accountable for this is anything but just a carve out because we don't want to deal with their collective bargaining agreement is a problem here. And to say that you're just simply attacking rich and powerful businesses when they have collective bargaining that has been negotiated through, force and through the agreements and laws in those states, that's an issue that needs to be done as well, because especially in areas where there is no choice but for certain jobs, you must join the union. So to say that this is simply a setup between, two, diametrically opposed, one being the weaker, I mean, it's interesting to hear my Democratic colleague basically say that the unions are weak. That's what was actually just said here, in a sense, that they were weak because they had to go up against businesses. So, not yet. I will in just a second. I think what we got to understand here, though, is the concern that I have is if you're going at this, let's make the playing field equal. If we're going to take a bill that is problematic, that we could have, and again, I state this, could have sat down and possibly found some very honest shots that would be put into this bill that could fix the arbitration system in ways that have been the egregious examples that was mentioned by my friend from Rhode Island and others, then let's do that. But let's at least also have a discussion here about what is a balance or inequity balance of this as we go forward. And I think that's why I agree with the gentleman's amendment. We'll have a vote on it here in a minute, but I think this discussion is at least something that needs to be had, and I'll be happy to yield to the chairman for a moment.
Thank you. I think you misunderstood what I said. I said the exact opposite. I said that the union and the company are both institutions. They both have power, and they're therefore in a position to make a reasonable agreement on an arbitration, whereas an individual faced with a company has a severe imbalance of power, and therefore the bill ought to apply to that individual, but not necessarily to a union where they can voluntarily and on an equal basis.
And in reclaiming my time, I mean, this may become a shock to many watching here. I'll actually agree with the chairman. I wasn't disagreeing with the chairman. I was disagreeing with the gentleman from Georgia in his characterization of businesses and his characterization of
Would the
how this is
gentleman
done.
yield?
I'll yield to the gentleman from Arizona.
Thank you for yielding. I'll just take a brief moment. When the chairman says that these are both institutions, he is correct. You're talking big businesses are institutions, the unions are institutions. But this bill only seeks to adjust inequities between the institution of a big business versus the individual. This amendment, however, it seeks to address the inequities of an individual in trying to work within the system of the big institution union. And the ranking member was exactly correct when he said individuals who want employment through a union must accept the results of the collective bargaining agreement, or they must walk away. They're done. And that's the point I think that we're losing here, and I think it's the point that we need to correct, and I think that's why this amendment was offered, and I support the amendment, and I yield back to the ranking member.
I'll yield back.
The gentleman from California.
Move to strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman, and thank you to the gentleman from Georgia for bringing forth this legislation. It is pro-consumer and is pro-Seventh Amendment, but just to put into perspective who I think is hurt most by forced arbitration agreements, it's rural Americans. Because if you think about it, in rural America, oftentimes there's a big company, town employer, and there's not many other employers. There's one big hospital healthcare system where you can go to. There's one bank that you can go to. So there's not a lot of choice in rural America. And when there's not a lot of choice and you have forced arbitration, you can't make the argument that you're in a populated area where you can go to another bank, another hospital, another employer. You're really locked in. And that puts this sense of helplessness and powerlessness across America. And this seeks to lift that. It also gets rid of a one-sided system that more times than not, it's the corporations who are drafting the terms of what would put somebody into forced arbitration. As a former prosecutor, someone who has tried dozens of jury trials in front of jurors, I trust everyday Americans to sort out these issues more than I would trust the arbitrator of choice from a corporation. But I also trust everyday Americans who 83% have said in a recent February 2019 poll that they want to get rid of forced arbitration. So I thank the gentleman. I also thank the gentleman from Florida who has made this a bipartisan piece of legislation for this committee today, and I yield back.
Gentleman, yield. Gentleman.
Yes, I would.
Thank you. Let's see. Mr. Chairman, first I wanted to recognize two young heroes who are with us today. They are law students from Harvard Law School, third-year students Molly Coleman and Vale Kulner-Yount, who've organized students at Harvard Law School to put pressure on law firms to drop policies of compulsory arbitration against their own employees so that if someone has a sexual harassment complaint or some other complaint, it would not be forced into one of these secretive off-limits entities where real justice is not done. And several law firms, including Kirkland & Ellis, Sidley & Austin, and Paul Hastings, have dropped their compulsory arbitration policies because they're there. I also wanted to salute Mr. Johnson for his excellent leadership and Mr. Gates for his insightful remarks about this legislation. Let's see, I am not averse to this amendment if I had heard any complaints from union members about this process. I had not heard a single complaint from a union member, and if what we're talking about is duty of fair representation, I don't know that they would want to get out of an alternative mediation or arbitration process. But in any event, we don't really know anything about that. But what we do have tons of evidence of is cases like the one I learned of from New York with Karen Ward, who sued Ernst & Young. She worked at Ernst & Young for sexual harassment after a series of insulting and degrading remarks about her body, her breasts, other parts of her body after she was propositioned on a trip. She tried to bring a sexual harassment lawsuit, was forced into compulsory arbitration where she was charged $185,000 in order to bring the case. And how many cases are being chilled, deterred, and just squelched by virtue of the fact that people are being charged for the right to even enter into their claims? If she'd gone to court, it would have been $500 in order to file her case. And here, they were charging her more than $180,000 to pay for the arbitrators under the terms of the contract. So this is an insult to the Constitution. It's an insult to everything that we believe in as Americans. I just want to close with a quote from John Adams, who said, "Representative government and trial by jury are the heart and lungs of liberty. Without them, we have no other fortification against being ridden like horses, fleeced like sheep, worked like cattle, and fed and clothed like swine and hounds." So let's stick with John Adams and the founders of the Constitution and the right to trial by jury. I yield back. Thank you.
Thank the gentleman for yielding back. We have 7.5 minutes left on 3 votes on the floor. The committee, therefore, will stand in recess now until immediately after the third vote, and I urge the members to come back as soon as they finish voting in the third vote. The committee is hereby in recess. The committee will come to order. Before we begin, I want to briefly note that our Chairman Emeritus, the gentleman from Wisconsin, Mr. Sensenbrenner, has announced that he will be retiring at the end of the term. He has always been a strong defender of this committee and its jurisdiction. We have worked together on many important issues, such as surveillance reform and reauthorization of the Voting Rights Act. As the former chairman of the Crime Subcommittee, he helped lead this committee's recent criminal justice reform efforts. As the current ranking member of the Antitrust Subcommittee, he is a strong partner in this committee's bipartisan investigation into competition in digital markets. He has also been a passionate advocate for the rights of individuals with disabilities. He sponsored the ADA Amendments Act of 2008, which President George Bush signed into law, and which strengthened the landmark Americans with Disabilities Act. He has served this committee and this House with distinction, and he will be sorely missed. But I look forward to continuing to work with him over the next year and a half as he completes his service in Congress. I would now recognize the ranking member for any comments he may have.
Thank you, Mr. Chairman. I appreciate you doing this. You know, for all the accomplishments that you just stated, on my side, it's not only the accomplishments of someone that I can look over to the left and see on the wall of this committee. For me to be able to sit next to Jim Sensenbrenner is one of the highlights of my career in serving with him. It is often said that when you have people that you look up to and they have played an impact on your life, you're truly just standing on the shoulders of their work that they've already went before, that most of us on this dais, especially on the Republican side, would not have the, frankly, the standing that we have from what he has done and over time. And it is something to be said that when he has put that much time and for all the time in his district and all the time talking to his constituents. But the one thing, Mr. Chairman, that I will say that I got to know, you know, my chairman over here from Emeritus is his love for his family and for his precious bride and his kid. And that is, to me, what makes this place special. It's just, we're going to have all kinds of disagreements up here, and that's what we do. But at the end of the day, we all got families, and we can all put aside our discussions to know at the end of the day it's about that. And for what you have done and for the stuff that you went through, you mean the world to me, and I am just happy that I was able to make it through this without doing what I thought I might do. So, but again, I just want to thank you. We're going to have a lot more for you in the next to come. You're not out of here yet, and I yield back.
Oh, Chairman, yield.
I'll be happy to yield.
Well, you know, I've already threatened that I will be more unhinged and more tart during the next 16 months, since there's nobody who will ever be able to say, I'm never going to vote for you again because you did this or said that. I do appreciate the comments both by the chairman and the ranking member. You know, it's been a great 42-year run. During this period of time, I think we have accomplished an awful lot for the American people, making them safer, particularly making children safer. With the Adam Walsh Act and the PROTECT Act. And that was all done on a bipartisan basis. You know, it kind of strikes me and disappoints me that when we do things on a bipartisan basis, it's not newsworthy. When we're screaming at each other and shaking our fists at each other, it gets to be very newsworthy. Well, the latter type of legislative action usually doesn't make it into law. The former type does. And I think that this committee, with its vast jurisdiction, which, as the chairman mentioned, when I became chairman, we lost a lot during my two predecessors' terms, that, you know, I grabbed it back and we were able to do, you know, an awful lot, you know, rather than in getting it stuck in perhaps the tar pits of the Energy and Commerce Committee and some of the other committees that think they should have it all. We have a vast jurisdiction. We've done a lot of it. I've made a lot of friends on both sides of the aisle. I'm not going very far because my wife is in a nursing home, and I don't have to come in during the rush hour, so I can make it in 20 minutes rather than riding the brake across the 14th Street Bridge. You know, this is something that I will look back to, and my children and my grandchildren, you know, will look back to and say that Grandpa made a difference. So thank you all from the bottom of my heart.
Thank the gentleman. At this time, I ask unanimous consent to enter into the record letters from Andoa Newton and Karen Ward describing their experiences with forced arbitration clauses after having been the victims of sexual harassment. Without objection, their letters will be entered into the record. When the committee recessed, the pending business was the Jordan Amendment to the amendment in the nature of a substitute. Does anyone seek recognition? Gentlelady from, I'm sorry, the gentleman from Texas, Mr. Gomer.
Thank you, Mr. Chairman. I think Matt Gates made some good points, as have friends across the aisle. But I have heard from union members who have expressed concerns about some of the things their union leaders do in secret. And, you know, they have concerns that some of the union leaders may, for more political reasons, be embracing more people coming in illegally, more people coming in that may take their jobs, and they just have very significant concerns. So when I looked at what Mr. Jordan's amendment does, and as the expression was used earlier, was good for the goose, could be good for the gander, this would help eliminate unions doing things that union members may not know about in the process of arbitration. And so I've decided if the majority will accept this amendment, I'll vote for the overall bill because it will make it fair across the board. So I would encourage everyone to support this amendment so that it makes it apply across the board fairly to everyone, and then we can have one of those bipartisan, truly bipartisan bills, and not just one or two people like Mr. Sensenbrenner was referring to. So I hope you'll support the Jordan Amendment. I yield back.
Who else seeks recognition? The gentlelady from gentlelady from Washington.
Thank you, Mr. Chairman. I wanted to speak to this amendment. I think it's important that we remember that the FAIR Act is about taking on power disparities that exist between an individual or a small business and those large corporations. And I think that that is very, very important because when you look at collective bargaining agreements reflect a negotiated agreement between a group of workers and an employer. And those workers are voluntarily agreeing to all of the things that are negotiated. So we call it third-partying the union. To say that the union is doing something and the members don't want it doesn't really make sense because the union is the membership. And that is what collective bargaining agreements do. They are well-balanced, they're carefully negotiated, and they are a tool also for equalizing power. So I think we really need to think about those power disparities, and that is why I do not support the amendment. I did want to just take a minute to recognize a few others that are in the audience. I wanted to recognize Tanuja Gupta, who is here and is with Google and organized, really took a brave risk of organizing her fellow Google employees to speak out and protest forced arbitration in their employment contracts. And together with other leaders, she organized a walkout of thousands of employees pressuring Google to amend their policies, and I just want to congratulate that work. I also wanted to recognize Lily Silbert, who is in the audience. Where is Lily? Is that you? Lily Silbert, who was sexually assaulted by a Massage Envy therapist. And after the assault, she downloaded the Massage Envy app on her phone to cancel her membership. And of course, hidden right there in the fine print of that app was a forced arbitration clause. And like thousands of other women who were assaulted, Lily filed a lawsuit, and now Massage Envy is using forced arbitration to prevent Lily from holding them accountable, attempting to force her and the other women into arbitration to keep it secret. And so I think that we would not be at the place that we are today without the work of these incredibly brave women and others who are taking up this issue, and I just want to give you my thanks. Thank you, Mr. Chairman. I yield back.
Gentlelady yields back. Does anyone else wish to speak on this amendment? The gentleman from Rhode Island.
Thank you, Mr. Chairman. I move to strike the last word. I oppose this amendment for all the reasons articulated by my colleagues on this side of the aisle, but I just wanted to take a moment to recognize several forced arbitration survivors and advocates who have traveled here from all over the country to attend today's hearing, and I know some of them are going to go upstairs for the special order hour, but I think these stories really underscore the impact of forced arbitration clauses on the lives of real people. Akila Edwards, who comes here from Arizona to be with us today, while struggling to make ends meet, she took out a number of payday loans. Her lenders charged exorbitant and illegal interest rates, some as high as 1,000%. However, because of forced arbitration clauses in the loan contracts, Akila was unable to fight these lenders and their illegal interest rates in court. We're also joined by Glenda and Peter Perez, who were both formerly employed by Cigna. Glenda was fired after making her supervisor aware of the racial discrimination she faced at work. Her case was forced into arbitration, and her company escaped any accountability for her firing. Later, Peter saw a photograph of Glenda's former employer cozying up with the arbitrator, and when he complained, he too was fired. We're also joined by Kelly Stein from Kentucky, who sought to hold the nursing home that mistreated her mother accountable for failing to provide necessary care. However, her case was forced out of court and into arbitration. We're also joined by Danielle Murdoch, who was a former Chipotle management trainee, and she's with us today. She was forced to work off the clock without pay by her employer. Danielle was also told to make her employees work without pay, and along with several thousand other Chipotle employees, Danielle's attempt to hold her employer accountable for wage theft has been forced into individual arbitration. And Karen Ward is here as a former head of the real estate investment banking at Ernst & Young accounting firm. She was paid hundreds of thousands of dollars less than her male counterparts and was subjected to routine sexual harassment at work. And she used, her firm, Ernst & Young, used forced arbitration to keep Karen's gender discrimination claims out of court. She's been billed more than $185,000 by her arbitrators, where the case still only in the discovery phase. And finally, Anwar Newton, who is vice president of legal affairs at Louis Vuitton, was sexually harassed by a colleague for years. After reporting him, she was reprimanded for filing a report. Her employer demanded that she apologize, and her harasser was promoted. Anwar filed her sexual harassment claims in New York State court, but her employer is attempting to compel arbitration because of a forced arbitration clause included as a required part of her employment agreement. And the last person I want to recognize is Tara Zoomer, who is a former employee of WeWork. She was fired after refusing to sign an arbitration agreement that would have stripped employees of their right to class action claims and a trial by jury. Since then, she's been a staunch advocate for workers' rights, testifying in California for legislation that was signed into law by Governor Jerry Brown, preventing the enforcement of mandatory arbitration clauses in employment contracts. I want to thank all the advocates for their advocacy, for being here, for giving us examples of the terrible unfairness and sometimes cruelty of these forced arbitration clauses. And again, I want to compliment Mr. Johnson for his lead on this piece of legislation, which will correct this injustice once and for all. And thank you for being with us today. And with that, I applaud all of you and yield back.
The gentleman yields back. Who else seeks recognition on this amendment? In that case, oh, the gentlelady from Texas. Wait, do you seek recognition? Gentlelady from, where is she? From Arizona.
Thank you, Mr. Chairman. And I just wanted to speak to the last speaker's speech and say I too have talked to different women that actually have been sexually assaulted and part of an arbitration agreement. And so I do have concern about arbitration agreements when it comes to actual sexual assault. And I would like to work with my Democrat colleagues on that particular issue. But this bill is way too broad, and I do support Mr. Jordan's amendment. Thank you.
She yield back. Gentlelady from Texas, for what purposes does she seek recognition?
Let's strike the last word.
Gentlelady's recognized.
Thank you. Let me begin, first of all, by saluting my friend, Congressman Sensenbrenner. We sat next to each other for a number of years as the chairman and ranking member of the Criminal Justice Committee. And during that time frame, there was certainly very constructive work being done, even though we were on different sides of the aisle. So I thank him, and I got to know his lovely wife and know of his family, and I think Congressman Collins is correct. It's all about family, so we're delighted that you will not be far away from us, but you'll be able to have some good time with your family. My pleasure to have served with you. I appreciate the gentleman from Ohio's amendment, but have to vigorously oppose it, and as well thank Congressman Johnson and co-sponsors for the leadership on responding to the needs of the American people. The question has to be asked and then answered when over 80% of the American people say that this is a devastating attack on justice and we want relief, and the Judiciary Committee, now being described as one of the most powerful committees in this Congress, does not respond, then who are we? And that is what we're grappling with. One of the issues of the forced arbitration is the idea that those agreements would be immune to judicial challenge. That leaves the victims with nothing. So they're forced into arbitration, and then all of a sudden you're making the agreement the king of the heap. I believe that the answer to Mr. Jordan's concern is, I know he engages with his unions to really find out whether membership has the concern that people in large corporations have. Usually, unions are engaged in a give and take with their membership. Their meetings, they ask what their membership wants. They have membership meetings. They have voting. Employees do not vote in corporations. They're not in a give and take situation. What do you want? Would you like this particular structure to be utilized when you have been brutalized in the office? You're frightened, you're alone? Is that the proper way to do? Are they asking their employees for that give and take? No, they are not. These are incorporated in employee manuals, big fat manuals. They're embedded in some page 492. Many people are hired without any knowledge of what a arbitration agreement is or what would happen with a forced arbitration agreement. So I would say that this amendment can be handled by the give and take of collective bargaining and the interaction that unions have with their members. And I would certainly welcome any facts, as has been suggested before, that indicates that this committee needs to address the question. But in the instance of making any agreements above the law, above the courts, I think that this is a bill that is long needed, and I support the underlying legislation, and I oppose the amendment and look forward to H.R. 1423 being passed. I yield back, Mr. Chairman.
Gentlelady yields back. The question is on the amendment.
Mr. Chairman, move to strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman. Mr. Chairman, I believe this is an opportunity lost. While we were walking to votes a few minutes ago, many of us on this side of the aisle were talking about how we would support parts of this bill, in particular, the idea that a victim of sexual harassment would be forced into arbitration is offensive to a lot of us. And I think that if this bill had been discussed more, we would find parts that we could agree to and try to move something. And I think the Senate would find common ground with us also on some of those areas. And I think it's unfortunate that we are moving forward on a broad bill like this. The plaintiffs' bar, a very large donor to the Democrat Party and Democrat candidates, has strongly supported a bill like this because it enhances frankly, their bottom line. And when we pit two different constituencies of the Democrat Party against each other with an amendment like this, where we talk about the plaintiffs' bar at the same time as the unions, my colleagues on the other side of the aisle decide they want their cake and eat it too. The only thing that they are inconsistent with is when their rhetoric on the campaign trail about taking money out of politics is undermined by this bill and undermined by actions which speak louder than words, frankly. I hope that at some point, this bill will go nowhere in the Senate, and I hope that at some point we can come together and we can reach an agreement on the important parts of this bill that will become law someday. And I, for that reason, support the gentleman from Ohio's amendment. I yield back.
Gentleman yields back. Now I think the question occurs on the amendment. Those in favor say aye. Those opposed, no. No. The opinion of the chair, the nays have it. The amendment is agreed to. A slow roll call is requested. The clerk will call the roll.
Mr. Nadler?
Did I say, I'm sorry. Let me repeat that. The amendment is not agreed to. Slow roll call has been requested. The clerk will call the roll.
Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren? No. Ms. Lofgren votes no. Ms. Jackson Lee? Ms. Jackson Lee votes no. Mr. Cohen? Mr. Johnson of Georgia? Mr. Johnson of Georgia votes no. Mr. Deutsch? Mr. Deutsch votes no. Ms. Bass? Ms. Bass votes no. Mr. Richmond? Mr. Jeffries? Mr. Cicilline? No. Mr. Cicilline votes no. Mr. Swalwell? No. Mr. Swalwell votes no. Mr. Liu? Mr. Raskin? No. Mr. Raskin votes no. Ms. Jayapal? Ms. Jayapal votes no. Ms. Stemmings? Mr. Correa? Ms. Scanlon? Ms. Scanlon votes no. Ms. Garcia?
No.
Ms. Garcia votes no. Mr. Neguse?
No.
Mr. Neguse votes no. Ms. McBath? Ms. McBath votes no. Mr. Stanton?
No.
Mr. Stanton votes no. Ms. Dean?
No.
Ms. Dean votes no. Ms. McCarcel Powell?
No.
Ms. McCarcel Powell votes no. Ms. Escobar?
No.
Ms. Escobar votes no. Mr. Collins? Mr. Collins votes aye. Mr. Sensenbrenner? Mr. Sensenbrenner votes aye. Mr. Shabbat? Mr. Gomert? Mr. Gomert votes aye. Mr. Jordan? Mr. Jordan votes yes. Mr. Buck? Mr. Buck votes aye. Mr. Ratcliffe? Mr. Ratcliffe votes yes. Ms. Roby? Ms. Roby votes aye. Mr. Gates? Mr. Gates votes aye. Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes aye. Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock? Mr. McClintock votes aye. Ms. Lesko? Ms. Lesko votes aye. Mr. Reschenthaler? Mr. Klein? Mr. Klein votes aye. Mr. Armstrong? Mr. Armstrong votes yes. Mr. Stubbe? Mr. Stubbe votes yes. Mr. Cohen, you are not recorded. Mr. Cohen votes no. Mr. Liu, you are not recorded. Mr. Liu votes no.
Are there any members who haven't voted who wish to vote? The clerk will report.
Mr. Chairman, there are 15 ayes and 20 noes.
59. The amendment is not agreed to. Are there any other amendments?
Mr. Chairman,
For what purpose is the gentleman from?
I have an amendment at the desk.
The clerk will report the amendment.
Amendment offered by Mr. Sensenbrenner of Wisconsin.
Point of order is reserved.
Amendment offered by Mr. Sensenbrenner of Wisconsin to the amendment in the nature of a substitute. Page 6, after
Chairman,
line
I ask
25.
unanimous consent the amendment be considered as read.
Without objection, and the gentleman is recognized to explain his amendment.
Mr. Chairman, let's be plain about what this bill does. At its core, it does one thing and only one thing. It steers millions of consumer and employment disputes into the hands of fat cat plaintiffs' class action trial lawyers, enabling them to make millions upon millions of dollars. And while members of their plaintiffs' class receive what? Minuscule recoveries, informed by a postcard that they've gained a few dollars or maybe a coupon. And while millions don't qualify for class actions, get left out in the cold, unable to afford high-priced courtroom lawyers to represent them in their individual cases. My amendment targets this injustice by at least assuring that before a court determines that this bill renders an arbitration contract unenforceable, it will ensure that a consumer or an employee will only have to pay a reasonable fee for its courtroom or class action lawyers. How? By making the plaintiff's lawyers in the case file an affidavit showing that their fees, in fact, will be reasonable. If the purpose of this bill is to prevent injustice, please support this amendment, because it is immensely unjust to take a person's contractual right to arbitration only to leave them facing exorbitant fees to bring their case to court, or just not being able to afford to bring their case at all. I urge all my colleagues to support this amendment and yield back the balance of my time.
Would the gentleman yield?
Mr. Chairman?
Would the gentleman yield for a question?
Well, certainly.
Wait, is the premise that an employee cannot enter into arbitration if he or she wants to? Because when you said you don't want to deny them the right to arbitration without other specifications in place, but wouldn't even under the legislation they have the right to enter into arbitration, but they couldn't be bound by it? Particular case?
It depends upon whether it's pre-dispute or post-dispute. I think that, what needs to be done is to make sure that the attorney's fees are reasonable. Now, I know that most individual cases can be taken on a contingency fee basis, but the class action, usually what happens is that the lawyers get paid first and the members of the class get what's left over. And that's unacceptable. It seems to me, I remember, getting a postcard that I got 50 cents off a product of the corporation that allegedly defrauded me. That's kind of an insult to people who a court has determined have been injured in a class action lawsuit.
The interesting thing about your proposal is that there are a number of people sitting in the room today, including Ms. Ward from New York, who's been charged $180,000 for the privilege of going through a compelled arbitration. They're trying to escape these compulsory high attorney fees by having the right to go to court. And if we have high fees to file in court, we should deal with that separately. In terms of attorney's fees, there are already lots of court rules that impose reasonableness caps on what attorneys charge. So, but
While reclaiming my time, try getting the judge to enforce those rules. I've gotten lots of class action settlements, in my time, and it says please read the fine print, so I've done it. And you look at how much the fees are and how much the total pot to be distributed is. The attorney's fees come off the top, and the allegedly victims of the class action violation end up getting what's left over, which frequently can be a 50-cent coupon that's attached to the postcard.
Right, and that goes to the question of what plaintiffs get and what plaintiffs' attorneys get. It doesn't go to the question of the underlying liability of the company that's been sued. But thank you for your clarification. I appreciate that.
Okay, I yield back.
Yeah, I'll recognize myself in opposition to the amendment. The point of order is still being reserved, and is being researched at the moment. But pending that, I'll recognize myself for 5 minutes in opposition to the amendment. The amendment says, in effect, as I understand it, that that the prohibition in the bill on enforcing these arbitration, these mandatory arbitration or forced arbitration agreements shall not apply if the attorneys for the plaintiff fees are too high, or higher than the recovery for an attorney. Well, drastically limiting the fees for only one side in litigation, in this case the side representing consumers and workers, as this amendment would do, is an unfair handout to corporations that may have broken the law. Limiting attorneys' fees for only one side makes it certain that finding an attorney to help a worker or consumer file her case will be next to impossible, because it takes a lot of money to take on a corporation, money that attorneys spend to bring the case. Limiting what they can recover puts an arbitrary and artificial cap on that, limiting access to justice for workers and consumers. We've all had experience, or many of us have, in which there's an injury, let's say, and you go to an attorney, and the attorney will make a calculation. Well, that's the possible recovery in that case is $50,000. It'll cost me $75,000 to litigate it. I'm not going to take 100% of your recovery, and that's negative anyway, so I'm not going to take the case, and you're not going to find an attorney. Attorneys' fee caps will close the courthouse doors for countless consumers and workers, while corporations will be free to pay their attorneys as much as they want. Under current law, attorneys' fees of class counsel must be approved by the court if the various parties are given the chance to object, including the defendants, class members, and state attorneys general. It would be inappropriate and unnecessary for Congress to second-guess the judgment of the courts who preside over the case. In contrast, there is no regulation or oversight by any court of the fees of the attorneys who represent corporate defendants in class action cases. And yet this amendment would cap only the plaintiff's lawyer's fees and not the defense lawyer's fees. Attorneys in class cases represent a large number of people who have been harmed by corporate misconduct. These attorneys routinely take cases that are highly complex or novel on a contingency basis. In these cases, the attorneys pay the entirety of costs associated with litigation, including discovery, payments for expert witnesses, and travel costs, which are only reimbursed if they win the case. But if you've put a limit on their fee, they cannot recover that. We should note that the contingency fee contract, which is often derided, is the greatest leveling device our justice system has ever produced. It allows working-class workers and consumers to afford the best lawyers in the country who can go toe-to-toe with giant corporations that have stolen their paychecks or hurt them with a defective product or in some other way. Attorneys that do not use contingent fees generally use a per-hour rate for cases, which is determined by the difficulty and complexity of the case. Attorneys' fees are already regulated on a state-by-state basis and under the professional responsibility rules, which require that attorneys' fees be reasonable. This amendment will discourage attorneys from representing victims of corporate misconduct in the first place, undermining their access to justice. The purpose of this bill, contrary to what was said, is not to enrich plaintiffs' attorneys. The purpose of this bill is to repeal provisions that are inserted in one-way contracts of adhesions by large corporations, limiting the rights of little guys and gals. And that's what we're trying to do. We're trying to afford access to the courts for people who need access to the courts. This amendment goes in exactly the wrong direction and is almost like an exclamation point saying, we want to turn the courts into collection agencies for big corporations, and damn it, that's exactly what we're going to do, and I oppose the amendment for that reason. Who else seeks recognition?
Mr. Chairman.
The gentleman from Georgia, the ranking member is recognized.
Yeah, I'm not claiming time at this point, but I do not believe we need to go further until we have an actual ruling on this point of order, and if it means to skip to the next amendment, we need to skip to the next amendment.
Okay, that's a reasonable suggestion. We will suspend discussion of this amendment. We'll go on to the next amendment, pending some advice from the parliamentarians about the germaneness of this amendment, which will determine how I rule on whether the amendment is germane or not. Who seeks a recognition for the?
Mr. Chairman, I have another amendment at the desk.
The gentleman from Wisconsin has an amendment at the desk. The clerk will, no?
Where is it?
Do you have the gentleman's amendment?
By unanimous consent, was suspended.
Where is it?
Well, does anybody have a different amendment?
This is number 2, yes.
Okay, we will suspend while we wait for the ruling of the Parliament, for the advice of the parliamentarians, and for finding a copy of Mr. Sensenbrenner's Second Amendment. We're about to, oh. The gentleman from Wisconsin, hold on one second. The gentleman from Wisconsin, you have an amendment to that? Right? All right.
I would suggest the chair rule on the point of order on the First
Haven't gotten
Amendment.
it yet.
Mr. Chairman, on the point of order,
The gentlelady from California.
it appears to me that the amendment is not germane because it attempts to deal with the regulation of attorney's fees, which is not within the purview of the bill itself. However, an argument has been made by the minority that this is just a precursor, and I think getting the guidance from the parliamentarian on this matter would be an appropriate effort rather than just winging it.
Well, that's what if the gentlelady will yield to me, that's what we're doing. My own personal opinion at the moment is that it's not germane, but we want to be fair, and we've asked for some ruling from the, advice, not a ruling, I make the ruling, advice from the parliamentarian. We're waiting for that. Are we going to, if we're going to get it shortly, if not, we should go on to the next amendment.
Mr. Chairman, over on this side, we've got a point of order.
Point of order, this gentleman will state his point of order.
I just counted, and you have more votes than we do, so if you wanted to proceed, I think the result would end up being the same.
It's pretty much close.
That's not a point of order, but we'll wait a couple more minutes. If not, we'll go to the next amendment.
Mr. Chairman, I withdraw my point of order.
The gentlelady withdraws her point of order. Are we prepared? The amendment is germane. Who seeks recognition? Oh, the gentleman will explain his amendment. Wait a minute.
We've done that.
He's done that. And I propose the amendment. Who else seeks recognition on this amendment? The gentlelady from Pennsylvania.
Just as we're having this discussion about the costs of arbitration, the availability of arbitration versus proceeding to the courts, what's top of mind for me is an issue that's bubbled up in my district. Pennsylvania has higher student debt load than any other state in the country. So we're hearing a lot from students who are forced to enter into compulsory arbitration agreements in order to get the student loans they need. And of course, these folks are, at a point when they don't have a lot of resources, they're just starting out in their careers. Often they're entering into these agreements, when they're just in their teens. So it's particularly onerous for them. We know that the CFPB found that 86% of the largest lenders in the private student loan market include arbitration clauses in their contracts. And these pre-dispute arbitration clauses offered as a prerequisite for borrowing money strip away the student's right to a jury trial if there's a legal dispute. And often the easiest way for them, or the only way that they're going to be able to get relief, is if they join into some kind of class action. So one way to protect student rights is to abolish the arbitration clauses in these student loan contracts, and for that reason, I'll be supporting the FAIR Act. Thank you.
And opposing the amendment.
Who's trying? No, she's
Yield?
supporting it.
Will the gentlewoman yield?
Yes, I yield.
Mr. Chair. From Georgia.
Thank you, Mr. Chairman. I move the strike last word.
Gentleman's recognized.
One of the things that we're discussing here is also a discussion of cost, and those are things, and the mandatory binding in these arbitration agreements increasingly are crafted to include what is called strong fair clauses. This has been an issue we look at from a cost perspective. For over a decade, companies have increasingly been incorporating these fair clauses into arbitration contracts with consumers. These clauses improve arbitration's efficacy for consumers in many ways, such as by assuring compliance with due process procedures of major arbitrating services, allowing either party to invoke arbitration, providing for payment of differences between the court and arbitration fees, allowing for fee shifting to a losing company, permitting requests from indigent consumers that companies pay the cost of arbitration, win or lose, and furnishing off-ramps to small claims courts for claims that would qualify in those fora. Consumer contracts increasingly include opt-out clauses that allow consumers for a time entering into a contract, 45 days, to opt out of mandatory binding arbitration clauses while preserving the rest of the bargaining represented in their contract. I think what is interesting here is every discussion that we have on these amendments, and that's fine, comes back to what I'll call the list of horribles. And I agree with many of these lists of horribles we could have fixed. Why don't we have a bill that fixes the list of horribles, but it just takes a mandatory approach on that? So again, we're going to get through this. We'll vote these, but I think we're missing an opportunity to find a bill that more on both sides could agree with, instead of a bill that we have issues with. I yield back.
Gentleman yields back. Who seeks recognition? The gentlelady from Pennsylvania.
Thank you, Mr. Chairman. I wanted to join my voice to thank those of you in the audience who have come here, taken the time out of your lives to reveal your authentic stories. I'm a real big believer that authentic stories inspire. I believe your stories have inspired the underlying legislation. You've suffered serious harm, and you are the face of many, 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 many other people. And so that's why I want to make sure I raise my voice in objection to this amendment. The very thing that this underlying bill seeks to do is to give plaintiffs their voice, to give plaintiffs a fair shot at their day in court. And unfortunately, what this amendment seeks to do is completely undo that. If we're talking about power disparities, this is actually reimposing that power disparity. If you read, as I read it, if you read the opening gambit of this amendment, it says, notwithstanding subsection A, a pre-dispute arbitration agreement, meaning forced arbitration, and a pre-dispute joint action waiver shall be valid. Shall be valid. It just completely undoes this bill unless the plaintiff goes through all of these affidavits, jumps through these hoops, makes presentations and proofs to the court as to their representation and their choice of counsel. This is tying plaintiffs' hands. It's absolutely against the very spirit of this bill, and it is against the rights that you plaintiffs, we plaintiffs, seek. I oppose this amendment, and I very much speak in favor of H.R. 1423. Thanks, Mr. Chairman. I'd be happy to.
Mr. Chairman.
Gentleman from Colorado.
I would just say I would associate myself with the remarks of my distinguished colleague from Pennsylvania. I also think I'm a bit confused by some of what the amendment purports to accomplish. One, it is duplicative in some respects. Attorney regulation and licensure is done by the states, and the rules of professional conduct in, I suspect, every jurisdiction in this country require written engagement letters and retention agreements and so forth. And of course, the states regulate a fair amount with respect to contingency fee agreements. And the gentleman from Wisconsin, I know that he hails from that state in particular, has passed a number of statutes regulating contingency fee agreements and caps on fees for a variety of different cases, medical malpractice cases being an example. So it's unclear to me why, particularly when I know that some folks on the other side of the aisle, my colleagues, believe in federalism and the notion of letting the states regulate in their domains, why we would try to impose these kinds of conditions at the federal level. But again, we should not lose sight fundamentally at what is at debate today, which is a piece of legislation that will do a lot in dramatically impacting countless lives for the better. I serve on the antitrust subcommittee and had the opportunity to hear from a number of the witnesses who are here today in the audience to recount their stories of ways in which forced arbitration had extinguished the pursuit of justice for so many consumers and employees across the country. So this bill, I think, is a prudent path forward in ensuring that every person in our country has access to justice, which is why I'll be supporting the bill and why I oppose the amendment. And with that, I would yield back to the distinguished gentlewoman from Pennsylvania.
And Mr. Chair, I yield my time.
Gentlelady yields her time. For what purpose does the gentleman from California seek recognition?
I mean, Mr. Chairman, I'm going back and forth on this myself, but it does seem to me that isn't it true that binding arbitration binds both of the parties, both the employer and the employee, both the consumers, both the consumers as well as the company? And if I have a grievance against my employer or a company I'm doing business with, but I can't afford a lawyer, I can't afford to take it to court, doesn't binding arbitration protect me by giving me an inexpensive path to resolve that grievance? Now, I was very disturbed to hear the case of an aggrieved party who's paid $185,000 so far and yet to have a decision. That is outrageous, and I'd like to know the details of that, because it's my understanding that under the American Arbitration Association best practices, the businesses pay for the arbitration, and 76% of the cases adhere to these practices. And then cases between $10,000 and $75,000, which would have no recourse to small claims court, claimants' fees average $219. And I also wonder if I shouldn't have the right myself to decide whether such a clause in a contract is in my best interest or whether it's a deal breaker. And it's been argued that binding arbitration clauses produce a contract between, for example, a major, but isn't every take it or leave it proposition? Isn't it my responsibility and my prerogative and right to decide if the totality of the agreement is in my interest or not.
Would the gentleman yield?
Otherwise, just a second. Otherwise, I'm afraid we end up dictating provisions to both the company and the employee or their customer. One more point, and then I'll be happy to yield. It's also been argued that unions are different than companies because unions are governed by the employees. But for the individual employee who dissents from those decisions, a union agreement is just as much a take it or leave it proposition, perhaps more so because in the case of a dissenting employee, that employee cannot go directly to the employer to negotiate different terms more in their interest. So with that, I'll be happy to yield and look forward to the chairman's guidance on these questions.
Well, thank you. I'd simply observe a couple of things. Number one, when I was in law school, they taught us about contracts of adhesion. That contracts of adhesion were basically invalid when one party had all the power and could force the other party, in effect, to sign the contract. We seem to have gotten away with this, and in order to get a credit card or a mortgage or a car loan or anything, or a cable TV contract, you have to sign the contract, and in that contract is a clause saying mandatory arbitration.
Pause for a second and ask, who's forcing me to do that?
You're being forced to do that by the fact that if you don't...
As a consumer, don't I have the absolute protection of saying, no, the terms of the agreement are unacceptable? No, the terms of the employment are unacceptable. I'll take my business elsewhere and take it to a competitor who's offering terms more to my liking.
In most places, there are only a few all the banks have the same provision in it. If you want to get a cable TV, you've got, the satellite TV company or the franchise company. They both have it. You don't have any real choice, and that's the point. There's no real choice because you have the absolute freedom to say, I'm not going to have a television, I'm not going to buy a car, I'm not going to get the loan.
In the case of the cable company, that's a choice that is restricted by an act of government, not the marketplace.
True, except that you're not going to have, even where that's not restricted, because you have the cable, the satellite companies, et cetera. All the big companies essentially now have the same provision.
If I have a grievance against that company, do I, and I can't afford to hire an attorney and take them to court, doesn't arbitration protect me?
No, because...
Forcing that company to go into a process that I can actually afford to participate in?
Most times if you have a grievance with your cable company, it's going to be maybe $20, maybe a couple $100, whatever it may be. The service didn't work or something.
Right. So
And the only way, frankly, that you can have that properly adjudicated is with a class action, where you get together with a lot of people with rather small claims, and you can pay a lawyer reasonably and enforce the course of litigation.
I don't have the time or ability to do that, and I might not find anybody else.
You might not.
How else do I get this matter resolved, but by the company being bound by binding arbitration? Now, again, if the consumer's judgment is that it's a deal breaker, then it's a deal breaker. But I think I have the right to make that decision for myself as a consumer, do I?
Yeah, except that if it's a deal breaker, you don't have other places to go given the fact that essentially all the major corporations do this. You can't get a cable TV contract, you can't get a mortgage, you can't get almost anything you need to get. The gentleman, well, my time has expired, the gentleman's time has expired. Is there any other discussion on the amendment? Gentleman from Georgia.
Thank you. I rise in opposition to the amendment. What the amendment would do would be to force all of these provisions in the motion to be included in the engagement letter or the contract between the plaintiff and the lawyers, and then it would subject the claim of attorney's fees to judicial interpretation as to whether or not it's reasonable or not. And we already have rules in place in certain circumstances where judges make determinations as to the fairness of attorney's fees. And so we don't need to duplicate what's already on record and required of courts. And secondly, while imposing these obligations on plaintiff's counsel, it does nothing to impose any obligations on defense counsel. Defense counsel generally works hourly, and fees of up to $1,000 an hour are being charged by big corporate entities to enforce these arbitration clauses against consumers and employees and people of unequal bargaining position, but they're still getting $1,000 an hour, and the corporations that are paying the fees get a chance to write the fees off from their income taxes, and so it's not fair to the consumers. This amendment really wants to get at class action lawsuits. That's really what it wants to do, but it incorporates smaller lawsuits along with the what they really want to get at, which are class action lawsuits. And for that reason, I oppose this amendment. And as far as arbitration goes, it's fine when parties, after a dispute has arisen, make a decision that we're going to divert from the civil justice process. We're going to go into mediation, or we'll go into arbitration. That's something that the parties have the ability to decide, but they can't decide it if the plaintiff has already signed a agreement that binds them to arbitration.
Would the sponsor yield?
I'll yield to the gentleman.
Thank you, Mr. Johnson. I think you make the essential point there, which I think goes right to the heart of your legislation. What we're trying to do is protect people's constitutional right of due process and jury trial. That's what really this is all about. We're trying to say that we're not going to allow market imbalances of power override the constitutional rights of the people. This reminds me a lot of the debate, which I thought had been settled back in the 1960s in cases like the Heart of Atlanta Motel case and the Ollie's Barbecue case, where restaurants and motels and hotels and bake shops and so on are saying, we don't want to serve gay couples, or we don't want to serve interracial couples, or we don't want to serve interfaith couples. And we've said, no, we're going to override that private contractual determination with the constitutional rights of the people as interpreted by Congress. And we're doing the exact same thing here. We're saying we are not going to allow private contracting parties to override and destroy people's Seventh Amendment rights and due process rights to get into court.
And reclaiming my time, the gentleman is correct. And what this amendment would do would be to render the arbitration clause enforceable if these certain provisions were not included in the attorney's fee contract. And so it gets right to the heart of what is intended by the legislation, and I certainly oppose it, and I'll yield to the gentleman.
Thank you for yielding. I appreciate that. I just want to make sure that Professor Raskin's concern for the Constitution is just as fervent in the next couple of bills that we are addressing as this one, and I yield back.
The gentleman yields back. The question occurs on the amendment. Those in favor say aye. Aye. Opposed, no. No. In the opinion of the chair, the noes have it. The amendment is not agreed to. A slow roll call is requested. The clerk will call the roll.
Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren? No. Ms. Lofgren votes no. Ms. Jackson Lee? Ms. Jackson Lee votes no. Mr. Cohen? Mr. Johnson of Georgia? Mr. Johnson of Georgia votes no. Mr. Deutsch? Mr. Deutsch votes no. Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Cicilline? Mr. Cicilline votes no. Mr. Swalwell? Mr. Swalwell votes no. Mr. Liu? Mr. Raskin? No. Mr. Raskin votes no. Ms. Jayapal? Ms. Jayapal votes no. Ms. Stemmings? Ms. Stemmings votes no. Mr. Correa? Ms. Scanlon? Ms. Scanlon votes no. Ms. Garcia?
No.
Ms. Garcia votes no. Mr. Neguse? Mr. Neguse votes no. Ms. McBath? Ms. McBath votes no. Mr. Stanton? Mr. Stanton votes no. Ms. Dean? Ms. Dean votes no. Ms. McCarcel-Powell? Ms. Escobar?
No.
Ms. Escobar votes no. Mr. Collins? Mr. Sensenbrenner? Mr. Sensenbrenner votes aye. Mr. Shabbat? Mr. Gomert? Mr. Gomert votes aye. Mr. Jordan? Mr. Jordan votes yes. Mr. Buck? Mr. Buck votes aye. Mr. Ratcliffe? Mr. Ratcliffe votes yes. Ms. Roby? Ms. Roby votes aye. Mr. Gates? Mr. Gates votes aye. Mr. Johnson of Louisiana? Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock? Mr. McClintock votes aye. Ms. Lesko? Ms. Lesko votes aye. Mr. Reschenthaler? Mr. Reschenthaler votes aye. Mr. Klein? Mr. Klein votes aye. Mr. Armstrong? Mr. Stube? Mr. Collins votes aye. Mr. Cohen votes no. Mr. Liu votes no. Ms. Mucarsel-Powell votes no.
The clerk will report. Gentleman from Florida?
Mr. Stube votes yes. Mr. Chairman, there are 14 ayes and 20 noes.
And the amendment is not agreed to. Are there any other amendments?
Chairman,
Gentleman from Wisconsin, for what purpose does the gentleman seek recognition?
I have an amendment at the desk, finally.
Gentlemen, the clerk will report the amendment.
Amendment offered by Mr. Sensenbrenner of Wisconsin to the amendment in the nature of a substitute. Page 9, line 2, insert the following before the period at the end.
Chairman, I ask unanimous consent that the amendment be considered as read.
Without objection, the gentleman is recognized for 5 minutes to explain his amendment.
Mr. Chairman, my amendment ensures that this bill will only be applied to contracts made after the bill's enactment. Why? Because freedom of contract and the rule of law that assures the enforcement of freely made contracts are an integral process and pieces of the bedrock that has supported America's rise to the freest, strongest, and most prosperous economy the world has ever known. Would this bill honor freedom of contract and then preserve the rule of law? The answer is no. Its entire purpose is to abrogate the provisions of millions upon millions of consumer, employee, and other contracts, running them all through the shredder. Will this decrease the cost of consumer goods and services? No. Honoring these contracts will help to keep down those costs. Will this improve the protection of employees? No. Research shows that employees get better results from arbitration than from courtroom trials. Will this improve the confidence of freedom of contract and the rule of law and to make the American economy great? No, exactly the opposite. I can tell you very clearly what this bill will do. Line the pockets of the class action trial lawyers. Leave out in the cold anybody who doesn't qualify for a class action suit and can't afford the high price of a courtroom lawyer for their individual case, and undermine the rule of law and freedom of contract. My amendment seeks to protect as much of that as possible by ensuring that the bill will not apply to contracts already made. And I yield back.
The gentleman yields back. I recognize myself for 5 minutes to oppose the amendment. I'm opposed to the amendment, and I yield the balance of the time to the gentleman from Rhode Island, Mr. Cicilline.
Thank you, Mr. Chairman. Mr. Chairman, I rise in opposition to the amendment. First of all, this amendment, if enacted, would leave millions of Americans unprotected from the dangers and unfairness of mandatory arbitration provisions. Consumers and workers rarely win in forced arbitration. According to a 2017 study by the Economic Policy Institute, consumers won only 9% of the claims brought, while in stark contrast, companies won 93% of the claims they brought. Heidi Scherholz, an economist at the Economic Policy Institute, notes that, and I quote, "Not only do companies win the overwhelming majority of claims when consumers are forced into arbitration, they win big," end quote. For example, in arbitration cases involving financial institutions, she notes that because consumers rarely win, they end up paying financial institutions a whopping $7,725 in arbitration on average. The Consumer Financial Protection Bureau concluded in 2015 that, and I quote, "There is no evidence of arbitration clauses leading to lower prices for consumers," end quote. Consumers and workers rarely receive any benefit of reduced costs through forced arbitration. In a letter urging passage of the FAIR Act, the National Association of Consumer Advocates wrote that forced arbitration results, and I quote, "in financially harmed consumers and workers left without any remedies at all," end quote. According to data from the two biggest arbitration providers, the American Arbitration Association and JAMS, only 1,909 consumers won a monetary arbitration award over a 5-year period. In all nursing home arbitration cases, only 4 won a monetary award over this period. Of the 11,114 employment claims that were filed, only 282 won a monetary award. That's 2.5%. And of the 6,012 arbitration cases involving credit cards and banks, only 131 won monetary damages. That's barely more than 2%. These numbers make it clear that you are more likely to be struck by lightning than win a monetary award in forced arbitration. And in fact, only today, the American Association for Justice released a report, "The Truth About Forced Arbitration. Americans are more likely to be struck by lightning than win in forced arbitration." I ask that this report be made part of the record.
Without objection.
Furthermore, forced arbitration discourages consumers and workers from adjudicating disputes altogether, while the lower probability of victory and meager legal fees associated with forced arbitration discourages attorneys from representing individuals in arbitration proceedings. Even when workers do go to arbitration, the system can wreak havoc on their lives. It's bad for victims of sexual assault and sexual harassment. We heard during the ARCAL subcommittee hearing from Gretchen Carlson about her experience and from Kevin Zoiber about his experience as a member of the armed forces. Finally, if arbitration was truly beneficial for working people, it would be popular with the American people. Instead, more than 84% of Americans across the political spectrum support ending forced arbitration in employment and consumer disputes because they know it harms their interests. So I urge my colleagues to oppose this amendment, which would mean millions and millions of Americans would continue to suffer at the hands of forced arbitration provisions which deny them the right to have their claims heard and will continue to allow big corporations in this country to not be held accountable for their misconduct.
Would the gentleman yield?
With that, I'll yield certainly to the gentleman.
Thank you. I thank the gentleman for yielding. This motion would allow current contracts that force arbitration on unwitting and unknowing victims to remain in place, and that's the problem. These provisions were without knowledge of the victims, and now you're going to force them to be bound by the arbitration clause. That's the purpose of the legislation, is to render these clauses unenforceable, and for that reason, I'd ask my colleagues to oppose this amendment, and I yield back.
The gentleman yields back.
I yield back, Mr. Chairman.
And I yield back. Is there any further discussion on this amendment?
Mr. Chairman, move to strike the last word.
Who is that? Oh, gentleman from Arizona.
I have a question for the gentleman from Rhode Island. I'm wondering how this is fair to when two parties enter into a contract and Congress changes the law to enforce that against a contract that has already been entered into. I didn't hear that in your remarks. I'm just wondering.
Sure. I mean, I think the reality is for millions of Americans, they aren't agreeing to these terms. These are provisions that are included in the fine print that most Americans don't even know are there. In fact, most people in this hearing room don't realize that they're subject to forced arbitration provisions in the care of their parents in a nursing home, on their mobile cell phones, on a number of consumer contracts. So those are not knowing, voluntary agreements to participate in arbitration. They're unwittingly being forced to as a condition of their contract services, And in fact, if after that parties want to voluntarily decide to participate in arbitration, they obviously can. But this legislation is designed to eliminate forced pre-dispute arbitration that compels people to give up their rights to litigate their grievances in a court of law in exchange for getting service for their phone or their cable or keeping their parents in a nursing home.
Reclaiming my time, I'm wondering, and I guess I direct this to the gentleman from Georgia who is sponsoring this bill, but I'm wondering if we shouldn't give both parties 30 days to renegotiate in that situation. I just don't think it is equitable to suggest that a contract that is entered into, whether someone reads the fine print or not, can be unilaterally changed by Congress and require the parties to participate in a new contract drawn by Congress without giving the parties time to renegotiate.
Will the gentleman yield for a question?
Yeah, of course.
I would just ask, I'm really curious to know what
I will yield.
I appreciate it. I'm really curious to know what that renegotiation would look like. Would that mean some additional fine print forced upon the consumer who has no ability, or would that actually be a provision that would leave it up to the consumer? Because right now, as we've been discussing this entire afternoon, that's just simply not the case, and the consumer has no ability.
Well, you've taken away the fine print, right? You've already said that we will not allow a certain kind of contract to be entered into.
I'm just asking though, what you have in mind, because the point that's been made by so many of my colleagues so eloquently, and is that the consumers all across America, millions of them, right now, are living by provisions that say if they are wronged, and we've spent the day laying out all the cases where that's happened, if they are wronged, their only option is forced arbitration. They have no say over whether to go to arbitration. They have no say over who the arbitrator is, because that's going to be picked by the corporation, and they have no ability to determine whether or not that's the path they choose to go down. So I want to understand what you're suggesting, because the history that we've dealt with that brought us to this moment shows that there's no ability to negotiate. That's the whole purpose of this legislation. That's what we've spent the whole day working on, and that's what still seems to be missing by so many of my colleagues.
Reclaiming my time, what the new contract would involve is an actual freedom. The freedom of the consumer and the freedom of the big bad corporation is what I think the term is over on that side. And they would have the opportunity to negotiate. Any claim over $15,000 couldn't be arbitrated. Any claim involving this type of claim couldn't be arbitrated. Whatever it is that you're...
Will the gentleman yield? I think the problem is you imagine a world in which I, as a consumer of a mobile phone company, Verizon, that I have the ability to negotiate that kind of agreement. Right now, they say, here are the terms of service. If you accept it, you're agreeing to mandatory arbitration. I don't have a choice right now to say, look, I'd like to have your service, but I'm going to cross out the forced arbitration, because guess what? I won't get the service. So we don't have the ability as an individual consumer to negotiate, because there's no bargaining power. And that's why precluding these from being included in consumer contracts is really the only way to protect the consumer.
I will yield to the chair.
This argument of freedom of contract reminds me exactly of the 1905 Supreme Court case of Lochner versus New York, in which a New York law limiting bakers to working 60 hours a week was held unconstitutional because it violated the baker's freedom of contract. Who is the state to tell the baker he couldn't contract to work 190 hours a week? It's the same one-sided thing here, and we have the right, and freedom of contract is not supreme over when you have no real freedom, when it's one-sided. I'll yield back.
I yield back.
Gentleman yields back. The question is on, gentlelady from Washington.
Thank you, Mr. Chairman. I just wanted to, I oppose this amendment as well, and I wanted to draw our attention back to the urgency of what we're talking about, and the incredible number, a staggering 60 million workers who are locked into mandatory arbitration contracts that they had to accept as conditions of their jobs, that would not be eligible if this amendment were to pass, because this would limit it to this current date. And I wanted to specifically draw attention to the issue of sexual harassment, because it has been spoken about a lot on this committee. But we're talking about, depending on the industry, anywhere from 25 to 85% of women reporting having experienced sexual harassment in the workplace. And because of that forced arbitration, many of those then experience the additional insult on top of injury of having their access to the courts stripped away. And not all workplaces are created equal. Industries that employ large numbers of women are much more likely to have forced arbitration requirements. So we have to be very clear that women are losing and have been losing in forced arbitration. Their choice is taken away, then they're forced into these secretive proceedings, and then they lose because they're forced into arbitration proceedings that are rigged against them. I wanted to raise a couple of examples. In my state and across the country, Darden Restaurants owns popular chains including Olive Garden and Longhorn Steakhouse. Darden has imposed a forced arbitration rule on the workers in these restaurants. Workers in those chains don't get their day in court, and they have to go to arbitration. And Darden workers have won in forced arbitration only 8 times. 8 times. Or take the thousands of women who are working for Sterling Jewelers, who were harassed, assaulted, and ignored for promotion, while less qualified men were interviewed, promoted, and allowed to perpetuate a culture of assault. Declarations submitted by over 250 women and men described pervasive, inappropriate conduct where women were groped, demeaned, and urged to sexually cater to their bosses just to stay employed. But because Sterling forced all employees to sign arbitration agreements, the class of 69,000 women affected by these conditions were forced to go it alone in arbitration. That means that women like hardworking Washington resident Lynell Gullidge are being held back from seeking justice, even though she was repeatedly passed over for promotion in favor of less qualified men and subjected to sexually inappropriate tirades from a male coworker. I know there are many on the other side of the aisle that have said that they would have been supportive if this were just limited to sexual assault, and I just wanted to remind this committee that last Congress, we introduced, Sherry Bustos and I, along with the late Walter Jones and Elise Stefanik on the House side, and on the Senate side with Lindsey Graham and Kirsten Gillibrand, we introduced the Ending Forced Arbitration of Sexual Harassment Act. We have introduced that again, 2019, which would invalidate forced arbitration clauses in cases of sex discrimination and harassment. But that's not sufficient. I would love to have all of you that have said that this is an important priority for you sign on to that bill, but that is not sufficient. And I think we need to make it clear that this, the FAIR Act goes beyond that in ensuring that we are restoring all consumers, workers, and small business rights. And starting, this is, I think, a very historic first act, and I thank my colleague, Mr. Johnson, for this bill. We do need even more legislation that restores choice to millions of workers, consumers, veterans, and small business owners who have been robbed of their voices. So I urge the committee to reject this amendment and to pass. I would. Yes.
I thank the gentlelady for her comments. I just can't help but observe, as a co-sponsor of this bill, that when it came to our own workplace, we had a broad bipartisan effort to eliminate mandatory arbitration, not only for sexual harassment, but for other forms of discrimination. That was bipartisan because we recognized that the mandatory arbitration provisions that were utilized in the House of Representatives were leading to unconscionable results. It's no different out in the other parts of the workplace. It's not just making sure that congressional employees' rights are protected, but the rights of others, women who are being harassed, people who are being discriminated against are protected. And I just thought it would be worth having us recall how we treated our own employees. And I thank the gentlelady for yielding.
I thank the gentlelady from California. That is absolutely an excellent point, and I think that this act is really trying to make sure that we bring justice and access to due process to all of the millions of workers who deserve it, who currently are being stripped of that without even knowing that they are. Thank you, Mr. Chairman. I yield back.
The question, I think, now occurs on the amendment. Those in favor say aye.
Aye.
Opposed, no. No. In the opinion of the chair, the nays have it. The amendment is not agreed to. A slow roll call is requested. The clerk will call the roll.
Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren?
No.
Ms. Lofgren votes no. Ms. Jackson Lee? Mr. Cohen? Mr. Johnson of Georgia? Mr. Johnson of Georgia votes no. Mr. Deutsch? Mr. Deutsch votes no. Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Cicilline? Mr. Cicilline votes no. Mr. Swalwell? Mr. Swalwell votes no. Mr. Liu? Mr. Liu votes no. Mr. Raskin? Ms. Jayapal? Ms. Jayapal votes no. Ms. Stemmings? Ms. Stemmings votes no. Mr. Correa? Ms. Scanlon? No. Ms. Scanlon votes no. Ms. Garcia?
No.
Ms. Garcia votes no. Mr. Neguse? Mr. Neguse votes no. Ms. McBath? Ms. McBath votes no. Mr. Stanton? No. Mr. Stanton votes no. Ms. Steen? Ms. Steen votes no. Ms. McCarcel-Powell? Ms. Escobar?
No.
Ms. Escobar votes no. Mr. Collins? Mr. Collins votes aye. Mr. Sensenbrenner? Mr. Sensenbrenner votes aye. Mr. Shabbat? Mr. Gomert? Mr. Gomert votes aye. Mr. Jordan? Mr. Jordan votes yes. Mr. Buck? Mr. Buck votes aye. Mr. Ratcliffe? Mr. Ratcliffe votes yes. Ms. Roby? Ms. Roby votes aye. Mr. Gates? Mr. Gates votes no. Mr. Johnson of Louisiana? Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock? Mr. McClintock votes aye. Ms. Lesko? Ms. Lesko votes aye. Mr. Reschenthaler? Mr. Reschenthaler votes aye. Mr. Klein? Mr. Klein votes aye. Mr. Armstrong? Mr. Armstrong votes yes. Mr. Stubbe? Mr. Stubbe votes yes. Ms. Jackson Lee, you are not recorded. Ms. Jackson Lee votes no.
Gentleman from Maryland?
You are not recorded. Mr. Raskin votes no.
Gentleman from Louisiana?
Mr. Richmond, you are not recorded. Mr. Richmond votes no.
The gentlewoman from Florida?
Ms. McCarcel-Powell votes no.
Has everyone voted who wished to vote? The clerk will report.
Mr. Chairman, there are 14 ayes and 21 noes.
The amendment is not agreed to. Are there any further amendments to the amendment in the nature of a substitute? The question then occurs on the amendment in the nature of a substitute. This will be followed immediately by a vote on final passage of the bill. All those in favor of the amendment in the nature of a substitute respond by saying aye. Aye. Opposed? No. In the opinion of the chair, the ayes have it. The amendment in the nature of a substitute is agreed to. A reporting quorum being present, the question is on the motion to report the bill H.R. 1423 as amended favorably to the House. Those in favor respond by saying aye. Aye. Opposed, no. No. And the ayes have it, and the bill is ordered reported favorably. A roll call, a recorded vote has been requested, and the clerk will call the roll.
Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Ms. Lofgren votes aye. Ms. Jackson Lee? Ms. Jackson Lee votes aye. Mr. Cohen? Mr. Johnson of Georgia? Mr. Johnson of Georgia votes aye. Mr. Deutsch? Mr. Deutsch votes aye. Ms. Bass? Mr. Richmond? Mr. Richmond votes aye. Mr. Jeffries? Mr. Cicilline?
Aye.
Mr. Cicilline votes aye. Mr. Swalwell? Mr. Swalwell votes aye. Mr. Liu? Mr. Liu votes aye. Mr. Raskin? Mr. Raskin votes aye. Ms. Jayapal? Ms. Jayapal votes aye. Ms. Demings? Ms. Demings votes aye. Mr. Correa? Ms. Scanlon? Ms. Scanlon votes aye. Ms. Garcia?
Aye.
Ms. Garcia votes aye. Mr. Neguse? Mr. Neguse votes aye. Ms. McBath? Ms. McBath votes aye. Mr. Stanton?
Aye.
Mr. Stanton votes aye. Ms. Dean?
Aye.
Ms. Dean votes aye. Ms. McCarcel-Powell?
Aye.
Ms. McCarcel-Powell votes aye. Ms. Escobar?
Aye.
Ms. Escobar votes aye. Mr. Collins? Mr. Collins votes no. Mr. Sensenbrenner? Mr. Sensenbrenner votes no. Mr. Shabbat? Mr. Gomert? Mr. Gomert votes no. Mr. Jordan? Mr. Jordan votes no. Mr. Buck? Mr. Buck votes no. Mr. Radcliffe? Mr. Radcliffe votes no. Ms. Roby? Ms. Roby votes no. Mr. Gates? Mr. Gates votes aye. Mr. Johnson of Louisiana? Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. McClintock votes no. Ms. Lesko? Ms. Lesko votes no. Mr. Reschenthaler? Mr. Reschenthaler votes no. Mr. Klein? Mr. Klein votes no. Mr. Armstrong? Mr. Armstrong votes no. Mr. Stubbe? Mr. Stubbe votes no.
Has everyone voted who wishes to vote? Yeah. What about, has Hank voted? Did Hank vote? Okay. All right, we got everybody. The clerk will report. Are we waiting for one more? Suspend that. Who are we waiting for? You have the next one ready? The gentleman from Tennessee.
Mr. Cohen votes aye.
The clerk will report.
Mr. Chairman, there are 22 ayes and 14 noes.
Then the bill is adopted. The ayes have it. The bill is amended as ordered reported favorably to the House. Members will have 2 days to submit views. The bill will be reported as a single amendment in the nature of a substitute incorporating all adopted amendments, of which there were none, I think. And without objection, staff is authorized to make technical and conforming changes. Pursuant to notice, I now call up H.R. 1236, the Extreme Risk Protection Order Act of 2019, for purposes of markup, and move that the committee report the bill favorably to the House. The clerk. All right, we'll suspend for a moment while the House thins out. As I said, we'd like to move on to the next bill, so people who are leaving, please do so quickly and quietly. People who are coming in, the same. We'll do it now. Pursuant to notice, I now call up H.R. 1236, the Extreme Risk Protection Order Act of 2019. For purposes of markup, and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 1236, to support state, tribal, and local efforts to remove access to firearms from individuals who are a danger to themselves or others pursuant to court orders for this purpose.
Without objection, the bill is considered as read and open for amendment at any time. I will begin by recognizing myself for an opening statement. Last month, the country was rocked by news of mass shootings on 2 successive days. In El Paso, Texas, where 22 people were killed and 26 were wounded, and in Dayton, Ohio, where 9 people were killed and 27 others were injured. Just a few weeks later, a gunman in Odessa, Texas, took the lives of 7 more people. In total, 53 people were killed in mass shootings in August alone. At a vigil to commemorate the victims in Dayton, the governor's speech was drowned out by calls to do something. Today, we will. This committee has already passed 2 important gun safety measures: the Bipartisan Background Checks Act and the Enhanced Background Checks Act, both of which passed the House in February and are currently being blocked in the Senate by the Republican majority. But that will not stop this committee. Today, we consider 3 more measures that would help prevent the tragic gun violence that has engulfed this nation in recent years. I want to emphasize, however, that we are not taking these additional actions simply to respond to mass shootings. As has been our motivation with respect to the gun safety bills the committee has already considered, we are acting because of the urgent need to respond to the daily toll of gun violence in our communities, whether they are mass shootings or not, and whether or not they make national headlines. There is no single bill that will address all of these issues. That is why we are considering 3 additional bills today. More than 35,000 Americans lose their lives because of guns every year. Every day in America, on average, 34 people are murdered with a firearm. Gun violence of this magnitude is a distinctly American problem. A country-to-country comparison is shocking. For example, in 2011, the United Kingdom had 146 deaths due to gun violence. Denmark, 71. Portugal, 142. Japan, just 30. But in the United States, more than 35,000. Even when you adjust for population differences, Americans are disproportionately killed by gun violence. A recent study in the American Journal of Medicine found that compared to 22 other high-income countries, the gun-related murder rate in the United States is 25 times higher. The President and others try to pin blame for gun violence on mental illness. But we know that the United States does not have a rate of mental illness that is 25 times higher than the rest of the world. That is clearly not the source of our gun violence crisis. We must approach this issue with a range of solutions and with a sense of urgency. And we cannot use the incantation of mental illness as an excuse to do nothing real. That is why we are taking action today. The first gun safety bill we will consider, H.R. 1236, the Extreme Risk Protection Order Act of 2019, provides funding to states to enact extreme risk protection statutes that empower law enforcement and families to petition courts to intervene when individuals in crisis pose a danger to themselves and to others. This bill encourages states and localities to take meaningful steps to prevent gun violence tragedies at home and in their communities, while at the same time protecting the due process rights of those individuals in crisis. Under this bill, states and localities are encouraged through funding assistance to pass laws that ensure a court may issue an extreme risk protection order removing firearms from a person in crisis and preventing them from purchasing firearms only after making a finding that there is evidence demonstrating that the person poses a significant danger of injuring himself, herself, or others. The judge considering the petition from law enforcement or family members would authorize temporary firearms restrictions for up to 30 days. To extend the length of the firearms restriction for up to a year, the court must afford the firearm owner a full hearing, ensuring the person's due process rights to contest the petition. H.R. 1236 strikes an appropriate balance between protecting the rights of the gun owner and ensuring community safety. The amendment in the nature of a substitute that I will offer shortly will include provisions based on H.R. 3076, introduced by our colleague, the gentlewoman from Georgia, Ms. McBath, that authorize the issuance of an extreme risk protection order by a federal court when law enforcement, family members, or household members seek one. The inclusion of this federal mechanism is an explicit acknowledgement that gun violence and mass shootings, unfortunately, have no bounds. Every jurisdiction in this country has been touched by gun violence. The federal provision ensures consistent access to courts and enables continuity of enforcement across state lines. Federal courts have long been bastions of due process, and the protections included in the federal ERPO provisions protect respondents' due process rights. It is important to note that the duration of an order issued pursuant to an ex parte proceeding contemplated in this bill, during which a neutral federal judge must weigh whether a threat is imminent, is limited to 14 days, during which the court will determine, after a hearing including participation by the respondent, if a long-term order is appropriate. Taken together, the grant provisions in H.R. 1236 and the federal petition provisions incorporated from H.R. 3076 provide a sensible means by which an individual who exhibits dangerous behavior can be prevented from possessing or purchasing firearms. According to one study, over 50% of mass shooters exhibited some warning signs before the shooting. The combined bill before us authorizes an individual who has serious concerns that someone they know possesses an extreme risk to take the action needed to save lives and prevent suicides. 17 states and the District of Columbia have passed extreme risk protection laws, which have proven to be effective. In California, one study found that extreme risk protection orders were issued under that state's law in 21 instances where there was concern of a mass casualty event. After Connecticut enacted an extreme risk protection order law, the state experienced a 14% reduction in its firearm suicide rate. In Indiana, the number of suicides declined 7.5% in the 10 years after Indiana enacted its extreme risk protection order law. The bottom line is that we know that extreme risk laws save lives. We have witnessed their effectiveness in state after state. So let us continue to take the reasonable and measured steps that the American people demand. This week, it was reported that nearly 90% of Americans support extreme risk protection laws. Today, this committee has the opportunity to build on measures the House has already passed, including H.R. 8, the Bipartisan Background Checks Act of 2019, which also enjoys similar overwhelming support, over 90%. I thank Representatives Carbajal and McBath for championing this effort and for introducing the critical provisions that constitute this important bill. And I urge all of my colleagues to support H.R. 1236 as it will be amended by the amendment in the nature of a substitute. I now recognize the ranking member of the Judiciary Committee, the gentleman from Georgia, Mr. Collins, for his opening statement.
Mr. Chairman, thank you for holding, again, this markup today. And like you, I'm concerned about addressing this important issue, from addressing the instances of mass shootings to combating the scourge of firearm violence plaguing our urban communities. I stand ready to work with you on sensible solutions that actually could prevent these atrocities. What I am not willing to do is support legislation that will not do anything to make us safer and simultaneously infringes on the rights and liberties guaranteed by our Constitution. Unfortunately, all three of the bills that we're considering today do just that. First, we'll be considering H.R. 1236, the Extreme Risk Protection Order Act of 2019. While this bill may seem like a common sense measure, it is flawed in far too many ways to be worthy of this committee's support. 5 months ago, in an interview, one of the statements that was given by the chairman, and you said this to one of your hometown papers: "My original motive in politics from the time I probably was 12 years old was civil rights, civil liberties, and due process. And I've always concentrated on them, and that has never changed." Well, I'm not sure what's changed, but the bill before us today has serious due process problems. Namely, the bill allows for confiscation of individuals' firearms without notice or an opportunity to be heard. Even more egregious is the fact that the ex parte determination can be made when a judge finds there is a reasonable cause to believe the individual possesses a danger to himself or others having access to a firearm. Reasonable cause is not even probable cause. It's certainly less than clear and convincing evidence. Do we really want to surrender Americans' constitutional rights to such a low standard without giving those citizens notice or an opportunity to be heard? What other rights are we willing to sacrifice in this manner? The ex parte proceeding standards are not the only flaws in this bill. For a permanent order, the court must find that a preponderance of evidence that the individual possesses a danger to himself or others by having access to a firearm. We don't convict people of petty crimes by a preponderance of evidence, but my colleagues are willing to take away a constitutional right with merely a finding of preponderance of the evidence. Ours is the committee charged with protecting due process and every constitutional right, not eviscerating them. Yet the defects in this bill continue to emerge. Once the court finds a person too dangerous to possess a firearm, what does the bill indicate the court should do? Does it provide for some sort of incapacitation, detention, evaluation, or provision of mental health services? No. In fact, the bill is silent. It does nothing to address the person's possible illnesses or instabilities, even though the court has just determined him or her dangerous enough to be stripped of a fundamental constitutional right. I suppose we should all just hope and pray such dangerous individuals don't have access to any other things that would allow them to harm themselves. If they do, then this is sort of a waste of time. H.R. 1236 allows a person to petition to take away any other person's Second Amendment rights with a court order. There is no required nexus between the parties. They don't even have to know each other. In light of that, it's unthinkable that this bill doesn't require a law enforcement officer to independently substantiate the claims, and there are no penalties for making a false claim against anyone. These are just a few of the myriad of problems that this is found in this bill. I've seen and heard statements from some of my Republican colleagues indicating that we'd be willing to consider red flag legislation. Unfortunately, the proposal today is so flawed that not anyone committed to looking at the errors that we have just laid out would be supportive of that. I have said this before, there are ways that we have worked together in the past. This is not one of those. This is another issue in which I think the harm it is found here, not discussed probably as much today as will be, is something that will again work to, as the chairman sort of alluded to, make us feel better about what we're doing, but in the end, not actually help in those situations in a real way, and in many ways could actually add to the problem. And with that, I yield back.
Thank you, Mr. Collins. Without objection, all other opening statements will be included in the record. I now recognize myself for purposes of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 1236, offered by Mr. Nadler. Strike all after the enacting clause and insert the following.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered as base text for purposes of amendment. I will recognize myself to explain the amendment. As discussed in my opening statement, the amendment in the nature of a substitute largely adds provisions from H.R. 3076, introduced by the gentlewoman from Georgia, Ms. McBath. These provisions authorize the issuance of an extreme risk protection order by a federal court when law enforcement family members or household members seek one. In addition to a few other modest changes to the underlying bill, these provisions strengthen significantly the underlying legislation, and I urge all members to support it. I now recognize the ranking member of the full committee, Mr. Collins, for any comments he may have on the amendment in the nature of a substitute.
Thank you, Mr. Chairman. Look, I suppose the amendment in the nature of a substitute actually, maybe addresses some of the due process issues that I raised just a moment ago with the underlying bill, but I'm sort of left scratching my head over some of the, at the amazement at what was just offered as the nature of a substitute. H.R. 1236 is introduced, allows for a judge to order someone's firearms to be taken away without notice to that person. If the judge finds there is reasonable cause to believe that the individual possesses a danger of causing harm to himself, herself, or to others by having access to a firearm. The amendment now allows for such other higher evidentiary standard. Is the majority saying that the states can receive grants if they implement an extreme risk protection order that requires the judge to make this finding based on probable cause? I'm not sure, and maybe we'll hear about that later. But this will lead to a patchwork of laws that vary from state to state, creating an incentive for those seeking extreme risk protection orders against others to go forum shopping. If they can't find a state to grant them an extreme risk protection order, this amendment allows them to ask a federal court to issue one. When we look at the process to seek and obtain a federal extreme risk protection order, we can see why the bizarre amendments were made to, we can't see why this was made to a state grant program. The federal extreme risk order section, while far from perfect, at least makes a better attempt at trying to secure due process rights, including under the grant program, states would be allowed to permitted to allow anyone to petition for an order against anyone. Under the proposed federal processes, only family or household members or law enforcement officers may petition the court. Under the grant program, an ex parte order can be in effect for 30 days and be ordered based on the finding of reasonable belief by a judge. Under the federal process, it can only be for 14 days and can be ordered based upon the finding of probable cause by a judge. However, the amendment requires that the court hold a long-term order hearing within 72 hours of issuing the ex parte order. The federal process would also require counsel to be provided for the respondent free of charge if he or she is financially unable to afford counsel. Under the grant program, the long-term orders can be granted if the court finds a preponderance of evidence that the individual possesses a danger of causing harm to himself or others by having access to a firearm. Under the federal process, a court must find by clear and convincing evidence that the individual possesses a risk of imminent personal injury to himself or by another by purchasing, possessing, or receiving a firearm or ammunition that the order is necessary to prevent injury. Under the grant program, the order can be in effect for an unspecified time frame. Under the federal process, it would expire after 180 days. It really does amaze me that we have set out one set of due process standards for one forum and different sets in another. And I would simply suggest that we go back to the drawing board and come up with at least a consistent proposal that doesn't cause really confusion or, as we've said, forum shopping. And I understand we're under immense pressure from folks to do something, but this especially now looks even more rushed, disjointed, and creates bad policy. And I would urge my colleagues to vote against this amendment in the nature of substitute. And with that, I yield back.
The gentleman yields back. Are there any amendments to the amendment in the nature of a substitute?
Mr. Chairman,
For what purpose is the gentlelady from California seek
I'd
recognized?
like to strike the last word.
Gentlelady is recognized.
First, I support Mr. Carbajal's bill and the substitute that you've just introduced. As the chair of the California Democratic delegation, we're all acutely aware in the state of California that California's taken the lead in so many gun violence measures, one of which is the so-called red flag bills. And we know, just from the statistics from law enforcement, that there are people who really were, in a bad place, who shouldn't have been armed, and the state procedures were used, and the public safety was protected. So that's really an important thing. We've got a number of bills up. We've passed bills already and sent them to the Senate. No one measure is going to solve every problem. But if we take a number of sensible steps, it will make people safer. And I think that's very important. I wanted to say just a word about Mr. Carbajal, because he took the lead to author this bill, and I want to give him, he was here earlier in the proceedings that had another obligation. Obviously, he's not a member of the committee, but he took the lead to introduce this bill, and I want to give him credit for doing that. Too many of us have had situations where people in our districts were the victim of gun violence. Recently, my district in Gilroy, California, was added to the list, a long, sad list of communities that experienced gun violence. And I think that's one of the issues, and we'll get to the other bill later in the evening or perhaps tomorrow. But you can't do it state by state. California, in that case, prohibited the purchase of assault weapons and magazines, and also restricts sales to people under 21. And so what happened, the perpetrator of this violence went to the neighboring state of Nevada, and he bought in Nevada what he couldn't buy in California. And so we really do think that we've got to have a broader approach, which is what these bills do today on the red flag law. It's not good enough when you can buy a gun on the internet just by clicking a little box saying, I'm fine. It's not good enough just to have state-only laws, much as I credit those states who stepped up to the bat to make a difference. So I support the bill and the underlying bill, but I particularly wanted to thank, obviously, our colleague, Ms. McBath, who is a leader and is responsible for the substitute, but also Mr. Carbajal, who's not a member of this committee, for the effort that he's put in and the credit that he deserves for it. And with that, Mr. Chairman,
Actually, will the gentlelady yield?
I would be happy to yield to my fellow Californian first, Mr. Swalwell, and then to Mr.
I thank the gentlelady, and just to follow up on the point that I think you so astutely made about California's gun safety laws, it's often used against us. Well, California has some of the toughest laws. In New York, I know you hear the same argument. In Illinois, the same thing. And then people will cite the gun deaths in Oakland or Richmond or Chicago. And the truth is, we're only as safe as the states around us, the lowest common denominator. In a recent study by Alameda County District Attorney Nancy O'Malley found that in the last year, in 2018, over half of the weapons used in the homicides where a weapon was recovered, the firearm came from outside the state, primarily Arizona and Nevada, where there are much looser gun laws. So I think this seeks to, many of the bills today seek to recognize that we need to be safe everywhere, and I would yield back.
And I would yield to the gentleman from Maryland.
And I thank the gentlelady from California. I just wanted to respond to my friend from Colorado who in the last round of statements lobbed a kind of provocative question in my direction, saying that he hoped that I would stand by the Constitution on these bills as I did in the bill about compelled arbitration. And I gladly accept that challenge. You know, I take my lead from the Supreme Court's decision in the Heller versus District of Columbia case, where the Supreme Court said that we can protect the core of the Second Amendment, which is the right of self-defense, with a handgun, the right to have a rifle for hunting and recreation, but it does not give you the right to carry dangerous weapons. It does not give unstable people, dangerous people, felons and fugitives the right to carry guns, and it certainly does not negate the power of the state to create reasonable time, place, manner, and use restrictions on the Second Amendment. Every constitutional right is conditioned by a set of regulatory restrictions that can be a legitimate exercise of the police power of the states or the constitutional powers given to Congress. So I accept that challenge gladly, and if anybody believes any of these bills are actually unconstitutional, they should say so and explain why, based on the Heller decision. Otherwise, all of the Second Amendment rhetoric is quite off point.
I yield back, Mr. Chairman.
Mr. Chairman, I have an amendment at the desk.
The spectators and the audience, please refrain from showing approval or disapproval of remarks from here. Those are our rules, although we appreciate the sentiment, but those are our rules.
Mr. Chair.
Gentleman,
amendment at the desk.
what purpose?
Before that, Mr.
Let's go
Chair,
on to the strike
thank
last
you.
word first, and then.
Thank you. Mr. Chair, if I could move to strike the last word. You know.
Ladies recognized.
Thank you. Mr. Chair and members, I really understand people that want us to do something after mass shootings. The thing is we need to work in a bipartisan fashion so we actually get it passed into law and do things that will actually make a difference. And we have done things in a bipartisan fashion in the past to actually help, like the Fix NICS Act and those type of things. And we also want to make sure that we're not taking away people's constitutional right without due process. And so that is why I oppose this legislation. And I oppose it because, one, it lacks the due process protections I want to see before someone loses their Second Amendment rights. Two, it doesn't address mental health concerns. There is no requirement in this bill for an individual to be detained, evaluated, or provide mental health services. Three, it allows people's Second Amendment constitutional rights to be taken away through ex parte orders, meaning they might not even know that this is happening to them or given a chance to defend themselves. And D, once people are stripped of their rights, there is no way to earn them back in this bill. But I do believe we can work together on bipartisan legislation. I'm from Arizona, and our Republican Arizona governor had put forward through the Senate a bill last year, a red flag legislation that was also supported by the NRA. But it had really strong due process protections. It also addressed mental health concerns, and it did not allow for ex parte orders. It only allowed for emergency orders with notice to the individual, and it allows people that did have their Second Amendment rights taken away a way to earn them back. And with that, I yield back.
Gentlelady yields back for our purposes. Gentlelady from Texas seek recognition.
Strike the last word, Mr. Chairman.
Gentlelady's recognized.
Mr. Chairman, there have been a number of things said here that doesn't allow me enough time to respond to, but let me first and express my appreciation to Congressman Carbajal and certainly to Congresswoman McBath. Whenever I see her, I hope she allows me to acknowledge Jordan, because that is how I first met her. And she was not a member of Congress. She was a grieving mother, of which she remains today. And that is the mountain that I stand on. 1999 was Columbine, and I came to Congress a few years before that. And we are in the same position after the heinous acts of Columbine that we are today. I heard the same arguments. I heard, let's wait. We don't have the proper procedure. I heard people talk about mental health, and it was clear, as I recollect, I was even put on a Columbine task force. It was clear that those young men, if you go back to that history, had mental health concerns. Every governor that does not want to move on any aspect of gun safety regulation raises the question of mental health. And when I say to my friends, write a bill, we'll be happy to move on that legislation. I have legislation dealing with mental health concerns. But in this substitute that is part of the chairman's mark, there is an array of issues dealing with evidence presented. On the long-term orders, there is a hearing where a due process can be rendered to the individual that you're seeking the extreme risk order against. Family members can be in the court. There is no doubt that as long as we languish in the sea of inaction and talk about what we can do, we will do nothing. We need a federal scheme, construct, because, as has been indicated, the mockery that is made of Chicago is because surrounding states have no laws that deal with gun trafficking and gun regulation and gun safety, and they all pile in to the states that do have laws. The same thing with Washington, D.C., California. So I think what we're trying to do today is to acknowledge that the federal government has been derelict. The Senate has been derelict in not passing the federal construct to save lives. I know you will hear from my colleagues, but the pain that we are experiencing in states that have just experienced the devastation of gun violence, from El Paso to Odessa, and I can assure you, state officials in my state, mental health, red flag laws, all of that has been rejected. And yet, this is an AR-15. It's a lightweight. I've held it in my hands. And so while we pitter-patter around, someone can get this in their hands. Law enforcement will be at the other end of that barrel while they're trying to protect the community. The AR-15, the weapon of war, was the choice of the killer in El Paso. It has been the choice of the killer in Las Vegas. The rounds that that individual had was just unbelievable. So if you would read the bill, you would see that there are due process provisions in this bill. And I thank the gentlelady from Georgia for enhancing it through the federal construct that she needs. In the hearing that I had last week, the summit that I had last week, and all through this time, I will take note of the witnesses that came to A1. None of them I asked their political perspective, what card they're carrying in their pocket. From chief medical examiners to a chief doctor out of the Texas Children's Hospital said $300 billion is being used to deal with gun violence and the death and pillage that comes after it. Nobody raised what voter registration card or who they're voting for, but they talked about the pain. So I'm here today in the name of Ayanna Stewart, who flew from Indiana to be with me in the summit, who organized the I Am Foundation, whose mother had 3 children, a girl and 2 boys. At 7 years old, Ayanna had to run to her room because they came and said, your brother, who left out just a few minutes ago with his Jordan shoes on, has been shot dead in the street. Then she went on with life. continued with her mother and a single parent. And at 13, they came to get her out of the class. She thought it had to do with her studies, but her other brother had been shot dead. Guns kill. People who have conditions contribute to that. We have to do something, and it has to be federal law that does something.
Mr. Chairman.
Gentlelady yields back.
Mr. Chairman.
Gentleman from Ohio, for what purposes seek recognition?
Strike the last word.
I'm sorry, I think the gentleman from Colorado was first.
He's given an amendment.
Oh, then the gentleman from Ohio.
I thank the chairman. If the House Judiciary passes this bill today, we will have changed a fundamental and sacred principle in this country. In America, you are innocent until proven guilty until today. If we pass this bill today, we are going to invert the standard and say you are guilty until proven innocent. And you will be guilty without doing anything wrong. Under this bill, you are guilty without doing anything wrong simply because someone thinks you might do something wrong. And who is the someone under this bill who can petition a court to take away your Second Amendment liberties? Who is the someone defined under this bill? Page 13, amendment of nature of substitute. The chairman just introduced it. Top of page 13, it says family or household member. Go down to subsection D. Who's a household member? An individual who resides or who has resided with the respondent during the past year. A roommate who hung out with you for 1 month last year can go petition a court to take away your Second Amendment liberties. Some roommate maybe didn't like you. Some thought you were a slob. Whatever, can go petition the court to take away your fundamental right without you doing anything wrong. And oh, guess what? Guess what? When they go in the court to take away your fundamental liberty, even though you haven't done anything, committed no crime, guess what? You don't even get to be there. You don't even get to defend yourself. That's exactly what this bill does. And Mr. Raskin has talked about the Constitution, the Bill of Rights. I heard him on TV talk about it. I heard him twice now in this committee hearing today talk about it. And that's how we're going to take away someone's Second Amendment liberties. And this is the House Judiciary Committee, for goodness sake. What other constitutional right can you lose without doing anything wrong and without your knowledge and then have to go petition a court to get it back? Tell me what that is.
I'm happy to answer
that happens. Tell me when that happens. This bill is so wrong on so many levels. It violates fundamental Second Amendment rights. It violates property rights. It violates due process rights. And yet today, the House Judiciary Committee, with the storied history this committee has in defending the Bill of Rights, is going to pass this legislation. I mean, this is scary. This is a scary road to start heading down. We all want to stop gun violence. We all know these terrible, evil things that happen are just that terrible and evil. But doing it, trying to do something that this bill seeks to do in this manner is so fundamentally wrong. And again, for the Judiciary Committee in the United States House of Representatives, who is charged more than any other committee in this body with defending the Constitution and the Bill of Rights, to pass this is just wrong. With that, Mr. Chairman, I yield back.
Will the gentleman yield?
Gentleman yield for a question.
Mr. Chairman? Mr. Chairman?
Thank you, Mr. Chairman. I move to strike the last word.
Gentlelady is recognized.
Thank you. Thank you, Chairman Adler, for calling this markup so that we can take these life-saving measures. I am proud that we are holding a historic markup today on extreme risk protection orders, including my bill, the Federal Extreme Risk Protection Order Act of 2019. And I'm also proud to be co-sponsor of H.R. 1236, led by Congressman Carbajal, to which we are adding my legislation. Extreme risk protection orders are a life-saving tool to keep firearms out of the hands of those that pose a danger to themselves or to others. The bill we are marking up today will guarantee nationwide access to this critical tool. With extreme risk laws at the state and federal level, we can prevent gun violence, including mass shootings, suicides, and all horrific events that do not make the everyday headlines. Too often we are told that we must accept gun violence. We are told that no single piece of legislation can prevent every incident. We're told that instead of changing our laws, we must have more lockdown drills, more security guards, and more bulletproof glass. more vigils for those that we have lost. But we also see time and time again that someone knew that a shooter was dangerous, someone knew the shooter had weapons, someone knew the shooter was filled with violent thoughts, or even that a person was thinking of taking his own life. Too often someone knew, but no one had a tool to do anything about it. Some states decided their law enforcement officers, their communities, and their families deserved that tool. That's why 17 states, as it was expressed earlier, and the District of Columbia passed extreme risk laws. These laws have had bipartisan support. They have been passed by state legislatures controlled by Republicans and Democrats. They have been signed into law by governors from across the political spectrum, and they are saving lives. Today, we take the next step in preventing gun violence with extreme risk laws. This package provides an incentive for more states to pass these laws, supports states that already have them, and creates a federal extreme risk law so that every community in every corner of this country has access to this life-saving tool. Our brave law enforcement officers put their lives on the line every single day to keep our families safe. They deserve every tool that we can give them to help keep our communities safe. And instead of fighting the horror of a mass shooting with more bullets, we can empower our law enforcement officers to disarm threats before a shot is fired, before another life is lost. This legislation also empowers family and household members, those who are most likely to see the signs that a person is in crisis. My legislation gives law enforcement and family members a way to take action, a way to protect themselves, to prevent mass shootings, or to save the life of a loved one considering suicide. Nearly 100 people every single day die in this country as a result of gun violence, and yes, I will never let you forget that my son Jordan was one of them. I know the pain of losing a child to gun violence, and not anyone in this room, anyone in this country should ever be faced with that pain. And for every single day that we fall into not taking action, mothers and fathers across this country will live through the same nightmare that I did, and many survivors that I've worked with over the country. And for every single day that we fail to take action, siblings and spouses will feel the same agony, the same grief that comes with losing a loved one. It is our responsibility to prevent this suffering, to bring an end to this constant heartbreak. Inaction is unacceptable. And today we are acting to help those in crisis. We act to empower law enforcement. We act to prevent the vigil for the loved ones that we'll keep losing if we don't do something about this. And I thank my colleagues who have co-sponsored this legislation, and the many advocates and survivors who continue to fight to end gun violence. Because I promise you, no one is immune to this. Don't ever believe that you are immune to this. I ask my colleagues on this committee, both Republicans and Democrats, to stand up with me in supporting this legislation. We have to save lives. And I yield back the balance of my time.
Will the gentlelady yield?
The gentlelady has yielded back the balance of her time. Who seeks recognition? The gentleman from Arizona.
Move to strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman. I appreciate the dialogue that's taking place today. I'm grateful for it. This is a serious issue. I echo the comments made by the representative from Arizona, Representative Lesko, and the gentleman from Ohio, Mr. Jordan. And I appreciate that the gentlelady from California, Ms. Lofgren, mentioned statistics and data, because I think that is important. She mentions the use of those. So the Department of Justice, Bureau of Justice Statistics, put out a study earlier this year, just in January of this year. And this is important to realize because they found that 1.3%, only 1.3% of prisoners who had committed a violent crime in this country obtained their gun from a retail source. Only 1.3%. that means that it has an impact on whether the NICS background check program is going to even work or be effective at all. But what they found that I think is really interesting and really problematic is that 43% obtained their weapon off the street or from the underground market. There are no background checks off the street and in the underground market. It just isn't happening. The point is, and this is what I think we miss, is a lot of times we think that we're going to correct something, correct a problem, and we create legislation, and it leaves massive gaps because there are massive gaps in how these things take place. An additional study was conducted on the behest of President Barack Obama in 2013. He ordered the Center for Disease Control and Prevention to assess existing research on gun violence, and that report, compiled by the Institute of Medicine and the National Research Council, found, among other things, that firearms are used defensively hundreds of thousands of times a year. According to the CDC, self-defense can be an important crime deterrent, and indeed it can be. Recent CDC reports acknowledge that studies directly assessing the effect of actual defensive use of guns have found consistently lower injury rates among gun-using crime victims compared with victims who used other self-protective strategies. In particular, the AR-15, which the gentlelady from Texas mentioned. Let me tell you, sometimes that has been used in self-defense. Oswego, Illinois, 2018, a man with an AR-15 intervened to stop a neighbor's knife attack and cited the larger weapon's intimidation factor as a reason why the attacker dropped the knife and stopped the attack. Catawba County, North Carolina, 2018, a 17-year-old successfully fought off 3 armed attackers with his AR-15. Houston, Texas, 2017, a homeowner survived a drive-by shooting by defending himself with his AR-15. Broken Arrow, Oklahoma, 2017, a homeowner's son killed 3 would-be burglars with an AR-15. The man was later deemed to have acted in justifiable self-defense. Ferguson, Missouri, African-American man protected a white man's store from rioters by standing outside with AR-15s. Texas, 2013, a 15-year-old boy used an AR-15 during a home invasion to save both his life and that of his 12-year-old sister. Rochester, New York, 2013, home intruders fled after facing an AR-15. I think sometimes in our zeal to try to protect people, we sometimes forget the other side of the story, that there are lawful uses of these weapons used to defend themselves against people who are evil with malevolent intentions. No one sanctions or approves of the type of mass shooting and violence that we've seen periodically in this country. Similarly, I don't think we can tolerate turning what is a constitutional right on its head, turning the burden of proof on someone who has not committed a crime and telling them you will be found responsible or not responsible based on an ex-parte proceeding, with or without your awareness of that ex-parte proceeding. And then you will have the pleasure of trying to set that aside at some future date, if you will. That's not the American way. And with that, I oppose the amendment, and I thank the chairman and yield the balance of my time.
The gentleman yields back. Are there any amendments to the bill?
Mr. Chairman?
Gentleman from Colorado, for purpose, does the gentleman seek recognition?
I have an amendment at the desk.
The gentleman has an amendment at the desk. The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 1236, offered by Mr. Buck of Colorado. On page 22, lines 5 and 10, strike and insert the following between lines 10 and 11.
Gentlelady from California reserves a point of order. Without objection, the amendment is considered as read, and the gentleman is recognized in support of the amendment.
Thank you, Mr. Chairman. Mr. Chairman, the evidence linking gangs and violent crime, including gun violence, is overwhelming. According to estimates, gangs and gang members are responsible for upwards of 90% of all violent crimes in our country. Nationwide, 80% of all gun-related homicides in the U.S. in a typical year are gang-related. In Chicago, there are over 100,000 gang members compared to 12,000 police officers. In Windy City a few years ago, gang members were responsible for 61% of all homicides. The homicide clearance rate for gun-related deaths, meaning an arrest was made, is incredibly low. Only 17.5% of these cases in Chicago result in an arrest. In Chicago, criminals know they will get away with it. No wonder gun violence is so high. Chicago isn't alone. In Baltimore, 88% of all killings last year were the result of gunfire. 84% of those killed had a criminal record, with nearly half having themselves committed a violent crime. Baltimore's homicide rate is on par with El Salvador, nearly 56 murders per 100,000 people, which is higher than many of the world's most violent countries. Baltimore's homicide rate is 10 times the U.S. rate. In 2015, the homicide clearance rate in Baltimore was only 27%. It is clear that this kind of the gang and gun violence is common in many major cities. Despite the clear link of gangs to gun violence, Democrats continue to support sanctuary city policies that protect gang members who are in our country illegally, like members of MS-13 who are terrorizing our cities. On July 21st, Daniel Alejandro Alvarado Cuellar was brutally murdered in Maryland by 7 people in a gang-related murder. While Cuellar's murder was not gun-related, it is believed that he was killed because of a gang war. 6 of the 7 people charged in his murder are members of MS-13. The majority of violent crime, including gun violence in the United States, is linked to gangs. My amendment is quite simple. It would allow the issuance of a red flag order against anyone whose name appears in a gang database if there was probable cause to include that individual in the database. We need to get guns out of the hands of violent criminals. That starts with giving law enforcement another tool to disarm gang members. We should target red flags against known criminals, especially gang members. This approach will have the most meaningful impact in reducing gun violence. And I yield back.
Virginia, yield.
I will yield to the gentleman from Georgia.
Thank you. I appreciate, what's here, and I think the standard that you set for probable cause and all is, again, there's been concerns before about the gang list, and this raises it to the level of probable cause, that there is actually, a standard here that is set. I appreciate the gentleman, at least his offering and making the standard of due process and also the standard of evidence here, which we have pointed out before, is contradictory in this bill. At least this is a clear standard that provides something that somebody could do, and I appreciate you offering that in that standard. I yield back to the gentleman.
And I yield to the gentleman from Arizona.
I thank the gentleman for yielding, and I appreciate his amendment and his efforts to improve this bill. I want to bring in some more data. This is done with regard to, someone mentioned police officers on the other end. And so in just a few years ago, 2013, 16,000 police officers from the level of officer all the way up to commander-in-chief responded to this survey. One of the questions was, what effect do you think a federal ban on manufacture and sale of some semi-automatic firearms termed by some as assault weapons would have on reducing crime? 71% said there'd have no effect. They didn't believe it'd have any effect. Do you think a federal ban on manufacture and sale of ammunition magazines that hold more than 10 rounds would reduce violent crime? 96% said no. Do you think that a federal law prohibiting private non-dealer transfers of firearms between individuals would reduce violent crime? 80% said no. Do you think increasing the severity of punishment for gun trafficking, particularly by unlicensed dealer or straw purchasers who buy arms for persons ineligible to own them, would reduce instances of gun crime? 60% said yes. That, I think, is something we need to be looking at. That is something we need to be looking at. There's another survey. When next time I talk, I'll be talking about a GAO report about how few people who falsely try to get their firearms are prosecuted. That's part of our problem. Yield back.
Gentleman yields back. I recognize myself for 5 minutes in opposition to the amendment. The factors in the bill that are to be considered by the court in considering these applications are all behaviorally based. That is to say, they're based on whether the person has engaged in recent threats or acts of violence toward other people, toward himself, recent acts of cruelty to animals, evidence of ongoing abuse of controlled substance by the person, may consider other factors, including the reckless use, display, or brandishing of a firearm, history of violence, evidence of explicit or implicit threats. The amendment proposes a new ground, which is not behaviorally based, it's associationally based. It says that the factor to be considered is whether the respondent's name appears on a list of dangerous people, of gang members, for instance, maintained by any federal, state, local, or tribal government, law enforcement agency, corrections department, juvenile rehabilitation. Number one, we know that these lists are often put together with no due process considerations. They're often inaccurate. They're not kept up to date. Now, that's not true of all departments, but many lists that would be used here. And they do not we do not have any indication of the reliability of any such list with respect to any individual. All the other factors that are in the bill are basically recent observations that the respondent committed threats or acts of violence, threats or act toward himself, toward others, acts of cruelty. In other words, things that would indicate that this person is unstable or dangerous, and that should be considered. Just the fact that someone's name is on a database maintained by some department, a database of unknown accuracy, and based on we don't know what, that's really a due process problem if some of these others are certainly this. So I would oppose the amendment.
Would the gentleman yield?
I will
Mr.
oppose,
Chairman?
I will oppose the amendment. Who's gentlelady from Texas? For what purpose?
Thank you, Mr. Speaker. Would the
I'll
gentleman
yield
yield?
to the gentlelady from Texas.
Thank you. I'd like to actually say a couple things about these databases. An experience that we have had in my district in El Paso, as CBP has continued to separate families, they have used these databases as a resource and as the information found in them as a reason to separate children from parents. We have had casework that has demonstrated the flaws in some of these databases where a father has been accused of being a gang member, and we have discovered after much time spent with lawyers, actually their lawyers have discovered problems with identity, confusion, similar names, people who have been denied their children as a result of this. And so I would just urge the committee, I know that members of the committee like to use these databases as a resource. I am telling you, based on experience in my district, they should not be held up as a reliable resource. And I would urge vote against this amendment. Thank you, Mr. Chairman.
Reclaiming my time, I would simply add, in addition to what Ms. Escobar said, in addition to the experience we've had, New York Times carried a story a few months ago about a 15-year-old Central American immigrant who'd been here for a number of years, who was doodling in high school and was observed doodling designs that some police officer thought was a gang insignia, and consequently his name was put on a gang list, and he was subsequently deported with total lack of due process. So I'd observed that in addition to everything that I said and that Ms. Escobar said about the list, they are frequently, I shouldn't say frequently, they are often enough, maybe frequently, racially discriminatory because there are no real enforceable standards for how they're put together, and therefore they should not be used as a predicate in this kind of proceeding. I'll yield to the gentlelady from...
Thank you, Mr. Chairman.
Thank
I
you.
wanted to
No,
add...
actually, he yielded to me. And I just wanted to say, make a statement and ask a question. You know, California had these databases, and they finally stopped when they discovered that they had 3-year-olds on the databases, gang members. I mean, so some of these are reliable, a lot of them are not. And so I think the comments that have been made in opposition to the amendment are correct. On the other hand, if the author of the amendment, Mr. Buck, were willing, Mr. Buck, if you are willing to vote in favor of this bill, if we adopt your amendment, I would support the amendment because there is some due process involved. This would be a factor to be considered. So the question is, if this amendment is adopted, will you support this bill?
This bill is so fatally flawed that I think there's a lot of amendments that need to be adopted before this bill rises to the level where I think it guarantees basic constitutional rights in this country. But I will certainly consider that if you vote for this bill. I would actually consider that a step in the right direction.
All right,
California
I
has been
appreciate
sending
that.
so
My
many
time
people.
My time has expired. I yield back.
My time has expired.
Move to strike last word.
The gentleman from Georgia is recognized.
I think we've just brought into account a very interesting discussion that just a couple of summers ago was brought to light and led by the chairman on a no-fly, no-buy, which we have shown to have multiple problems with the exact very same thing we just talked about. That there was, the list had inaccuracies, had senators, had members of Congress, had others who were on this list, but yet it was taken then. We've got to take this list and we've got to accept this list. Because if we do that, then we're making a statement forward. With no, real inaccuracies or discussion. It is also interesting to me that, however, in this amendment offered by Mr. Buck, that the department, agency, or administration had to have probable cause to identify the respondent or the member that is on the list. Another step further than just simply being on the list. The agency had to show probable cause that the person is supposed to be on the list. Now, if we're really, the discussion here is also, the chairman made the comment that this is a behavioral list and not an associational list. Have we actually, want to consider what it takes to become a gang member? In many of these, this is not only associational, but behavioral. And it's not and this is the sad part, this is not a joke. This is the problems that we have here that need serious answers and serious solutions and serious discussions without saying simply because we don't like the list, we're not going to include it in this bill. And no, before the question ever comes up, I will not vote for this because of the many problems that I listed beforehand in this bill that are a legitimate attempt. I can make no bones about the attempt. It's just the wrong attempt. As we look at this, though, to say that to bar this amendment from not going forward is it's not behavioral listed and it's associational takes to the very heart of what gang members do. And gang members in society, how you even get into the gang to start with, is typically violent, it is typically behavioral, and it is typically shown to be the very thing that this bill is actually purporting to do. If we really wanted to get at some of these lists that were just talked about as being so bad, then why don't we put this standard in every one of these lists of probable cause? Why don't we actually raise the standard, actually put the list into a certain area that we actually can determine that somebody should actually be there instead of getting on there as we've seen by mistake. It's amazing to me, we had a large blow up on the floor of this House just a couple of years ago about the no-fly, no-buy list, which was shown to have issues, but at that point, nobody brought those, or from the other side brought those as a concern, and now we're bringing it as a concern. So this is just, again, when this amendment actually puts probable cause to identify the respondent as a member of a gang, it is a little bit concerning to me that we're blowing this into a different proportion to say that it's not behavioral, so we don't want it, it's associational. I think there's a lot of problems with that. With that, I yield to the gentleman from Colorado.
Would the gentleman
Thank
yield?
you. Thank you. I appreciate my friend from Georgia, and I want to respond to the chairman's comments. Mr. Chairman, being jumped into a gang is a behavior. It is an action. Wearing a red hat is an action. Wearing blue shoelaces is an action. You choose to put certain things on to display. When you wear a tattoo or you go and get a tattoo that says 13, you are making a statement to the world. And it is an action when you are getting that tattoo and when you display that tattoo. When you show gang signs to other people, that's an action. And that's what gets you.
The gentleman yield on that point.
I will.
Very, very briefly. When you write 13 on a piece of paper, maybe it's a sign of that thing. Maybe you're just doodling because it's the 13th of June.
Reclaiming my time. Reclaiming my time on this one. Reclaiming my time. Probable cause, if taken properly, is not 13 on a doodle pad, Mr. Chairman. That is not an argument that actually, frankly, makes sense here. Because this amendment actually says probable cause. So to say that I'm writing here 13, I may be writing circles here because I think we're wasting time, but that doesn't mean that I have a problem. It means that I'm bored. Now, that's what probable cause would do. I'd have to come in and I'd have to look and say, should I be on that list or should I not be on that list? I think that's the concern I have here. I understand what you're trying to say, but you're splitting a hair that just doesn't exist.
Would the gentleman yield?
From Colorado.
Would the gentleman yield?
I believe I have the time now.
You do.
Thank you. Mr. Chairman, this goes beyond West Side Story and the Jets and the Sharks. This is a situation where the police officers are trained, and there are very identifiable signs, and it isn't just one sign. It isn't just someone writing the number 13 in school. This is a series of, this is a threshold that has to be met, and whether you agree with it or not, a court is going to decide with a probable cause standard in order to make the decision that someone is in a gang. And if we're serious about combating violent acts, we should start with that kind of probable cause finding.
Gentleman, yield for a question.
I will.
Under this amendment, if this amendment were adopted, and a court were considering an application for one of these orders, and it had various pieces of evidence in front of it, one of which was the inclusion of his name on a list, on a gang list maintained by some department.
I'm digging here.
Would it have to conduct a collateral inquiry as to whether that department had probable cause to put that person's name on the list?
So what would happen in this situation is the officer involved would present to the court an affidavit, and the affidavit would say this individual is dangerous for these reasons, and then that affidavit would say this individual has a gang membership as evidenced by a confession, a color, a tattoo, an association, on and on. And that evidence would be the probable cause for this particular element of violence. If we're trying to stop violent crime, let's go after those that commit the violent crime.
This is a higher standard.
The gentleman's time has expired.
He's asking you that question. So-
Gentlelady from Texas? No. I'm sorry, the gentleman from Georgia.
Thank you, Mr. Chairman, and I move to strike the last word.
Last word is duly stricken. The gentleman is recognized.
I rise in opposition to this amendment. This is common sense legislation that goes to protect society and protect those who would be a danger to themselves. And I want to commend Representative McBath for her diligence and her work in crafting this legislation along with Representative Carbajal. This is meaningful legislation. It would mark a crucial step towards addressing our country's tragic suicide epidemic. In 2017, over 47,000 Americans died by suicide, and more than half of these included the use of a firearm. This marks a 31% increase in suicide since 2001. When loved ones are a danger to themselves and others, many people don't know where to turn their loved ones. H.R. 1236 could change that by providing federal funding to increase public awareness of extreme risk laws and establishing a federal extreme risk law. The family and friends of those considering suicide could be educated on an effective, life-saving resource. However, if we are to require our federal court system to implement extreme risk protection orders and place the onus on them to enforce these, we must ensure the federal court system has the resources to do so. The Judicial Conference currently believes district court systems are understaffed, burdening judges and impeding their ability to seek justice in their own courtrooms. In fact, in 2019, the Judicial Conference recommended that the Northern District of Georgia hire at least one additional permanent judge to alleviate the burden on current judges. Additionally, the workload of magistrate judges has increased since 2014, with an 8% increase of total matters disposed of by these judges. In fact, the last government shutdown severely restricted federal court operations, allowing President Trump to not only hold federal employees hostage, but our judicial system as well. Had the president not finally agreed to work with Congress, paid operations would have shut down after January the 18th. Now, H.R. 1236 is vitally important and would take crucial steps to save the lives of people who are suffering and might be a danger to themselves. However, we cannot expect it to be as effective as it could be if we don't ensure our federal court system is fully funded and has all of the resources necessary to enforce this bill. So Once again, we're between a rock and a hard place. We need this bill, and we also will need to ramp up our funding for the federal courts. So let's pass this bill. Let's do what we need to do to protect the public and to protect those who would resort to suicide with no other options. Let's help our relatives and friends of these people, help them, and pass this legislation. And with that, I will yield back.
Who seeks recognition? The gentleman from Texas, Mr. Gomert.
I'll rise in support of the amendment. I think it's well thought out. Anytime we can add probable cause finding to determinations by a court when they're considering constitutional rights, then it certainly makes a proposed bill better. I know sometimes here in Congress, people get to playing games, but I greatly appreciate the sincerity of my colleague, Ms. McBath. It brings to mind so many times sitting there as a judge on felony cases and listening to the horrendous effects of crime. My friend from Texas had mentioned that since the events of 1999 in Colorado that nothing has changed, but actually in 1999 the assault weapons ban was in place. And I know that some like to say, oh, it was so effective, and that's one of the directions folks here may want to go, but apparently do. But the study that was done and often cited by people like Senator Feinstein, by Chris Coper and Jeff Roth, National Institute for Justice, they actually noted, quote, the evidence is not strong enough for us to conclude that there was any meaningful effect, i.e. that the effect was different from zero, unquote. 7 years later, they published, the NIJ published a follow-up and said, we cannot clearly credit the ban, assault weapons ban, with any of the nation's recent drop in gun violence, and indeed, there's been no discernible reduction in the lethality and injuriousness of gun violence, unquote. John Adams in 1797, as our second president, said, this Constitution is intended for a moral and religious people. It is wholly inadequate for the government of any other. As we hear about victimization, as we hear my friend from Georgia talk about the suicides, I can guarantee you crimes, suicides will increase as morality and spirituality continue to decrease in America. The polls show very clearly, as the Supreme Court said at the turn of the 19th century in the Trinity Church case, that it cited pages of evidence and said, this is a Christian nation. Obviously, everybody wasn't a Christian, but as David Horowitz, former communist and avowed atheist Jew, currently says in his current newest book, what we're seeing really is an attack on Christianity. And that has gone on around this nation, and I know some can scoff, but the more we get away from being a moral and religious nation, the more need there will be to get rid of the Second Amendment, to get rid of freedom of assembly. Oh, before that, you can't continue to have a right against unreasonable search and seizure, due process, freedom of assembly, freedom of speech, freedom of religion. Those will have to go away because we are no longer a moral and religious nation.
Would the gentleman yield?
So, no, I won't. I don't have enough time to do that. So I would just submit to you that we can use these words and try to craft laws, but people will continue to kill themselves at a higher and higher alarming rate, and there will be continuing these mass shootings we didn't used to deal with. But perhaps there was something good when children in school were taught that you shouldn't covet, you shouldn't be jealous, you shouldn't kill, that those are things you should not do. And today we have more politicians encouraging jealousy, covetousness, and we've divided the country, and it needs to stop. That will do more than any of these bills in taking away constitutional rights. I yield back.
The gentleman yields back. The gentlelady from Pennsylvania, Ms. Dean.
Thank you, Mr. Chairman. And I rise in opposition to this amendment for all of the reasons and the flaws that have been pointed out by my colleagues. But I want to speak to the underlying bill to compliment Ms. McBath, our colleague and friend, for her courage. Representative Carbajal, the chairman, I just thank you for doing this. I wanted to serve on the Judiciary Committee. And one of the reasons I wanted to serve on the Judiciary Committee was to make a difference around gun violence. We can, we're going to, and because of your strength, I believe we will get there. I have long believed in this measure, and I'm going to tell you a very personal story why. It was literally 30 years ago today. I just texted my husband to say, you okay I tell this story? It was 30 years ago today that my then 26-year-old sister-in-law in Columbia, South Carolina, was riding her scooter to work when a drunk driver hit her, killed her, and left the scene. She was 26. She was beautiful. She had her whole life ahead of her. Hit-and-run driver. My husband had the sad task of going down to Columbia to collect her body, and a couple of days later, he and I went down to collect her things. She was engaged and living with her fiance, and when we packed up her things, we found a gun in the house. We also by then recognized and knew who the killer was. The drunk driver literally was the backdoor neighbor within shooting distance of my sister-in-law's home. My husband and I were enraged at the killing, but we didn't think twice. We looked at each other, we saw the gun, we put it in our trunk and locked the trunk. There was a gun in that house. I didn't think twice. Of course I wasn't going to leave it lying around for my sister-in-law's fiance, who was enraged. He was out of his mind with grief and anger and loss. I wasn't gonna risk leaving it around. It's a rational thing to do, and people need the ability to do that legally. We need to give people the chance to save lives. Not all death is gun violence or gang violence. Much of it is suicide. As Mr. Johnson so eloquently pointed out, we have a serious crisis of suicide. We have people that fall into grave crises. They're not otherwise mentally ill, but like my brother-in-law, he was in a grave crisis. I didn't want to risk anybody else getting hurt. We need to give people these tools. They are legal, they offer due process, they will save lives. Red flags law makes sense. They made sense years ago. They make sense now. And I hope we will pass this and save lives. I yield the remainder of my time.
Gentlelady yields back. Does anyone else seek recognition on this amendment? Gentlelady from Georgia.
Thank you, Mr. Chairman. I'd like to just make a response in reference to my Republican colleague, Mr. Gomer. You know, I cannot agree with him more in terms of the country being in a moral crisis, and guns have a lot to do with it, but I just have to say this one thing, that I truly believe that the moral crisis is that the guns have become our God. Guns have become our God. Guns have become the means by which we solve all of our problems, have become our authority. Guns are the problem because we no longer reverence God. I agree with you 100%. But immorally, using guns as the mean to solve our problems and our differences, then definitely we are in moral decay. And for anyone that considers themselves a person of faith to continue to watch this carnage and to and not be able or willing to act, that is immoral. And I yield back the balance of my time.
Gentlelady yields back. The gentlelady from Pennsylvania.
I just was looking at the amendment that was offered, and I have to say I'm a little confused about the amendment because our colleagues across the aisle have said that they oppose this bill because it doesn't provide enough due process. But this amendment fails that test. It only requires probable cause when the bill itself would require clear and convincing evidence, which is a higher standard. So, you know, if our colleagues think that we should have a weaker standard, then that would be great, and we can just all vote on the bill as is. It also, the bill as written also would allow them to provide that evidence if we have a gang member who is a current danger. So it doesn't exclude offering evidence if in fact it can be provided. So I don't think the amendment offers anything. I think it actually is contrary to the arguments that our colleagues are making, and I would oppose it on that basis.
Gentlelady yields back. Gentlelady from Texas.
I want to respect the gentleman from Colorado. We've worked together on some matters, and I appreciate his offering. I want to keep communities safe, and certainly it is a trigger, if you will, when communities hear about gangs. They would be inclined to support the gentleman from Colorado's amendment. But I think we have written a very strong bill dealing with these risk orders. As I said, since 1999, Columbine, United States Congress, we've not moved much of an inch on trying to secure communities. You would utilize the term gang, and most of our constituents would say put them on the list. I would be open to considering this after the fact, to give it more thought. But right now, as it is written, and knowing the protections that are in this bill that deals with ex parte orders and deals with long-term orders with hearings, I couldn't undermine that with this provision that is vague with dangerous consequences. What is a juvenile? 12, 11, 8, 14, 15, 16. A juvenile is someone who runs awry of the school officer, named many different names in our schools throughout the nation. A juvenile is someone inside a car who shouldn't be in the car, where the older, more experienced young men mostly, or young girls, are driving it. A juvenile is a child whose brain is not fully formed. And my concern would be, it is with a database and list that could not be vetted, could not be assured that it is used and updated, where that juvenile in college now is still on the list for something they did when they were 14. And then I think the last point that plagues the criminal justice system, it is inherently biased. What are the predominant population incarcerated across America are African American men and increasingly Latinos and increasing African American women. So I could not cede to this language, knowing that the dominant members on that list who could be judged not dangerous, but have had a run-in with the law in the early period of their life, 8, 9, 10, 11, 12, 13, 14, 15, and they're on a list, and they are predominantly young men of color. I think the four corners of this legislation allows indicia to be able to utilize the present list to cull those who may be engaged in detrimental activity that may be juveniles. The definitions does not say what age the persons are who engage in potential detrimental activity. So I would make the argument that this is not an adult bill. It says if you're engaged in certain conduct, that you would in fact be subject to such an order. A parent could indicate that that teenager is subject to certain behavior. And we realize that Columbine, teenagers, Sandy Hook, teenagers, Santa Fe, a teenager. That parent, that teacher could have taken note of that behavior. And I would recognize that, and it is recognized in this legislation. But for living in my life and living in my neighborhoods and living with juvenile detention centers that have 200+ youngsters, predominantly of color, I have to oppose this amendment. I yield back.
Mr. Chairman. Thank you, Mr. Chairman. And I want to ask the gentleman from Colorado who's offered the amendment if he would consider by agreement an amendment to his amendment on line 8 where it says otherwise tracking gangs, gang members, and to add any individual affiliated with white nationalism. And I would yield to the gentleman.
I consider that a gang. Let's go for it.
So you would add
absolutely
that language?
White nationalism, black nationalism. I think any type of supremacy and someone's in a gang organization, absolutely add it to it. If they're being tracked by a police department for that, and it's a dangerous organization, I think we should add. If you want to do that, let's add La Cosa Nostra to this.
I'm just asking on my amendment to the amendment.
Sure.
Okay, I'll yield back. Thank you. As amended, right?
Doesn't the amendment, to amend the amendment require unanimous consent? Right now, wait a minute. Let's suspend for a moment.
So yes, Mr. Chairman, I'm asking for unanimous consent to amend the amendment with the language agreed upon by Mr. Buck and myself.
Do we need unanimous consent for that? Unanimous consent is required for a second-degree amendment. Suspend for a moment. Without objection, the amendment is amended. I would still urge a no vote on the amendment as amended.
Mr. Chairman, before I'm withholding objection, just so we've gotten real agreeable here, but I would like to at least see the language that was said. There was a discussion from here of white nationalism, there's a discussion of black nationalism here. I need to see the language that we just agreed upon.
It's entirely unreasonable to ask to see the language.
That's a terrible thing.
Yeah,
No, not to get in front of the parade.
if the gentleman
here,
will
but
yield.
let's at least make sure what we're doing.
If the gentleman will yield,
Yeah, would the gentleman put the amendment in writing?
I don't have time. I mean, I was asking a question. I was reserving the right to object.
it was simply, Mr. Chairman, line 8, including individuals affiliated with white nationalism. Hard stop.
Gentlemen?
Mr. Chairman, I would accept an amendment that said that one of the risk factors would be any form of supremacy indicating a tendency to violence. That would include your white supremacy or white nationalism.
Any? What does that mean?
So, Mr. Chairman,
I would object to that.
Yeah.
I don't know what that means.
Mr. Chairman, with respect to Mr. Buck, I'm offering that and to move this along. If he doesn't want to accept that, I'll withdraw it. If Mr. Buck doesn't want to accept the language I offered.
The second degree amendment is withdrawn. The question occurs on, gentlelady from Washington.
Thank you, Mr. Chairman. I just wanted to go back to this amendment and the question of gang databases, and I wanted to highlight a report that was just released by the Inspector General for the City of Chicago. And in that report, they talk about how immigration officials, education agencies, and the FBI access the database more than 1 million times over the last decade. And in the report, it noted that police in the last 20 years identified more than 134,200 people as gang members, but 15,000 of those entries did not list gang membership or explain why they were listed as gang members. Nearly 1,000 people were listed with multiple genders. 80 people were entered as 0 years old. 90 people had a birth date before 1901. And thousands were identified as gang members despite not being arrested or accused of a crime. And so I think that this amendment is problematic on so many levels, and I want to take us back to the underlying bill and Extreme Risk Protection Order Act, which would incentivize states and localities to implement extreme risk laws, which is simply common sense. And I wanted to bring forward our experience in my home state of Washington, which became the 4th state in the nation to pass an extreme risk law in 2016. Since we have implemented that law in Washington state, and we've supported it with county resources to help enforce the law by also recovering firearms from people ordered to surrender them by a judge, a number of people at risk of suicide have been referred. According to Kimberly Wyatt, who runs the King County program, she has, quote, seen folks who were in the midst of a behavioral health crisis come into court and thank law enforcement for saving their lives. Late last year, law enforcement in Washington state prevented a possible mass shooting after someone flagged a potential threat. And that was a man who posted images on Facebook of himself holding an AR-style rifle and posted repeated threats to, quote, kill 30 Jews and commit a school shooting. So evidence shows that these extreme risk laws are effective. For every 10 to 20 firearm removals under extreme risk laws in Connecticut and Indiana, about 1 life was saved through a suicide prevented. Case study on California's extreme risk law found at least 21 cases in which extreme risk protection orders were used to disarm people who threatened mass shootings. And the support for these laws cut across demographics and party. A recent NPR poll showed that Americans, including Republicans and gun owners, broadly support red flag laws like this. And so I just want us to come back to the incredibly passionate and moving testimony of my colleague, Representative McBath, and thank goodness we have you here in Congress. We are talking about saving lives. We are talking about reasonable things that can and have been done in states across the country that have been shown to be working, that do not continue to need amendments like this one that we have with tremendous respect to my colleague, Mr. Buck. We have data that shows that these laws work. We should just pass this law here in Congress, and we should move on to the other bills that we have that also are necessary in a tapestry of laws that we need to pass here in Congress, because the reality is that as we sit here debating and debating, more lives are being lost. In the 200 days since the Senate failed to act on the common sense legislation that we passed in the House of Representatives, we have had incredible numbers of mass shootings in El Paso, Texas, and Dayton, Ohio. We went with my colleague, Representative Escobar, Congressman Neguse and I went to the vigil in the memorial in El Paso, deeply moving. We need to take action, and I just hope that my colleagues will get to the core of what this bill does, which has been proven again and again, state after state, to be an effective way of ensuring that we do not put guns in the hands of those who are at extreme risk, red flag laws. So I thank you, Mr. Chairman, and I yield back the balance of my time.
The question is on the amendment. Those in favor say aye. Gentleman from Pennsylvania, who I hope will be the last speaker on this amendment. Florida.
Mr. Chair, I'm good, thanks. Sorry about that.
Thank you, Mr. Chairman. If the gentlelady's correct that these red flag laws are working state by state, then I don't understand why we wouldn't allow them to continue to work state by state. It seems notable to me that my state of Florida has a strong sheriff-based system. Other states have state police, which is not a regime we're familiar with. And so to institute a national red flag law seems to be unfaithful to the very debate that we hear from my Democrat colleagues. I'm rather proud of Florida's red flag law. I think that it gives sufficient due process. I think a lot of the concerns my Republican colleagues have addressed wouldn't apply to the Florida law, but I also recognize that different states are different, and it would be my hope that we allow the federalist system that we're all proud to serve within to function correctly. It's my expectation that best practices will emerge, that they'll be copied among the states, and we can get onto the stuff that only the federal government could do, like reforming our asylum laws so that we don't continue to have a mounting crisis on our southern border. But I know the ranking member has more to offer, and so I'll yield him the remainder of my time.
Thank you, and I agree with the chairman, and we're just finishing up. But I think one of the things that just brought up the gentleman from Florida is this conflicting standards that we found in this bill. There's a conflicting, process standard in the bill between states and also between the federal, and I think that's a problem that would invite forum shopping and invite others. There's also many laws, not a part of those that have red flag laws, that already have issues. If someone is having an issue, you could be brought before a judge, you could be, found incompetent. You could find these, and every state has those. But also going back to the last one, and this is actually something that gentlelady from Washington State, we actually agree on, just in different ways. We've shown, if we can't bring this list up, even with due process, put in an extra step of due process, then don't ever bring the no-fly, no-buy list up again. Don't ever bring it up again. Because it is no due process on that list. You can be on the list and not even know it, and similar names are a problem. So I guess let's just be, in having this conversation, I can understand if you want to vote against it or not like it. I get that. But let's don't have another discussion. In fact, I would maybe put forth, let's do away with the no-fly, no-buy list, but everybody would go really upset about that. But this brings out a problem. This one actually makes a list better in the sense that it is still problematic, which I think we would agree upon, but at least there is a probable cause outside of even being put on the list.
Would the gentleman yield?
I'll yield for a second.
I was not in Congress when the no-fly, no-buy list was passed, but I will just tell you that on the outside, we were not in favor of it for exactly the same reasons. It's there is a serious problem with who ends up on these lists and how you get off of these lists. And I don't think that my entire caucus agrees with me on that, so I'm not speaking for anybody else, but I am saying that there is a consistency here, at least to the thinking that these databases have tremendous problems. And the reality is that on the no-fly, no-buy list, that no-fly list, that list targets a lot of Muslims, a lot of Sikh Americans, a lot of individuals that are deemed as terrorists. Here we are targeting Black and brown communities, as my colleague from Texas talked about. And I just think we have to be very clear that there are a lot of problems with these databases. We talked about this during the DREAM Act. We had an extensive discussion on this. So I am consistent, Mr. Collins. I'm with you on this.
And I agree, and I think reclaiming the time, and I think the gentlelady's right, because I was here and lived through this and was talked very badly, about whenever we say this is a problem, we were the worst in the world because you're saying, well, you're letting terrorists get a gun. No, that was not the issue on this. So I think, we've had this discussion. I appreciate the gentleman from Colorado, bringing this. I think there is sufficient protection. I will vote for this amendment, but at least it's brought out a large discussion sometimes, but in late nights in the Judiciary Committee, as I've found over my 6.5 years here, it's amazing who comes around to actually having similar points of view. I would have never started the day thinking Ms. Jayapal and I would have a similar point of view on something, but we can handle that, and the world is still going to be processing tomorrow. I yield back.
The gentleman yields back. The question finally occurs on the amendment. Those in favor say aye. Aye. Opposed, no. No. In the opinion of the chair, the nays have it. The amendment is not agreed to. Roll call is requested. The clerk will call the roll.
Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren? Ms. Jackson Lee? Ms. Jackson Lee votes no. Mr. Cohen? Mr. Johnson of Georgia? Mr. Johnson of Georgia votes no. Mr. Deutsch? Mr. Deutsch votes no. Ms. Bass? Mr. Richmond? Mr. Richmond votes no. Mr. Jeffries? Mr. Cicilline? Mr. Swalwell? Mr. Swalwell votes no. Mr. Liu? Mr. Liu votes no. Mr. Raskin? Mr. Raskin votes no. Ms. Jayapal? Ms. Jayapal votes no. Ms. Demings? Ms. Demings votes no. Mr. Correa? Mr. Correa votes no. Ms. Scanlon? Ms. Scanlon votes no. Ms. Garcia?
No.
Ms. Garcia votes no. Mr. Neguse?
No.
Mr. Neguse votes no. Ms. McBath? Ms. McBath votes no. Mr. Stanton?
No.
Mr. Stanton votes no. Ms. Dean? Ms. Dean votes no. Ms. McCarcel-Powell? Ms. McCarcel-Powell votes no. Ms. Escobar? Ms. Escobar votes no. Mr. Collins?
Aye.
Mr. Collins votes aye. Mr. Sensenbrenner? Mr. Shabbat? Mr. Gomert? Mr. Gomert votes aye. Mr. Jordan? Mr. Buck? Mr. Buck votes aye. Mr. Ratcliffe? Ms. Roby? Ms. Roby votes aye. Mr. Gates? Mr. Gates votes aye. Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes aye. Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock? Mr. McClintock votes no. Ms. Lesko? Ms. Lesko votes aye. Mr. Reschenthaler? Mr. Reschenthaler votes aye. Mr. Klein? Mr. Klein votes aye. Mr. Armstrong? Mr. Stubbe?
Gentlelady from California?
Ms. Lofgren votes no.
Are there any other members who wish to vote who haven't voted? Clerk will report. Wait. We're waiting on... Gentleman from Florida?
Mr. Stubbe, you're not recorded. Mr. Stubbe votes yes.
The clerk will report.
Mr. Chairman, there are 11 ayes and 21 noes.
The amendment is not agreed to. Are there any further amendments to the
Mr.
amendment
Chairman.
in the nature of a substitute? Gentleman from Louisiana.
Have an amendment at the desk.
Gentlemen, the clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 1236, offered by Mr. Johnson of Louisiana. Page 29, line 6, strike shall be, and all that follows through line 9.
Without objection, the amendment will be considered as read. The gentleman is recognized to explain his amendment.
Thank you, Mr. Chairman. I offer this amendment to
The
further...
gentlelady from California reserves a point of order.
Thank you. I offer this amendment to further deter an applicant from knowingly providing materially false information or intentionally harassing an individual named on an extreme risk protection application. We have to do all within our power to prevent falsely depriving any American of their constitutional rights, and I think we can help do this by increasing the level of punishment here. And the underlying legislation, H.R. 1236, did not include any penalties for false reporting or frivolous petitions. While the amendment in the nature of a substitute now includes such a provision, it does not go far enough to deter false claims. My amendment would add that an applicant abusing this process can be fined up to $5,000, imprisoned for not more than 5 years or both, to make it crystal clear that no American with a malicious intent to falsely strip a citizen of their constitutional rights will be permitted at any time. The right to arms is a critically important part of our constitutional history and traditions. It is rooted in our inalienable right to self-defense, to ensure personal security, liberty, and private property. And we have a duty here in the House Judiciary Committee to guard that very carefully. I just want to say this to my dear colleague, Ms. McBath, whose story is compelling. I know that we agree on the moral crisis in our country, and I'm glad you said that tonight. I just take issue with one thing you said. You said our concern is that guns have become our God. Those are your words. That's not our concern. Our concern is that there is a very real risk today that the state is taking the place of God, that the state is becoming our God. And that was the founders' great fear. That's the reason we have the Bill of Rights. It's the reason it was passed. It's the reason we have to protect these individual rights, because it's so important to who we are as Americans and as human beings. So I urge my colleagues to support what I think is a very reasonable amendment.
Would the gentleman yield?
I'm happy to yield.
And thank the gentleman for yielding. And I would just ask if the gentleman is familiar with any jurisdiction in the United States, a territory or a state where perjury is not a crime, meaning where if someone was to go to a court and give a false statement where they could not be charged with the crime, and I would yield back.
No, I think that's a crime in every jurisdiction. Well, unless you're talking about the FBI, Representative Gohmert says. No, but what we need to do is build into this bill, and it's been acknowledged because the amendment in the nature of a substitute does have these penalties. It's been acknowledged, I think, on both sides of the aisle that we need to have a deterrent here because this is so serious. This step that's being taken is so serious. All I'm saying is let's enhance the penalty because if you're going to have a real deterrent, you need to make it serious. I yield back to
withdraw my point of order.
I yield back, Mr. Chairman.
This is, gentlelady is withdrawing the point of order, but this is in addition to that.
Mr. Chair?
For what purpose does the gentleman from California seek recognition?
I move to strike the last word.
Gentleman is recognized.
Let me first thank Representative Carvajal and Representative McBath for this legislation. I want to say that everyone on this committee wants to reduce gun violence. So I don't doubt the motivations or sincerity of my colleagues across the aisle. I do note that their arguments and policies have not made us safer. So over the years, in fact, based on recent studies, we have increased mass shootings, not only in frequency, but also in lethality. We've heard numbers and arguments from my colleagues across the aisle, and both their policies and those advanced by the president have not worked. And I think we should look at different ways to solve this problem. With respect to this specific legislation, the Extreme Risk Protection Order, what we're doing actually is not that new, because under domestic violence restraining orders, you can take away the guns of the perpetrator in an ex parte hearing. We have 5150 mentally ill kinds of determinations where, again, the person can get the guns taken away without having to be at a hearing. So this has been done before in other jurisdictions. Courts have upheld it. So this amendment is particularly odd because it doesn't seem that in these other instances with domestic violence restraining orders and with 5150 proceedings that we have this massive increased penalty. There's no reason for it to apply to this bill. Much of this bill is simply funding existing laws in existing states that have extreme risk protection laws that have been upheld by the courts. And so nothing here is unconstitutional because the courts have already upheld existing laws that do this. I note that I was in California State Legislature when a young man went on a rampage in Isla Vista near UC Santa Barbara and killed 6 students and injured several others. It was a tragic day and it spurred us to pass California's gun violence restraining order law, the first extreme risk protection order state law in the country. Now, I believe that this legislation will be very helpful for states to continue doing these laws. I also have 2 marksmanship awards from the U.S. military. I've fired guns, I've taken them apart, I've cleaned them. I know how lethal they are. So in terms of suicide, they are extremely lethal, more lethal than any other means of suicide. We know that based on the latest statistics from the Centers for Disease Control in 2017, there were 39,773 gun deaths, which is over 100 a day. So today in America, over 100 people will die from gun violence. 35 will be killed by someone else. Over 60 will be by suicide. These extreme risk protection orders will help mitigate that problem, and we know it works because studies have shown that it works and states have adopted these extreme risk protection laws. So we can try doing the same thing over and over again and expect a different result, but that doesn't seem to be working. We should try something new, and I request my colleagues to think about this as simply trying to pass legislation because the old ways have not worked, have not kept us safer. And with that, I yield back.
I recognize myself for a moment. On the amendment. I am not prepared to support this amendment at this point. I don't know that we should oppose the amendment. The difference is the bill says shall be fined not less than 1,000. The amendment says not more than 5,000, but that couldn't be 1,000 also. The amendment adds an imprisonment up to 5 years. Presumably someone who did it so egregiously that a judge would do that probably committed perjury in doing that. My hesitation at this point is that I think before we would accept this amendment, we'd have to look at, talk to some other people, look at what various state laws say to make sure that we're not completely out of line with the practices, see what the experience is. So I will oppose this amendment for the moment, but it may be that we'll go toward it by the time we get to the floor.
Mr. Chairman.
Mr.
Recognize.
Yes, I'll yield.
I appreciate that, and I know with Mr. Johnson as well. I think we open this, so just to clarify, because I know a lot of us would be interested in, if could be worked together, we would be an acceptable amendment at Rules Committee. Is that what that you would accept?
I'm not going to commit that we'll accept it, but I'm saying we might.
Is that what you're at? I mean, that's what you're intending.
I suppose, yes,
Okay,
Rules Committee. And now, I want to make clear, I'm not committing that we will accept this amendment, but I do think that it's worthy enough to study it and to discuss it, and either to accept it later or to accept it in part or not. But I'm not prepared to, well, I'm not prepared to support it now. I would oppose it now if it comes to a vote, but if we don't do that, we will take a very careful look at this.
The gentleman yield.
Yeah.
I am willing, I take the chairman at his word in good faith. I do think it's a reasonable and thoughtful amendment, and I think it's one that should be bipartisan. I do take you at your word and the others, the sponsors of this legislation, that we do not want people to abuse this. We don't want anyone to be unjustly deprived of their constitutional rights. And because of that, in a spirit of bipartisanship, which is all too rare these days, I will withdraw the amendment in the hope that we can work on that together.
I appreciate the gentleman's action, and we will look at it carefully, and we will be talking to you and to the minority, to the ranking minority member before we go to Rules Committee.
Mr. Chairman, can I bring up a point?
Yeah.
Why don't we, because I know there's another amendment waiting on this one, why don't we withdraw pending work right now, and we'll work on it right now, because this is something we can get done. As we both have known, this is...
Well, we have to talk to other people. We can't make a decision
we got
right
plenty
now.
of staff to do that. We can sit right here and do that.
No, I can't do that right now.
Okay.
I would say, Mr. Chairman, I mean, the penalty provision is in the amendment in the nature of a substitute. So it's not that we have to determine whether or not
The
that's
question is
appropriate.
the degree of the penalty. I agree with
Right, and I'm not sure that there's any research on any state level that's going to change the outcome of that.
I don't know. I'm just not prepared to accept it at this point. It may be that we'll accept it a week from now, but, you know.
All right,
I'm just not prepared
I'll
to do that
withdraw
right
it because we've been here for up to hours anyway, and hopefully we can work on that.
I appreciate the gentleman's action, and we will be working on this.
Thank you, Mr. Chairman.
Are there any other amendments to the amendment in the nature of a substitute? Gentleman from California.
Yes, I'd move to amend by striking the last word.
Sorry?
I'd move to amend by striking the last word.
I couldn't hear him.
Move to strike the last word.
Gentleman moves to strike last word. The gentleman is recognized.
Thank you, Mr. Chairman. I think it's rather ironic, the previous bill on binding arbitration, it was argued that trial by jury is so important that it should be provided even when both parties waive that right in a contract. But then we immediately turn around and consider this bill, which argues that we should deny a person's Second Amendment rights without a jury. I do believe the underlying premise of this bill is sound. If somebody goes out of their way to warn us they want to kill a bunch of people, we ought to take them at their word. And that's what we used to do. When we identified someone who was a danger to themselves or others, we could judicially commit them to mental hospitals where we could confine them, treat them, care for them, and protect the rest of society from them. In fact, in my state of California in 1958, we had 37,000 mentally ill in state mental hospitals. Many of them were dangerous when the state's population was barely a third of what it is today. Proportionally, that would be about 100,000 population in the mental hospital today. But we emptied out those hospitals. Only about 7,000 are now confined for treatment, and the rest are out on our streets, many among our burgeoning homeless population. And I'd ask the proponents a few questions. First, what makes you think such a law will keep firearms from violent people? Most firearms used in crimes are illegally obtained in the first place. I mean, is it the effectiveness with which our drug laws have kept drugs out of the hands of drug addicts? And second, and more importantly, if someone is too dangerous to have legal access to a gun, aren't they too dangerous to be out on our streets at all? If they're violent criminals, why aren't they incarcerated? And if they're dangerously mentally ill, why aren't they confined so that they can't do harm with illegally obtained firearms or any number of other lethal forms of mayhem? Mr. Liu was absolutely right in one respect. He said we do need to look closely at what policies work and what policies don't work. We did not have this crisis 50 years ago, and we have to ask what policies have changed in those 50 years. Well, 50 years ago, we executed murderers. 50 years ago, we put violent criminals behind bars until they were too old and feeble to be dangerous. 50 years ago, when we identified a dangerously mentally ill person, we confined them so that we could treat them, and we did these things fully within the provisions of our Bill of Rights and trial by jury. 50 years ago, we had virtually no gun control laws, and the question I'd raise, after 50 years of enacting such laws, if they were a solution to this problem, wouldn't things be getting better and not worse? You know, Mexico has the most stringent gun control laws in the Western Hemisphere, and yet their murder rate is 4 times what it is in the United States. In 50 years, we've dramatically constrained the death penalty. We've released dangerous criminals back onto our streets through early release programs as well as sanctuary laws, and we've emptied our state mental hospitals. And at the same time, we've enacted a wide range of gun control laws, and things are getting worse. 50 years of practical experience. we've discovered that gun control laws are extremely effective at disarming law-abiding citizens. They are extremely ineffective at disarming criminals and madmen and terrorists. Now, if we're serious about confronting this crisis, we should set aside ideology and instead take a clear look at the public policies that actually worked to control this violence in the past and to protect all of our citizens from it. And until we're willing to do so, I believe things are going to continue to get worse. I yield back.
The question now occurs on, the amendment was withdrawn. Are there any further amendments?
Mr. Chairman,
Gentleman from Colorado.
I have an amendment at the desk.
Gentleman from Colorado has an amendment at the desk. The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 1236, offered by Mr. Buck of Colorado. On page 22, line 20, strike.
I reserve a point of order.
Gentlelady reserves a point of order. Without objection, the amendment will be considered as read. The gentleman is recognized to explain his amendment.
Thank you, Mr. Chairman. Mr. Chairman, I want to focus on one area of deep concern that affects active duty military personnel as well as millions of our nation's veterans. Sadly, this bill turns a deaf ear to the concerns that our service members and veterans have been raising for years. For many years now, the VA has used a patient flag system to identify veterans who the VA bureaucrats deem unsafe or a threat. These flags are then used against the veteran to delay or deny routine medical treatment. The VA allows a veteran to be flagged as a danger even in cases where the veteran expresses, quote, frustration about VA services and or wait times, end quote. We all know VA wait times are unacceptable. To flag a veteran as a danger for expressing frustration with the system is simply not fair. The VA's patient flag system is also ripe for abuse. More than 6 years ago, the VA Inspector General concluded the bureaucracy lacked, quote, comprehensive definition of what constitutes disruptive behavior, end of quote. The system is also not uniform, allowing VA facilities to adopt their own system without proper oversight. In January 2018, the VA Inspector General also expressed concern that the VA flag system was arbitrary. It was secretive in that veterans were unaware that they had been flagged, and it denied the veteran due process as it lacked any recourse to remove phony flag or file an appeal in any meaningful way. The IG also found that medical records for full 49% of all flagged veterans lacked any evidence that the veteran had been notified they had been flagged. One veteran was flagged out of retribution because he registered a complaint of elder abuse after a VA nurse openly mocked and laughed at a deaf veteran of World War II in the waiting room. Flags like this are all too common. They are used to punish veterans who speak out, including on behalf of their fellow veterans. I am concerned that the VA patient flag system, which lacks proper civil liberty protections, such as notice and a right to appeal, will somehow result in and influence extreme risk protection orders. We cannot allow that to happen. Another concern that I have is that the potential for a red flag under the current bill will deter veterans from seeking appropriate medical attention for service-related disabilities. This red flag bill has the potential to stigmatize veterans who might suffer from PTSD. Congress has done so much to encourage veterans to seek needed help. Will this red flag bill now use the veteran's medical records against the veteran? We can't allow that to happen. In addition, I'm concerned with the impact a red flag regime would have on active duty military personnel. Imagine a Marine who is about to deploy. She recently got divorced, and her ex-husband files a petition for an extreme risk protection order against her, not because she is truly a danger to anyone, but because she is using this process, which lacks common sense safeguards, to target his ex-wife. The kind of stress that a made-up petition would have will affect command readiness for our military. For this reason, I think red flag petitions involving active duty military personnel should be referred to DOD so they can be handled within the command authority. So here's what my amendment would do. First, it would require federal courts to refer extreme risk protection order petitions involving active duty personnel to DOD. Second, it makes sure that past military service, which naturally involves a history of using a firearm, cannot be considered as a risk factor to deprive a veteran of their Second Amendment rights. Third, it clarifies existing federal law to ensure that accessing VA benefits will not trigger a loss of Second Amendment rights. This approach is based on a bipartisan bill to protect veterans' rights. Fourth, it ensures that no veteran will lose their gun rights based on the fact that the veteran needs help in managing their affairs, such as VA benefits, or was flagged under the VA patient system that fails to include proper protections and safeguards. I believe that this amendment is common sense. It contains many bipartisan provisions, and I urge the committee to adopt the amendment. I yield back.
Mr. Chairman.
Gentleman yields back. Does the gentlelady insist on a point of order?
I do. The amendment is outside the jurisdiction of the Judiciary Committee, devises procedures that are within the jurisdiction of the Veterans Affairs Committee, not this one, and therefore is beyond the scope of our committee authority and is not germane.
Does the sponsor wish to reply to that?
Yes, thank you, Mr. Chairman. Mr. Chairman, this bill, my amendment, I'm sorry, specifically amends the bill in front of us. It doesn't ask another committee to take it up, number one. Number two, it talks about risk factors that are included in our bill, specifically page 22 of our bill, and makes sure that a veteran's use of a firearm previously is not considered a risk factor because that veteran was serving his country and had authority to use that weapon. So I want to make sure that we are protecting veterans, and it is, I believe, germane to the underlying bill that we're considering.
I'm prepared to, the chair is prepared to rule on the point of order. Chair rules the point of order is well taken. The bill is not, the amendment is not within the jurisdiction of the committee. Although it amends this bill, any amendment obviously would amend this bill, it requires actions to be taken by the Department of Veterans Affairs under Title 38, and we have no jurisdiction over Title 38, and we have no jurisdiction over the Department of Veterans Affairs. So we cannot adopt an amendment to a bill which requires various actions by the Department of Veterans Affairs. Consequently, the amendment is out of order, period. Are there any further amendments? Are there any further amendments?
Mr. Chairman.
Gentleman from Ohio.
Mr. Chairman, I have an amendment at the desk.
The gentleman from Ohio has an amendment on the desk. The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 1236.
Mr. Chairman, I ask that the amendment be considered as read.
I reserve a point of order.
The gentlelady reserves a point of order. Without objection, the amendment will be considered as read. The gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. On August 4th, we yet again experienced tragedy at the hands of evil or mentally unstable individuals. One of those massacres happened in El Paso, Texas, and the other, of course, happened in Dayton, Ohio, which is less than 30 miles from my congressional district. First and foremost, we should recognize these tragedies and pray for all the families in Dayton and El Paso and throughout the nation who have had a loved one killed at the hands of senseless murderers. Although I'm a firm advocate of Second Amendment rights, I also believe that firearms should not be in the hands of criminals or those with mental illnesses like those who took the lives of so many this past August. One way we can accomplish this is to ensure that the NICS system is accurate, up to date, and is properly checked to make sure that individuals who are in a database cannot obtain a firearm. In my home state of Ohio, they are working to accomplish just that. On the face of this legislation, it seems as if the majority is attempting to also make sure that individuals who shouldn't have a gun can't obtain one with their red flag law. However, it's not without its flaws. I was an attorney in Southwest Ohio, and I've served in this committee since I was elected to Congress 23 years ago. So I, like so many other colleagues sitting on both ends of this dais, understand the importance of due process. Unfortunately, this legislation, as drafted, fails to protect the due process of everyday, hardworking, law-abiding gun owners. This legislation is flawed because it provides federal grants to states to enact red flag laws that could deprive a person of a right to possess firearms before a hearing where the gun owner has notice and is given an opportunity to participate. As you all know, due process is fundamental to the very existence of our nation, and for this red flag law to have such a low evidentiary standard illustrates that Democrats don't seem to care much about the constitutional rights of American citizens. This bill, as written, only requires that state courts find by a preponderance of the evidence that an individual poses a danger to him or herself or others before taking their guns away. Their legislation also states that the order of protection can exist in perpetuity as ordered by one judge. And even then, it appears it can be done ex parte or without the knowledge or participation of the individual subject to that order. My amendment is simple and protects the due process rights of law-abiding citizens who want to exercise their Second Amendment rights. It ensures that the applicant must show with clear and convincing evidence that the respondent poses an imminent, particularized, and substantial risk of unlawfully using a firearm to cause death to him or herself or others. And if a state court should find that the respondent does, then it cannot issue an order for more than 21 days, during which time the respondent is evaluated to determine if he or she has a mental illness. Additionally, before an ex parte order can be obtained, the applicant must swear under oath, under penalty of perjury, that the respondent should not be in possession of a firearm. And should a court so find that the respondent should be prohibited from possessing a firearm, the order must be reviewed and renewed annually. My amendment goes a long way to ensure that the rights of Americans are protected, while at the same time helping to keep guns out of the hands of criminals and mentally unstable individuals. I urge my colleagues to adopt this common sense amendment to help make our communities safer, while at the same time allowing law-abiding Americans to continue to exercise their Second Amendment rights and without jeopardizing their due process rights. And with that, I yield back.
I will yield, the gentleman yields back. I will yield myself 5 minutes.
I withdraw my point of order.
I'm sorry. Gentlelady from California withdraws her point of order. I will yield myself 5 minutes in opposition to the amendment. The bill discusses behavior. We're here today to discuss behavior, not to stigmatize mental health disability. Specific behavioral indicators of dangerousness are far more reliable predictors of future violence than is mental illness, which is why extreme risk laws prevent access to firearms by persons exhibiting dangerous behavior regardless of diagnosis. Most people with serious mental illness, such as schizophrenia or bipolar disorder, are never violent toward others. Past violent behavior is the best predictor of future violence, regardless of a diagnosis of mental illness. Other risk factors include threats of violence, alcohol or substance associated with dangerous behavior, and reckless firearm behavior, which is why ERPOs are issued based on these factors. While mental illness such as depression does increase the risk of suicide, not all individuals with a mental health diagnosis will become suicidal. The following are risk factors for suicide and are included in the ERPO legislation: prior suicide attempts, threats of suicide, risky alcohol or substance abuse, and recent acquisition of firearms. These are the behaviors that must underlie any ERPO issued. And to substitute mental illness criteria for behavioral criteria is simply the wrong direction, is not borne out by experience or by evidence, and would greatly lessen, would stigmatize mental illness generally, but would also greatly lessen the effectiveness in preventing firearms violence of the bill. Accordingly, I urge defeat of this amendment. Who seeks recognition?
Mr. Chairman.
Gentleman from Colorado. Mr. Neguse.
Thank you, Mr. Chair. I agree with the chairman. I certainly oppose this amendment. I believe the amendment undermines and ultimately weakens the underlying bill. But I again want to go back to the core of why we're here and why we ought to work together to pass this important proposal. There's a gentleman in my state of Colorado by the name of Tom Sullivan. Tom Sullivan is a state representative who represents his district honorably in Colorado. He also happens to be someone whose family has been directly impacted by gun violence. In 2012, on July 20th, Tom lost his son, Alex, in the Aurora theater shooting. Alex turned 27 that evening, and Tom and his wife lost him forever. I know that I can't begin to fathom, to describe the agony that they have experienced as a family at the loss of Alex. But they, like our colleague, Representative Macbeth, who continues to inspire so many of us, they turned that sorrow and that anguish into action. And Tom, over the course of the last 7 years, has become a champion for gun violence prevention. He was elected, as I said, to the state legislature, and earlier this year in Colorado, he succeeded, thanks to his leadership, working with our governor and the state legislature in enacting a red flag law that is very similar to the law that we are debating tonight. As a country, as a people, and as a Congress, I believe we have to take action for Tom's family and for the families of countless others who have been so tragically impacted by gun violence. And I know that my colleagues on the side of the aisle earlier throughout this debate have referenced this notion that we need to pursue bipartisan solutions. It bears mentioning that there are 2 Republican co-sponsors on this bill. It bears mentioning that in Colorado, in a poll that was conducted this summer, 60% of Republicans support red flag laws. So if my colleagues are serious about addressing gun violence, about addressing suicide, Colorado happens to have the 10th highest rate of suicides in the United States. 50% of those involve a firearm. If my colleagues are serious about that, I would hope that they would join us tonight in supporting this bill so that we can finally do something about the pervasive gun violence that is ravaging communities across our country. And with that, I yield back the balance of my time.
Who seeks recognition? Okay, the gentlelady from Georgia is, I'm sorry, for what purpose does the gentlelady from Georgia seek recognition?
Thank you, Madam Chair. I move to strike the last word.
Recognized for 5 minutes.
Thank you very much. I'd like to address amendments that add mental health as a factor to consider when determining whether to issue an ERPO. I understand the desire to address mental health. That is the reason why I sit on the Mental Health Caucus. And as a member of the Mental Health Caucus, it's very important to me that extreme risk laws continue to be a vital tool in helping people that are in crisis, including but not limited to those that are subject to having a mental illness. However, adding mental health as a factor could actually do more harm than it will do good. It could stigmatize mental health. It could even prevent people from getting the treatment that they need for fear that it could affect their own ability to own a gun. The truth is that most people with mental illness are never violent towards others. In fact, they are more likely to be victims of violence themselves. According to a 2015 study in the Annals of Epidemiology, only 4% of violent acts in the United States are attributable to mental illness. Rather than stigmatizing mental illness, we need to focus on evidence-based risk factors for violence. And those are the factors already included in this bill for a judge to consider when issuing an extreme risk protective order. And these include recent threats, recent violent acts, reckless use of a firearm, and substance abuse. When the Senate Judiciary Committee had their hearing on extreme risk laws earlier this year, Chairman Graham invited Ron Hohenberg of the National Alliance on Mental Health, Mental Illness. And Mr. Hohenberg testified that extreme risk laws should be based on individualized assessments rather than stereotypical assumptions about specific groups of people that are not grounded in evidence. And I really couldn't agree more. I urge my Republican colleagues to listen to the witness invited to testify by Senator Graham and reject these efforts to stigmatize those with mental illness. We must take an evidence-based approach to keeping people safe and look at genuine indications of violence. For that reason, I oppose this amendment. I yield back the balance of my time.
For what purpose does the gentleman from Rhode Island seek recognition?
I move to strike the last word, Madam Chair.
The gentleman is recognized for 5 minutes.
Thank you, Madam Chair, and I rise in opposition to the amendment. And I want to just make a couple of points. Number one, there's been a lot of discussion this afternoon, this evening, about the absence of due process and the fact that there is a constitutional right at issue here, the Second Amendment being somehow infringed upon. And I want to associate myself with the distinguished gentleman from Maryland who reminds us in the Heller decision, the United States Supreme Court acknowledged the right of the government, both the state and federal governments, to impose reasonable restrictions. That this isn't a limitless right to possess firearms of any kind, anytime, any place you want. And in fact, the legislation that is before us includes important due process protections. On page 7 is a notice and due process section which says the individual named in an application for an extreme risk protection order as described in subparagraph A shall be given written notice of the application and an opportunity to be heard on the matter in accordance with this section. That is classic due process. Notice and an opportunity to be heard. Second point I want to make is that with respect to the ex parte order, the standard of proof in that is probable cause. This is at page 16. A court may issue an ex parte order only upon a finding of probable cause to believe. And so what this legislation is designed to do is when an individual, a family member, finds out or discovers that someone is about to have access to a firearm that is somehow reflecting some danger to themselves or the community. Think of an example, hearing that someone's gonna take a gun and go shoot up a school. Right now, there's no mechanism to stop that from happening. There's no mechanism to go to a court and say, this person is a danger to themselves and others, is going to do something that is going to result in the terrible loss of life. That's exactly what this bill provides, is a vehicle to do that in a really responsible way with notice, with an opportunity to be heard, with a higher standard of probable cause in an ex parte proceeding. And while there's a lot of discussion about the Second Amendment and the constitutional right, let me remind my friends on the other side of the aisle, there's a constitutional right to life, liberty, and the pursuit of happiness. My constituents have the constitutional right to take a walk in the park with their grandchildren, be protected from gun violence. They have a constitutional right to worship in a synagogue or a church and be free from being gunned down. Those are also important liberties and freedoms that we have a responsibility to protect. And I think on balance, this bill does exactly the right thing. It protects those freedoms and those liberties with reasonable procedures to protect people from someone who has exhibited an intention to hurt themselves or others by use of a firearm. We have got to do something. The American people are sick and tired of seeing news accounts and seeing people in their own communities that have been ravaged by gun violence. And by the way, we should remember that the magnitude of gun violence in America is staggering. On average, 136,000 Americans are shot each year, totaling more than 1 million in the last decade. Over the last few years, our country has lived through the deadliest mass shootings in modern American history. And as the chairman said, Americans are 25 times more likely to be killed in a gun homicide than residents of other high-income countries. 25 times more likely. We have a responsibility to do something about that. We ought to look at the example of New Zealand. It took one mass shooting fueled by hate before action was taken, and yet we've had more than 293 mass shootings this year alone, more shootings than there have been days in the year, and we continue to say never again, but tragic and preventable shootings have become the new normal. We have a responsibility to do something. We're not going to pass legislation that's going to eliminate gun violence in its entirety, but we can pass a series of bills when taken together, can significantly reduce gun violence in this country and protect our constituents from the violence and the horror and the loss of what occurs during these kinds of gun massacres. And so I urge my colleagues to support this.
Gentleman yield.
I'm happy to.
Thank you. I get your passion for this. You're going to vote for it. We're not, and I'm not even going to take up the fact that we believe in constitutional right to life on a lot of different subjects, so we're not going to go there. But I do have a point to make about your discussion of standards. That is not, the standard you stated is not the standard for the entire bill. The standard is found in the federal standard, not the state grant program. The state grant program is still, it says on page 9, line 3, the court finds there is reasonable cause to believe or makes a finding under a higher standard. So it's not all protected under a probable cause standard. I understand the gentleman's passion. I understand what he wants, but it needs to be at least pointed out that
just real quick, the ex parte provision is the provision that has the probable cause standard, which makes sense because if someone doesn't have a right to be heard and it's done ex parte, it makes sense that you heighten the standard to probable cause, which is.
And we're not allowed, but it's part of the. I yield back.
That I yield back, Madam Chair.
The gentleman's time has expired. The question is on the amendment. Those in favor say aye. Those opposed, no.
No.
In the opinion of the chair, the nays have it, and the amendment is not agreed to. A roll call is requested. Clerk will take, no roll call? Thank you. Are there any further amendments to the amendment?
Madam Chair,
Yes.
move to strike the last word.
Gentleman is recognized for 5 minutes.
Thank you, Madam Chairman. I want to thank Congressman Carbajal for his tireless work on this issue. I especially want to thank Congresswoman McBath for her leadership, for her passion, for being a role model for all of us in how to approach this issue. And I want to acknowledge my friend Congresswoman Brooks, Congressman Upton, and Congresswoman Dingell for their help on the Jake Laird Act. After February 14th, it's important to remember that the Florida legislature, in fact, did pass bills to increase both to increase the minimum wage for rifle purchases to 21 and passed an extreme risk protection order law. And in the 2 months after that law passed, Mr. Gates acknowledges, guns were removed from roughly 50 dangerous situations, including 34 times in Broward County. And those laws include robust due process protections, and they truly save lives. There's evidence. We've seen it. We know that it works. This should be the law all around the country. Tragic violent shootings continue to happen all across our nation, and data at the federal level shows that active shooter incidents are on the rise, with many shooters showing signs of mental illness and nearly a quarter of the incidents occurring at schools. We're continuing to grapple with how to combat these incidents. Local law enforcement remains on the front lines every day of this fight and is often responsible for halting the actions of these dangerous individuals. It's critical that they have the tools to do that. That's all we're trying to do. I don't understand why this is so complicated. Contrary to conventional wisdom, gun violence is rarely random. It's rarely random. If we recognize warning signs and police have the tools to take action, we can save lives. According to Sandy Hook Promise, most mass shootings are planned for 6 months to a year. In each case they examined, there were warning signs that were ignored. In Florida, police have long had the authority to detain people who are a danger to themselves or others for mental health evaluations, but no authority to take weapons out of dangerous hands until they pass the Extreme Risk Protection Order law after Parkland. It's time for the federal government to step up and help give every jurisdiction the tools needed to intervene and save lives. Congress, we've had this discussion over and over again. Congress has shamefully failed to respond to gun violence, not only in schools and churches and nightclubs and concert venues, but in response to the loss of brave law enforcement officers, those who put their badges, run toward danger, ignore the risk that they won't return home after their shift. Now's the time for the federal government to help states implement red flag laws around the country. And I just want to finish with a reference to a conversation that we had earlier today when we heard from Vic Bencomo, 22-year Navy veteran, gun owner, member of Colorado Gun Owners for Safety, who testified about the number of times that as a veteran, he's had to come to the aid of other veterans who considered suicide. We shouldn't leave it up to other veterans to be there to help save the lives of those who served our country. If we know that a veteran is considering taking his own life, if we know anyone is considering taking his or her own life, then let's make sure that the tools exist to help save that life. That's all we're talking about. And again, we're not going to stop. Yeah, it's true. It's true. Criminals are going to get their hands on guns. It's true. There are lots of arguments that we can make against this and every effort to address gun violence by saying this isn't going to stop all gun violence. There's still going to be gun violence, and that is 100% right. But if we can take this action tonight and move this bill forward, and it saves one life, and that's a life of someone that you know and love, then everyone on this committee knows that it's the right thing to do, and I urge my colleagues to support this bill.
Gentleman yields. Are there any further amendments? Gentleman from Maryland.
Move to strike the last word.
Is recognized.
Mr. Chairman, I also want to just add a word of praise for our colleague, Lucy McBath, who has channeled in unthinkable, unspeakable anguish and pain in her life into active citizenship and leadership. And I'm Not sure how many people could actually accomplish that miraculous recovery and transformation. And I want to praise her for what she's doing for us in Congress and for all of the people of America. I also want to salute 300 of my constituents who are assembled tonight in downtown Silver Spring in support of this package of gun safety legislation and standing strong for the views held by the vast majority of the American people that we can make effective, positive changes in our gun laws. And I also want to associate myself with the recent statements of Mr. Deutsch and Mr. Cicilline, which I found very powerful and very eloquent. I support this legislation strongly, Mr. Chairman, because something happened a few weeks ago in Maryland where a man was muttering threats about killing people and how mad he was. And we've got a red flag law in Maryland. His name was Mark Edward Rutkowski, 54 years old. The provisions of the red flag law were activated. The police went to his home with an extreme risk protection order, and they found 146 firearms, an arsenal of handguns, rifles, shotguns, and assault-style weapons belonging to him and his father, and he was charged with one count of making a threat of mass violence and could serve up to 10 years. Now, who knows where that one would have led? It could have led to the kind of massacre that we saw at the Annapolis Gazette. And one of my constituents tonight is at the rally. She lost her husband in the Annapolis Gazette massacre. So from El Paso to Dayton to Newtown, Connecticut, to the Pulse nightclub shooting, all over America now, millions and millions of lives are affected and touched by this reign of gun terror. And we see a political pattern in the wake of these events. The president immediately says, seeing the convulsions in public opinion, well, we're going to have to do a universal background check. And then, as each day goes by, he's lobbied by the National Rifle Association. He's moved by, I suppose, some of our colleagues across the aisle, and he begins to back away and say, well, I don't know, maybe everything's okay. Maybe there's really nothing that can be done. Maybe we should just denounce evil. Let's just denounce evil. Let's denounce immorality. There's a solution for you. In the world's oldest, greatest modern democracy, let's denounce evil. There's a good solution. Mr. Chairman, let's go back to the Constitution. The Constitution was written for the people. It was written to protect our rights and our freedoms, and yes, including the right to keep and bear arms, by which the Supreme Court has interpreted to mean the right to a handgun to defend yourself, the right to a rifle in order to engage in recreational activity and hunting. Not a right to have weapons of war, not a right to obtain any of this without a background check, not the right Justice Scalia tells us to go into a courtroom with guns or go into a public school with guns or go into any public place with a gun where the community has decided you shouldn't go. That's Justice Scalia talking. That's the conservatives in the court, the 5-justice majority. The 4 liberals, of course, thought that they read the Second Amendment to believe that gun possession should be tethered to service in the militia, in the National Guard. That was not the reading the majority gave it, but the majority still said ample room for regulation. Just like in the First Amendment, you got a right to speak. You don't have a right to pick up a microphone or a megaphone at 2 o'clock in the morning in front of the White House and keep the president's family up and make a ruckus. In fact, when you support reasonable time, place, and manner regulations of the First Amendment, you enhance freedom of speech so that everybody can speak and we can make speech harmonious with everything else. And that's the same thing with the Second Amendment. And yet we get this absurd rhetoric that when you have reasonable common sense gun safety regulation to keep people from getting guns who shouldn't have them, like felons and fugitives and unstable people, that somehow we're violating the Second Amendment. Let's get together across party lines. This is for the American people. The reason we have a social contract in the Constitution is because the people should be safer within the Constitution, within the rule of law, than they are in the state of nature. I yield back.
The gentleman yields back. The question, what purpose does the gentleman from Florida seek recognition?
Strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman. During my colleague from California's presidential campaign, he and I didn't agree on too many issues, but there was a sentiment expressed that is generational in nature, and that is ours is the first generation that has lived with these mass shootings throughout our time in school. And then now, as young people are having to endure yet another generation of school shootings, and regardless of which solution set you adopt, it is a fact that younger Americans have these mass shootings as a part of their psychological and American experience, and it is just deeply sad. And so I still think there's plenty of room to denounce evil. I still think there's plenty of room for our states to enact red flag laws. And I have some caution based on the comments of my good friend from Florida, Mr. Deutsch. You know, the bill from Florida that he references is one I helped write. And my colleague from Florida, Mr. Deutsch, can ask his own constituent, a Democrat, former State Representative Jared Moskowitz. I helped write those red flag provisions because I believe strongly that our state could do better. But when my colleague talks about veterans and their firearms and their access to firearms, I can assure you that if laws like this were in place in the absence of due process, and I think we should probably do a lot more there, that veterans might be less willing to share their trauma, share their mental health frailties out of fear that it would divorce them from their firearms. And it's just a population I care a lot about because I represent, I think, more veterans than any member of the committee and most other members of Congress. And we would never want to live in a world where people are less likely to seek the mental health care that they need and that we would all want them to seek out of fear that it might deprive them of their rights. So none of these are easy issues. I think that there's definitely room here for legislation that would accommodate the concerns of Republicans and Democrats. Sadly, this isn't that bill. I continue to be encouraged by the work of Senator Graham, and his approach seems to be more closely aligned with legislation that had been previously introduced in a bipartisan fashion by Senators Nelson and Senator Rubio following the tragic events in the state of Florida. And so I hope that's ultimately the work product we end up with. If we get work product like that, I would be inclined to support it, but the legislation that's before the committee now seems to go further. I'll yield to my friend from Florida.
Yeah, thank you. I thank my friend, and I just want to use the opportunity not to talk about this legislation. I want to use the opportunity to talk about veterans and anyone else in mental distress. It is Suicide Prevention Month. Today is World Suicide Prevention Day, I believe. And I want to just reiterate the importance of having difficult conversations about mental health. Asking someone that you care about if they're thinking about suicide will not hurt them, but it could save their life. I would encourage anyone listening today to reach out if they need help. The Suicide Prevention Lifeline is 1-800-273-TALK. There is great agreement among every member in this committee that we need to do what we can to ensure that people have access to help. That's one thing that there is no doubt on. I wanted to take the opportunity just to do that. I thank my friend Florida and Ms. McBath.
I'm going to reclaim my time, and I appreciate the gentleman's recognition that these are not binary issues, that there is a point at which if you create barriers to people seeking mental health, that could limit the ultimate success that they could have in their treatment. I think about our colleague, the gentleman from Massachusetts, Seth Moulton, who bravely, courageously, during his presidential campaign, stepped forward and said that he himself had dealt with trauma as a consequence from his service. I don't think anyone here would want to go red flag Congressman Moulton, for having made those admissions. I think that you would want people that would have those challenges to show the same bravery and the same positive action that he showed, and we wouldn't want to create a deterrent to that. I appreciate my colleagues.
Will the gentleman yield?
I will.
Can we all agree that there are just too many members of Congress running for president?
Hey, wait till 2024. I yield back.
Gentleman yields back. The question is on the amendment. Those in Gentlelady from Pennsylvania.
I move to strike the last word.
Gentlelady from Pennsylvania.
I did just want to note that we lose 20 veterans to suicide every day, and that one of the big purposes of this law is to address the issues of folks who are using guns to commit suicide, that's 60% of the gun violence in this country. and that this is a healthy step towards trying to address those issues. With that, I would yield to the gentlewoman from Texas.
I thank the gentlewoman from Pennsylvania, and I want to associate myself with your words. And Congressman Deutsch, I want to associate myself with your words about suicide. And I think it's important to note in a earlier hearing that we had today, a veteran himself acknowledged the fact that he would want to take away guns from a veteran who was contemplating suicide. So veterans themselves understand to save veterans' lives, they would want to have the construct to be able to do that. I indicated a gun violence prevention summit that we held in Houston. In that hearing of individuals' presentations without respect to party, the issue that they raised was the issue of dealing with the displaying of warning signs, the very crux of this bill. In 51% of mass shootings from 2009 to 2017, the attacker exhibited warning signs before the shooting. For example, before killing 6 people in Isla Vista, California, in May 2014, the shooter made homicidal and suicidal threats, and his parents alerted law enforcement, but there was nothing they could legally do to remove the firearms before the California changed its law. The U.S. Secret Service and the U.S. Department of Education studied targeted school violence incidents and found behavior warning signs that caused others to be concerned in 93% of the cases. They also found that in 81% of incidences, other people, most often peers, had some type of knowledge about the shooter's plans. In Parkland, where 17 people were killed, it was noted that this student had been expelled from school, and students and teachers reported he displayed threatening behavior. His mother had repeatedly contacted law enforcement. In domestic violence cases, before there is a conviction, family members are without any structure to, in fact, talk about the behavior of that loved one that is in the household that is threatening the family members and the children. And so this legislation is long overdue federally. And I want to acknowledge the individuals who came to this conclusion last week. Dr. Joan Shook with the Texas Children's Hospital, Dr. Dwayne Wolf, Deputy Chief Medical Examiner in Harris County, Sergeant Jeffrey McGowan, Harris County Sheriff's Department, Chief Troy Finner, who is the Executive Chief of the Houston Police Department, Joan Shook, Umar Shah, Executive Director of the Harris County Public Health, Kim Ogg, District Attorney for Harris County, Dr. Howard Henderson, who is a Professor of Administration of Justice at Texas Southern University, Professor Ronald Turner, A.A. White, Professor of Law, University of Houston, Matthew Simpson, Deputy Political Director, ACLU, Sonia Corrales, Chief Program Officer, Houston Area Women's Center, which confirms the need for this kind of law as it relates to domestic violence, and Sonia Ayaya Stewart, who lost her 2 brothers, the founder of I Am Foundation, Rhonda Hart, who lost a daughter at Santa Fe, and Ariel Hobbs, who we heard from today, who said that many of her friends, she has them now because of death. She represents March for Our Lives, and Elizabeth Hanks, Moms Demands Action. They conceded to the point that this legislation of extreme risk orders was important to save lives, and I believe this is what we need to do on the federal level, not just state by state. With that, I yield back my time.
Gentlelady yields back. The question occurs on the amendment. Those in favor say aye.
North Dakota.
Mr. Chairman, thanks. Move to strike the last word. And this is, we've heard it all. Anybody who knows me thinks we've voted on a red flag law in the North Dakota legislature. We voted it down summarily. We are now putting a federal system in place that'll be in effect in North Dakota the same as it is also. And we're also setting up a situation where we incentivize states to do this. So I think we know how this is going. I'm hopeful that there is more common sense across the chamber than there is here, but that is not necessarily the case. So here's what I'm actually imploring my friends on the other side to do. And this is important because there's two completely different standards in this bill depending on where you're at. In the ex parte motion for the state grant program, it's reasonable cause. We call that reasonable suspicion in North Dakota. In the ex parte version in the federal one, there's probable cause. In the state one, it's until a hearing is scheduled or 30 days. I'm not sure, I'm having a difficult time reading it. In the federal one, it's 14 days. In the state one, it's preponderance of the evidence. In the federal one, it's clear and convincing evidence. The duration in the state one can be indefinite. The duration in the federal one is 180 days and must actively seek an extension. Most importantly, in the federal one, you're requiring court-appointed counsel. But we don't require that in any state court. And in fact, in the states that do have red flag laws, court-appointed counsel is the exception and not the rule. So we are setting up a system, one, where you're forcing the citizens of North Dakota to have this law in federal court when they have summarily rejected it in the state legislature, which happened in the last legislative session. Secondly, you're incentivizing states to put their own policy in place. And thirdly, in states that already have it, you are going to have two completely different evidentiary standards in hearings, depending on when you're in federal court or in state court. And if you don't think that's going to cause a significant amount of problems when you are actually on the ground practicing criminal or civil work in these jurisdictions, you're nuts. It's going to be a problem. You have competing interests. This is before we get into whether the federal government should actively be engaged in this. By the rationale in which we allow the federal government to do that, any crime involving a gun should rise to the federal level as opposed to having state level assaults, murder, domestic violence, all of the things which we ask our states to do. So as you continue to move forward this, you are going to have another opportunity, and I implore my friends on the other side, if the federal one, as bad as it is significantly better and offers more protections to people than we are allowing states to implement on their own. So if this is good enough for this body to say we should do it, at the very least, give somebody a court-appointed counsel and require states that already have red flag laws then to require court-appointed counsel at the state level. We have this, the due process protections on the federal side of this are better than the state side. That does not mean I think they're good. But more importantly, this kind of inconsistency, when you are applying it in the criminal justice system, as it works on the ground with lawyers and prosecutors and cops and judges and all of the people who are involved in this, is incredibly problematic. It's inconsistent. And outside of the issue of guns and how politically polarizing it is, this is not good policy. And with that, I yield back.
Spoken on this. Thank you, Mr. Chairman. I felt the need to respond. Earlier in debates, my friend, Congressman Rasky, had espoused, basically making fun of my position that generations have been punished for the sins of their predecessors, and he couldn't conceive of any type of punishment other than prison. He couldn't conceive that people could be punished by paying tremendous amounts of money, and then yet just now, I let that go. The comment basically that we're not going to do any good by just declaring against immorality. There is nothing this committee can do in the way of declarations that can change the status of the immorality in this country by declaring tonight, but it would help if people in Congress, including this committee, would not jump to conclusions too soon and condemn law enforcement before they find out the law enforcement officer was acting in self-defense and further dividing the country. We had a president that kept choosing, before the evidence was in, to go against law enforcement. And, you know, it's Natan Sharansky that spent 12 years in a Soviet gulag for promoting freedom of speech. He said, and this was basically echoed in a way by Oprah Winfrey when she said, you know, we've lost our moral center, used to be provided by churches. Sharansky said a lack of moral clarity is why people living in free societies cannot distinguish between religious fundamentalists in a democratic state and religious terrorists in a fundamentalist state. In this new Orwellian world, the arsonist and the firefighter are deemed morally equivalent. What we can push, we can't effectuate what needs to be done tonight, but we can resolve that we are going to encourage the teaching of right and wrong. And we're not going to use politics to promote jealousy. And you didn't build that. It belongs to all of us. But we're going to promote, as Sharansky talks about, this idea that it is important to protect a free society. And we have not done a good job of that. It's all relative. If it feels right for you, okay. Maybe if it doesn't feel right for somebody else, it's not. This relativity has encouraged people to wonder, would it feel good to kill people? And then they go out and kill people. We need to be promoting a morality among ourselves and among this body and encouraging schools. There's nothing wrong with speaking and teaching against jealousy and against killing instead of just ignoring those and teaching relativity instead. Oprah Winfrey is right. We have lost our moral center. We can't fix that tonight, but until that is fixed, we are going to keep having to take away more and more and more constitutional rights. Why? Because we need to be safe. And it was attributed to Franklin, some question whether he said it or not, those who would give up their liberty for safety deserve neither. But it is important to understand before we start giving up these liberties, these things that are in the Constitution, continue to give them up and continue to have the Supreme Court say, you know what, we're going to have to cut back on the rights that this constitutional provision allows because people want to be safe. We've seen it for decades now, and the point is, Oprah Winfrey was right. We've lost our moral center, and we ought to be promoting that, or we're going to be spending many, many hours debating the taking away of what used to be American rights. I yield back.
Gentleman yields back. The question finally occurs on the amendment. No. Okay. There are no further pending amendments, so the question occurs on the amendment in the nature of a substitute. This will be followed immediately by a vote on final passage of the bill. I understand there will be a roll call vote on each of them. So all those in favor of the amendment in the nature of a substitute, say aye. Aye. Opposed, no. The ayes have it. The amendment in the nature of a substitute is adopted. No, they're not calling roll call. A reporting quorum being present, the question is on the motion to report the bill H.R. 1236 as amended favorably to the House. Those in favor will respond by saying aye. Aye. Those opposed, no. No. And the ayes have it, and the bill is ordered reported favorably. Recorded vote has been requested. The clerk will call the roll.
Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Aye. Ms. Lofgren votes aye. Ms. Jackson Lee? Aye. Ms. Jackson Lee votes aye. Mr. Cohen? Mr. Johnson of Georgia? Mr. Deutsch? Mr. Deutsch votes aye. Ms. Bass? Ms. Bass votes aye. Mr. Richmond? Mr. Jeffries? Mr. Jeffries votes aye. Mr. Cicilline? Mr. Cicilline votes aye. Mr. Swalwell? Mr. Swalwell votes aye. Mr. Liu? Mr. Liu votes aye. Mr. Raskin? Mr. Raskin votes aye. Ms. Jayapal? Ms. Jayapal votes aye. Ms. Demmings? Ms. Demmings votes aye. Mr. Correa? Mr. Correa votes aye. Ms. Scanlon? Ms. Scanlon votes aye. Ms. Garcia?
Aye.
Ms. Garcia votes aye. Mr. Neguse?
Aye.
Mr. Neguse votes aye. Ms. McBath? Ms. McBath votes aye. Mr. Stanton?
Aye.
Mr. Stanton votes aye. Ms. Steen?
Aye.
Ms. Steen votes aye. Ms. McCarcel-Powell?
Aye.
Ms. McCarcel-Powell votes aye. Ms. Escobar?
Aye.
Ms. Escobar votes aye. Mr. Collins? Mr. Collins votes no. Mr. Sensenbrenner? Mr. Shabbat? Mr. Shabbat votes no. Mr. Gomert? Mr. Gomert votes no. Mr. Jordan? Mr. Jordan votes no. Mr. Buck? Mr. Buck votes no. Mr. Ratcliffe? Mr. Ratcliffe votes no. Ms. Roby? Ms. Roby votes no. Mr. Gates? Mr. Gates votes no. Mr. Johnson, Louisiana? Mr. Johnson of Louisiana votes no. Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. McClintock votes no. Ms. Lesko? Ms. Lesko votes no. Mr. Reschenthaler? Mr. Reschenthaler votes no. Mr. Klein? Mr. Klein votes no. Mr. Armstrong? Mr. Armstrong votes no. Mr. Stubbe? Mr. Stubbe votes no.
The gentleman from Tennessee? Gentleman,
Mr. Cohen votes aye.
are there any members who haven't, who wish to vote who haven't voted yet? Clerk will report.
Mr. Chairman, there are 22 ayes and 16 noes.
The ayes have it. The bill as amended is ordered reported favorably to the House. Members will have 2 days to submit views. The bill will be reported as a single amendment in the nature of a substitute, incorporating all adopted amendments, and without objection, staff is authorized to make technical and conforming changes. Can someone throw this out? Pursuant to notice, I now call, now we have 3 more bills to do in this markup. 2 more gun bill, 4 more bills. 4, and two less controversial bills. I hope to do at least one of the gun bills tonight. And I hope that everyone doesn't feel necessary to speak on every single amendment so we can finish at a relatively reasonable hour. Pursuant to notice, I now call up H.R. 1186, the Keep Americans Safe Act for purposes of markup, and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 1186, to regulate large-capacity ammunition feeding devices.
Without objection, the bill is considered as read and open for amendment at any point. I will begin by recognizing myself for an opening statement. H.R. 1186, the Keep Americans Safe Act, introduced by our colleague, the gentleman from Florida, Mr. Deutsch, would prohibit importing, selling, manufacturing, transferring, or possessing large-capacity magazines that can hold more than 10 rounds of ammunition. Time and time again over the last decade, we have seen large-capacity magazines used in horrible mass shootings. These tragedies have been magnified in their destructiveness because of the use of large-capacity magazines. A review of the record is sobering. For example, the screen depicts a 100-round dual-drum rifle magazine similar to the one used 7 years ago by the Aurora movie theater shooter with an AR-15 assault rifle. Last month, the shooter in Dayton on August 4th used a 100-round drum magazine to kill 9 people and injure 27 others in just 30 seconds. And days before that attack, the shooter who killed 4 people and injured 13 others at the Garlic Festival in Gilroy, California, used a 75-round drum magazine in addition to 40-round magazines. The next screenshot shows the type of 30-round magazine used to kill 20 children and 6 adults in 2012 at Sandy Hook Elementary School in Newtown, Connecticut. Many of the 6- and 7-year-old victims were from the first grade classrooms near the front of the school. All but 2 of the victims were shot multiple times. Before turning the weapon on himself, the shooter at the Pulse nightclub in Orlando, Florida, used the same type of magazine, in addition to a pistol with a 17-round magazine, to kill 49 people 3 years ago. The man who on November 5, 2017, fatally shot 26 people and wounded 20 others at the First Baptist Church in Sutherland Springs, Texas, used a nearly identical magazine. This photo shows a device similar to the 33-round magazine used by the gunman in Tucson, Arizona, who seriously wounded and almost killed Representative Gabrielle Giffords in a supermarket parking lot in 2011. The gunman used a handgun equipped with a 33-round magazine that enabled him to kill 6 people, including Chief Judge John Roll of the U.S. District Court of Arizona, and to injure 13 others. The shooter's spree was only interrupted when he was tackled by a bystander as he temporarily stopped shooting to remove the magazine and attach a new one to his weapon when the first magazine finally ran out of ammunition. Studies have shown what is plainly obvious to the vast majority of the American people. Large capacity magazines make it easier to kill more people, and they serve virtually no other function. One analysis of mass casualty shootings between 1982 and 2012 found that large capacity ammunition magazines were recovered in over half of these incidents. And on average, their use caused twice as many fatalities and 14 times as many injuries. Without question, it is long overdue to ban these instruments of death. Congress has considered and enacted similar legislation before. In 1994, Congress banned the possession or transfer of magazines capable of holding more than 10 rounds of ammunition. Just as the bill before us today does, those who possessed magazines on or before the date of enactment that exceeded 10 rounds were grandfathered in, and they could continue to possess the banned magazines. The 1994 prohibition was extremely successful, but it had a deadly flaw. It contained a sunset provision, and in 2004, the federal ban expired. Since the expiration of this law in 2004, the use of high-capacity magazines in crime guns has grown substantially, with tragic results. For example, in Virginia, when the federal ban was in effect, there was a significant reduction in the share of crime guns equipped with high-capacity magazines, down to an all-time low of 10% before the law expired in 2004. But by 2010, the share of Virginia crime guns equipped with high-capacity magazines had more than doubled to 22%. 9 states and the District of Columbia regulate high-capacity magazines. States with these laws experience mass shootings at less than half the rate of states without restrictions. And according to a Boston University researcher, whether a state has a large-capacity ammunition magazine ban is the single best predictor of the mass shooting rates in that state. The evidence is clear that it is time that we finally reestablish a ban on these deadly devices, and the American people strongly agree. One recent poll shows 70% of Americans support a ban on large-capacity magazines, which underscores the obvious. We must reasonably limit the tool favored by mass casualty shooters. The memory of their innocent victims and the critical need to prevent further mass shootings is what brings us here today. Today, we take an important step to limit future carnage by passing a 10-round magazine limit. I thank Mr. Deutsch for championing this effort and for introducing this very significant bill, and I urge all of my colleagues to support it. I now recognize the ranking member of the Judiciary Committee, the gentleman from Georgia, Mr. Collins, for his opening statement.
Thank you, Mr. Chairman. We're now on to our second bill of the night. We're considering a bill that, despite its name, will do nothing to make Americans safe. You don't have to take my word for it. Instead, let's consider some published studies that examine the issue. We all know that in 1994, a 10-year federal ban on commonly owned semi-automatic firearms and magazines capable of holding more than 10 rounds of ammunition was enacted as part of the Violent Crime Control and Law Enforcement Act of 1994. While that ban was in place, a 1997 Department of Justice funded study of the ban determined that at best the assault rifle ban can only have a limited effect on total gun murders because the banned weapons and magazines were never involved in more than a modest fraction of all gun murderers. A comprehensive study by the Centers for Disease Control, CDC, in 2003 looked at 51 studies covering a full array of gun control measures, including the assault weapons ban magazine capacity limitation, and was unable to show that the limitation had reduced crime. The following year, a 2004 U.S. Department of Justice funded follow-up study of the 1994 assault weapon ban determined that should it be renewed, the ban's effect on gun violence are likely to be small at best and perhaps too small for reliable measurement. Following the 2007 shooting at Virginia Tech, Governor Tim Kaine convened a panel to discuss and study the atrocity. The shooter used several magazines that had capacities of greater than 10 rounds. The report stated that the panel considered whether the previous Federal Assault Weapons Act of 1994 that banned 15-round magazines would have made a difference in the April 16th instance. The law lapsed after 10 years, and in October 2004, the ban had banned clips or magazines with over 10 rounds. The report concluded that the 10-round magazines that were legal would have not made much of a difference in each of these incidents. Even pistols with rapid loaders could have been about as deadly in this situation. If you want to disagree with the CDC, the DOJ, the Virginia Tech findings, I can point to you a 2018 RAND Corporation comprehensive study surveyed the available research on several gun policies. RAND sought to determine how bans on the sale of assault weapons and high-capacity magazines affect gun outcomes. The study concluded, we found no qualifying studies showing that the bans on the sale of assault weapons and the high-capacity magazines decreased any of the 8 outcomes we investigated. The magazines that this bill would prohibit are common with most semi-automatic rifles and pistols. Law-abiding Americans own and use millions of these magazines safely and responsibly. There are already roughly 130 million detachable magazines. More than 30 million of these can accommodate more than 30 rounds. Many of them are not aftermarket items because manufacturers often provide magazines that will hold 15 to 30 rounds of ammunition as standard equipment for handguns and rifles. The data simply does not support enacting this measure if the goal is to save lives. H.R. 1186 is not a reasonable limit on magazine capacity. It's an arbitrary limit on Americans' right to self-defense that will only ensure criminals possess these items and will use them to victimize law-abiding citizens. One of the things to realize, and if you take mass shootings into account, studies have also shown, and this was a Mother Jones article and database, that of mass shootings more involving from 1982 to 2019, 4+ fatalities, the weapons used were handguns, 62%, obtained legally, 83%. When you look at this, the rifles were 25 and shotguns were 13. When you look at this, this shows what the studies actually show. What we have before us tonight is another attempt to make people feel good without helping a thing. You may think this is helping, it may make you feel good, but as I've said before, this will not heal you and it will not solve your problem. As we move forward, please keep that in mind. With that, I yield back.
Thank you, Mr. Collins. Without objection, all other opening statements will be included in the record. I now recognize myself for purposes of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 1186, offered by Mr. Nadler. Strike all that follows after the enacting clause and insert the following.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered as base text for purposes of amendment. I will recognize myself to explain the amendment. This amendment makes several minor clarifications to the bill, but it makes no significant substantive changes. I urge all members to support the amendment, and I yield back the balance of my time. I now recognize the ranking member of the full committee, Mr. Collins, for any comments he may have on the amendment.
No comments on that. I'll reel back.
I now recognize the sponsor of the bill, Mr. Deutsch of Florida.
Thank you, Chairman Nadler. Thanks for recognizing me. Thanks for including this bill to ban high-capacity magazines in the markup and for your support through the years on this important issue. I'd like to thank our colleague in the Senate, Senator Menendez, for championing this bill for so many years. On the other side of the Capitol, I also want to acknowledge the leadership of Congresswoman DeGette, who represents the Columbine community, and Congressman Titus, who represents the Las Vegas community, for all that they've done to help bring this bill to this markup. We all know too many victims and too many surviving family members and loved ones of mass shootings and other acts of gun violence. Today, we stand together to demand that this Congress do something to stop it, and that's what this is. What is the Keep Americans Safe Act all about? Seconds. Just seconds. Because seconds matter. The few seconds that it takes to reload a weapon matter. Those seconds can mean all the difference. Those seconds can save a life. Seconds matter. Yesterday, President Trump honored the first responders from the shootings last month in El Paso and Dayton. They did everything they could to save lives. In Dayton, Ohio, on a busy evening of nightlife, first responders stopped the shooter in a remarkable 30 seconds. That's fast. It is shockingly fast. We're so grateful that they were there to take action. In those 30 seconds, the shooter killed 9 people and injured 27 others. A night of joy was cut short in 30 seconds. The people running out of bars and clubs that night felt the terror that those in Orlando felt in 2016 at Pulse. Celebrations and lives cut short in just moments. After the Pulse shooting in Orlando, I said to my colleagues, you shouldn't need a mass shooting in your district to care about gun violence. Gun violence happens in every district, every day in America. And then on the tragic day almost 19 months ago, a mass shooting happened in my district in Parkland. In Stoneman Douglas High School, a gunman killed 17 and injured 17 others. He fired more than 150 rounds in 6 minutes. 150 rounds in 6 minutes. We know that seconds mattered in those hallways. Students ran down those hallways desperate for safety. And we know that seconds could have made a difference. If this gunman was limited to 10-round magazines, some of those students may have survived that horrible day. High-capacity magazines were meant for the battlefield, not for our communities. Together with assault weapons, high-capacity magazines make mass shootings more deadly. They injure more people faster than gun violence without them. Analysis of mass shootings from 2009 to 2017 found that 58% involved firearms with high-capacity magazines, and in those shootings, there were twice as many fatalities and 14 times as many injuries per incident on average compared to those that did not include the use of high-capacity magazines. We need to act today so that we don't keep breaking the record for the next worst mass shooting in American history. We need to act now so that the next students or concert goers or church goers or young people at a nightclub or back to school shoppers have those precious few seconds to escape. The time to act is right now. I urge my colleagues, I implore my colleagues to support this legislation, to take action here tonight to help save lives. I yield back the balance of my time.
For what purpose does the gentlelady seek recognition?
To strike the last word.
Okay, the gentlelady is recognized for 5 minutes.
You know, at the beginning of this summer's district work period, I was faced with the heartbreaking and infuriating news that Gilroy, the town of Gilroy in my congressional district, had joined the too long list of communities experiencing the tragedy of a mass shooting. At the Garlic Festival, a family-friendly festival that happens every year, and like the perpetrators of so many gun deaths that preceded the Garlic Festival shooting, as well as the ones that followed, as well as everyday gun violence, the Gilroy shooter used an AK-47 style weapon. He had a 75-round drum magazine and 5 40-round magazines with him at the time of the incident. Now, California, along with being the first state to ban assault weapons, is also one of 9 states that bans the sale or import of large capacity magazines or those that accept more than 10 rounds. Why didn't that forward-thinking law protect us? Because it's a state law, and the shooter went to Nevada right next door and bought what he couldn't buy in California. And that makes so clear why we need a nationwide law to protect people. As we know, these lethal weapons unleash a large volume of bullets in a hurry, and they tumble, they do tremendous damage. I'd like to say a word for the first responders at Gilroy. They were facing a shooter with an assault weapon with multiple rounds of bullets, and they didn't have assault weapons. They ran at him, and in under 1 minute, they shot him, and they put an end to that. But because of the nature of his weapon, he was able to kill 3 people and injure 17 others. It really bothers me when I hear people say, well, it wouldn't solve the problem. Yes, it would. Stephen Romero, who was killed that day, was 6 years old. Kayla Salazar was 13 years old. They would still be alive if that shooter had not had access to those weapons. They matter. And if this doesn't solve every problem in every community, it would have saved their lives. And that's a reason why we should act. I just want to say a word of disappointment that when the president recognized the first responders in Dayton and El Paso, as he should, that he neglected to take note of the tremendous bravery of the first responders in Gilroy, who I'm so proud of. What they did was so terrifying, and yet they saved so many lives. And not just the police officers. While the event was going on, the firefighters who were told to stand back until an event is over, they have violated those protocols. They went roaring in anyhow, and because they did, they were able to save some of the 17 who had been so severely injured because they were right on the spot. Of those who are injured, some will never fully recover. That's how damaging these weapons are. So at the vigil we had in Gilroy, it was really just to support the families and the people who are traumatized by that whole experience. And I said then, now is not the time to talk about remedies to gun violence, because we need to just support each other. That was right for them, but now is the time to talk about taking steps to prevent massacres as happened in Gilroy, California. I hope that we are successful in bringing this into law, and when we do, I will be remembering all the victims, but especially a 6-year-old boy and a 13-year-old girl who should still be alive today. I yield back.
For what purpose does the gentleman from Florida seek recognition?
Move to strike the last word.
Gentleman is recognized for 5 minutes.
First, I'd like to submit for the record, Losing Count, the empty case for high-capacity magazine restrictions by Matthew Lorcy, July 17, 2018, from the Cato Institute. There's a number of different issues with this bill, but first I'm just going to start with the definition on lines 12 through 14 on the first page, defining what a magazine is under this 10-round magazine ban. Or that can be readily restored, changed, or converted to accept more than 10 rounds of ammunition. I know there's many on this committee that either served in the military, they're familiar with firearms. Just about every firearm, whether it be a handgun or a rifle that accepts a magazine, there's a little metal piece at the bottom of the magazine. Just about every single one of those could be readily restored, changed, or converted to accept more than 10 rounds of ammunition. So this bill would actually ban just about the use of every semi-automatic firearm, rifle, and handgun. Most handguns, I would say most of the handguns that I carry on a regular basis, using my concealed carry permit in the state of Florida, carry more than 10 rounds. So you're banning just about every handgun and firearm and rifle that would accept a magazine because of the way that this definition is worded, because any of those could be converted. There's simply a little metal piece at the bottom of a magazine for any rifle that accepts a magazine. That's the first issue. The second issue is this would solve absolutely nothing. My colleague from Florida talked about Parkland. The Parkland shooter fired 150 rounds over the course of about 7 minutes, which I don't know where the other gentleman from Florida got his information from, but this news report says using a 10-round magazine. So this bill would do absolutely nothing to have addressed, if this bill was law prior to the Parkland shooter, would have done nothing to address that instance because he used 10-round magazines. In the Virginia Tech shooting, for several years, the deadliest mass shooting in American history, the shooter changed magazines a total of 17 times in the course of his rampage, rapidly and frequently exchanging 10-round magazines that would be compliant with most magazine bans, including this bill. So what you're trying to accomplish, you're not going to accomplish. And any of those of us that served in the military, that I was an infantry officer, we frequently did magazine exchanges as a training exercise. You can exchange magazines in a very quick manner of time. On average, it's 3 seconds, but most guys that practice it could probably do it in 1 or 2 seconds. So you're really not accomplishing anything there as well. Then, further in the language of the bill, on page 2, paragraph 12 through 15, this paragraph shall not apply to the possession of any large capacity ammunition feeding devices otherwise lawfully possessed on or before the date of enactment of the Keep Americans Safe Act. So the shooter in Parkland, the shooter at Virginia Tech, any person that currently possesses the 100-round magazines, the 200-round magazines, the 30-round magazines can still keep their magazines, because you're not banning anything that people lawfully possess at the time that this bill is passed into law. So you're accomplishing absolutely nothing if you're purporting to say that if only people that are shooting and acting in violence and have evil in their hearts that want to shoot and kill a lot of people, if they only have 10-round magazines, then they're not going to kill as many people as they would if they had, say, a 30-round magazine, which the facts don't support that at all. And this bill wouldn't affect that at all, because it doesn't ban current use or possession of anything over a 10-round magazine. So I don't quite understand if the left is trying to say and purport that nobody in the United States should have a 10-round magazine, because if they decide to use it for a nefarious purpose and they try to kill as many people as possible in the shortest amount of time, then why wouldn't you ban possession of the article that you're complaining is purporting to cause all of the violence that you're purporting it's going to cause? But it doesn't, because even the gentleman from Florida, whose district is in Parkland, the shooter in Parkland used a 10-round magazine. The bill that the left in this Congress passed with universal background checks, the Parkland shooter passed a background check at a licensed firearm dealer. That would have done nothing to stop the shooter at Parkland. So what you purport to stop violence, universal background checks, wouldn't have stopped the shooter in Parkland. This 10-round magazine ban wouldn't have stopped the shooter in Parkland. Even if he hadn't done it now and he wanted to do it later, even if this bill was passed, he still could have his 30-round magazines if that's what he used, but he didn't. He used 10-round magazines. So I don't understand what, other than taking those steps to slowly make it illegal to possess firearms that are semi-automatic or any way, shape, or form in America, this is protecting, other than inflicting against law-abiding citizens' Second Amendment rights and infringing upon their rights to carry lawfully. I yield back.
Madam Chairman?
Yes, the gentleman from California.
I forgot to ask unanimous consent to put into the record a communication from the County of Santa Clara in favor of these bills, as well as an article about Gilroy, and I ask unanimous consent.
Without objection. The other gentlewoman from California?
Thank you. Thank you very much, Madam Chair. I haven't spoken tonight, so let me just thank the chair for his leadership in putting forward all of these bills. All of us are just coming off of a 6-week recess where we just saw bloodshed from one end of our country to the next. I was listening to my colleague over there, and it sounded like he might even have some interest in banning assault weapons. I was listening to him saying, why ban the magazine? Why not go after the gun? So if he would have any interest in doing that, I would love to join him in that effort. When we when we are considering these bills, just as we consider bills expanding and improving firearm background checks earlier this year, those are definitive steps that we've made in this House. My colleague refers to the left. I'm not exactly sure who he's referring to, because as I look at my colleagues on this side of the aisle, I see people who are in the Democratic Party. I'm not sure what left he is referring to. But if I think about less than 2 weeks ago, what happened over our break of 54, in addition to the mass shootings that we all very tragically witnessed, a 54-year-old St. Louis man was arrested in connection with the fatal shooting of a 15-year-old child. Over the weekend, at least 34 people were shot, 6 of them fatally, in gun violence in Chicago, and there were 131 murders in only the first 6 months of 2019 in Los Angeles. And I know many of my California colleagues already mentioned that in California we have tough gun laws that we're very proud of, but the problem we have in California is the guns that are coming from outside of California. So we know that gun violence is a problem that reaches far and wide in this country, not only with mass shootings, but in many communities where homicide rates can often reach 10 times the national average. So I know that the committee will, in the next few weeks, examine other types of gun violence issues. But I just have to say that one thing that is just so confusing to me about my colleagues on the other side of the aisle is that they are very clear in their critiques or any holes in legislation that we might propose, but I never hear a solution. And I know that you have to be as concerned about the violence in this country as we are, so what on earth is the solution? When I do hear you put something forward, it's often mental health that's mentioned. You know what? I'm fine with that. Let's deal with mental health. But there's never a concern about putting any resources toward mental health. Mental health is an issue, but it's interesting that mental health comes up when it's a particular type of gunman, not the type of gun violence that many communities see on a daily basis. So I just would really like to hear my colleagues propose some definitive solutions. Ranking member mentioned various studies, and so the studies don't definitively prove that this is a solution or that's a solution. I'm not even sure what studies have been allowed, since I know that the Centers for Disease Control weren't even really allowed to look at gun violence. I believe it's a public health issue, but they weren't really even allowed to look at it. So I don't know what studies he's talking about, but for God's sake, even if the study is not definitive, if it is possible to save some lives, and you know, the thing that happened in Dayton, Ohio, to me, blows up one of the myths that my colleagues make a lot of times, which is we need to make sure that the good guys have guns so that the good guys can go after the bad guys. Well, in Dayton, Ohio, the good guys did have guns. It didn't matter, because those people were slaughtered within a few seconds. The good guys got there, they took out the bad guy, but how many people were killed and how many people were injured? So it makes no sense. When it comes to assault weapons, we know what assault weapons are for. One of these days, I would like to hear some solution from my colleagues, and I'm willing to support you on the mental health tip, but you should come to the table with resources to address mental health, not just the rhetoric. I ask unanimous consent to enter into the record a statement from Representative Robin Kelly from Illinois and also Lacey Clay from Missouri.
Without objection.
Will the gentlelady yield your last word? One study that I do want to make reference to is that if an assault weapon is used with a high-capacity magazine, the number of people that are killed in a mass shooting increases by 62% because of the lethality of the weapon with those high-capacity magazines. So we know for sure, because they are more deadly, they kill more people. And so there is no doubt that passing a ban on these high-capacity magazines will result in saving lives. And with that, I yield back.
Who seeks recognition? For what purpose does the gentlelady from Florida seek recognition?
Thank you, Madam Chair. I would like to strike the last word.
Yes, the gentlelady is recognized for 5 minutes.
Thank you. I want to first say thank you to my colleagues who have had the courage to continue to work on gun reform bills, even though we get obstacle and
obstacle and obstacle. Thank you to my friend Lucy and also Representative Ted Deutsch for bringing this important piece of legislation. We know that the use of high-capacity magazines caused twice as many fatalities as those massacres where they were not being used. We have seen Gilroy, which used a 75 round, where 3 people were killed and 13 were wounded in less than 1 minute. Sandy Hook Elementary, an assault weapon was used with a 30-round magazine that took the lives of 20 children. Pulse in Orlando in 2016, the perpetrator used a 30-round magazine, taking the lives of 49 individuals. One of the lives that was taken at Pulse was Jerry Wright. And when I hear Representative Collins saying that this bill is not going to do anything to save any lives, I would like to ask my colleague, Representative Collins, to say that to Fred and MJ Wright, who continue to fight for common sense gun reform. I would like for him to look into the eyes of the parents of Sandy Hook who have not stopped advocating for common sense gun reform. And we have not seen the will or the courage by my colleagues. When you had the majority for decades, not one gun reform bill was brought in the committee or passed in the House of Representatives. I have to agree with also my colleague Karen Bass. You continue to bring up mental health. Fine, you think it's mental health? Fine, let's invest in mental health programs. But then let's also take action on other forms of gun reform and gun safety legislation that will save the lives of the people that we continue to see lose their life on senseless gun violence. This is a very difficult subject for me, and I've been waiting to speak because every single time I sit in this committee and I hear my Republican colleagues obstruct any sort of action, it's disheartening because I know that most Americans are watching and they see that you have no will, no courage. I also lost my father to gun violence. No, it wasn't through a massacre. They didn't use high-capacity magazines. It was a criminal. But there are many things that we can do to avoid another family member from getting a call that they've lost a loved one. So I implore you, please have courage and work with us in good faith to take action. Please. I yield back.
Who seeks recognition?
Yes, move to strike the last word.
Yeah, the gentleman from Pennsylvania is recognized for 5 minutes.
Thanks. I just got to clarify the record because a lot's been said about the people on my side of the aisle. A lot of us were in the state senate, or state senates. A lot of us were in the state house. Many of us worked on these issues. We had bills on these issues in the state house, and the difference is we respect due process, and we want to make sure that we're protecting people's rights as we're protecting individuals. Now, just talk about this term, Ranking Member Collins has proposed legislation. He has a bill that would make it easy for law enforcement to coordinate and share information to prevent mass violence, to reduce illegal street sales of firearms, and actually persecute perpetrators of gun violence. None of these are partisan. They all protect due process, yet not a single Democrat has co-sponsored this bill. There was talk about Republicans not doing anything. Previously, I wasn't here, I just got elected, but last year, when Republicans controlled the House, we actually did pass legislation to prevent mass shootings that was signed by the president. The Fix NICS Act updated our nation's background check system, which to date has blocked more than 1.3 million gun sales to individuals prohibited from owning firearms. So before you say Republicans haven't done anything on this issue, I want you to investigate what we've done before we got here. I want you to look back just a year at legislation we actually passed. I want you to think about how we take a very balanced approach that protects due process, protects people's properties, but still makes it hard for bad guys to get guns. I yield back my time.
For what purpose does the gentleman from Colorado seek recognition?
Move to strike the last word.
You are recognized for 5 minutes.
Thank you, Madam Chair, and I appreciate the comments from my colleague from Pennsylvania. I would just say this. I too, take umbrage, as my colleague from Florida did, with the characterizations of this bill, and those were not characterizations that you made, but they were made earlier with respect to this notion that the bill would save no lives and that it would simply make us feel good. And I think I would assume you would take the same umbrage if we were to characterize a bill that you had proposed to address this pandemic of gun violence in the United States, if we had characterized it in the same way. This bill has nothing to do with making any of us feel good in the view of the folks on this side of the aisle. It has everything to do with saving lives. And that's why each and every one of us are so passionate about it. Now, I also will say I did not intend to quote Oprah tonight, but Mr. Gohmert made a comment earlier that said Oprah was right, and so I just want to make sure he is aware. An article from 2016 in which she said, quote, "What will be the number? What will be the number? What number is high enough to get our attention so that we will say enough? I thought the number was 26 in Newtown," she continued, referring to the 2012 shootings where 20 children and 6 adults were slain at Sandy Hook. Are we as a country, do we really believe that assault weapons should be made available to anybody? Are assault weapons necessary? I just say enough. When are we going to be conscious enough to say, that doesn't make any sense? We have the right to bear arms, but do we have the right to bear assault weapons? That's what I ask. So those are Oprah's words, not mine. But you and I certainly agree. You and I, Mr. Gohmert, agree that Oprah is certainly right. So I will just say this. In Colorado, we are no stranger to gun violence. Columbine was mentioned earlier. 20 years ago, when 2 shooters entered Columbine High School in Littleton, Colorado, I lived just 10 miles away. I was in 9th grade in my high school when it was shut down, and we learned later that evening that students the same age as me had lost their lives in a tragic and terrible shooting. And that murder, it was one of the first of its kind in the United States, and it has become all too commonplace in America today. As one of the first places to experience that tragedy, this devastation, this violence, it really is an epidemic of gun violence that has taken far too many lives and wrecked countless communities, and yet nothing has been done. I have many constituents who are waiting for this Congress to act. Folks like Jane Doherty, a Coloradan who lost her sister in the Sandy Hook shooting in December 2012. Mary, who was the school psychologist that gave her life trying to protect her students. She went to work at Sandy Hook on December 14th and was never seen again. And as we all know, 26 individuals were murdered in 5 minutes, and 156 rounds were found at the scene. You heard me earlier talk about the leadership of Tom Sullivan, his courage, someone who lost his son in the Aurora shooting where 12 people were killed and 58 others injured. Again, a military-style weapon and a 100-round capacity magazine used. So I will just say this. I recognize that some of my colleagues have some objections to these bills, but I would implore my colleagues on the other side of the aisle to be intellectually honest. Just because a bill doesn't solve all problems doesn't mean it is not a bill worth pursuing. And with that, I would encourage my colleagues to vote in favor of the bill before us today. I yield back the balance of my time.
Okay, the critical issues we're addressing today obviously go to the core of our constitutional democracy and understandably, given the carnage we've seen in recent months, bring out strong passions in us as they do in the American people. Nevertheless, I must remind everyone on our committee that House rules and precedents require us to refrain from imputing the personal motives of another member. These admonitions apply as well to remarks characterizing the motives behind legislation. Members are certainly permitted to voice critical opinions of Congress, of the House, and of political parties, so I hope that what should be a spirited discussion of these issues today will stay focused on those issues and take care to keep our comments in compliance with House rules for decorum.
Move to strike the last word.
The gentleman from Georgia is recognized.
I appreciate the chairman and chair lady recognizing that fact. I wish that it had been followed. We were having at least a decent discussion up until a few minutes ago. There are many solutions to what we're dealing with. And as someone who now has been said to look at someone and explain to them why I don't think this will work, I have. I have been, not only as a pastor, as a chaplain in the military, I have had to, unfortunate and fortunate, preventing because of the blessing received in making and helping people through times of trouble, whether their loved one was killed with a firearm, whether their loved one was killed by a drunk driver, whether their loved one was killed by a member of their own family's hands. I have looked at them, and I would tell them right now that this bill, although would help possibly in some ways, would not bring their loved one back, would not do everything that many times these are supposed to help with. Now, I appreciate the fact, and we can do this, but we have differences of opinion. If we really wanted to take every step out and put forward solutions, then have the chairman bring my bill up, the MVP Act. It's not been brought up. It's not even been actually marked for a markup, where we actually put resources with U.S. attorneys to actually prosecute gun crimes, to actually do things that can actually get at straw purchases, ghost purchases, these other things that actually make this a difference. I have no problem standing for what I believe, and we can disagree all day long. And I will say it. And that's what this committee is about policy, about what we believe works and what we believe does not work. It's also the reason we have majority and minority. It's the reason that you have a substantial majority over our minority to vote whatever you want in. And that's fine. But to simply talk about issues that work, I go back to my bill. Gun prosecutions are now up. We're seeing some of that under the new administration, but we've not seen it as it should be. There are plenty of gun laws on the books that are not ever enforced. We see gun prosecutions and prosecutors not declining to prosecute gun crimes, which would have took people off the no-buy list, would have took guns away from them, and not done. But we don't talk about that. We talk about other things. I think the problem here is simply the need to do something sometimes outweighs the need to do something that would effectively, as my friend from Florida talked about the magazines in the Parkland issue, the other issues. We can go down to this line, and I am not yielding on this anytime for a second. I think we can get through the rest of this evening and disagree inherently on what actually and how much of effect this would actually have. We've stated studies really on both sides. Most of the studies respecting the 94 ban have shown not to have worked. But simply to go back and talk about this from a perspective of those who may or may not walked in my shoes and what I would do or what I would not do, again, let's cloud the point. Let's throw it up. Let's say Doug's wrong or the ranking member is wrong simply because he has a different opinion than the majority, and have put forward solutions that do go at the heart of gun violence. But I can't get a hearing. Ask the chairman, why not that? Your bills are good, why can't I get a hearing on mine? I'll tell you why. Because he don't want to deal with it. We could have put it on the markup for the day. Was I given a courtesy call and said, hey, Mr. Ranking Member, you've got a bill that we'd love to try. We're going to vote it down, but we're going to give you a hearing. I don't get that, and that's part of majority-minority. I get that. But what I'm not going to get, I'll state my reasons for why I vote, and I'll state my reasons for why I disagree. And I will look anyone in the eye and tell them. My friend from Georgia, heart breaks for her tragedy, but I will still tell her I disagree with this bill. And that's just the way that we go. But when we can't make our point, we try to make other things. If that's what makes us feel better, so be it. I yield back.
Mr. Chairman.
Gentlelady from Texas.
Let me, I just want to say to the ranking member that I think, knowing the chairman, all courtesies are certainly in the possibility of our leadership. And I don't think anyone is disregarding any member's legislative work. We have 3 bills now here today. Some of us are optimistic that we will have another opportunity for markup of additional bills. Some of us have bills that we believe will contribute to a new schematic on gun safety in this nation. So the fact that his bill is not presently on the markup is not a final word that I might imagine might occur.
Would you join me in calling for a markup on it?
I would join you in increasing the number of opportunities for bills to be marked up.
How about mine?
And we all will be advocating for our bills. I see Congressman Raskin smiling, but let me say this. Congressman Raskin gave a constitutional recounting with the famous Hello bill that's used, I think, wrongly. And no one read the finer print or that indicated that regulation was not ruled unconstitutional as relates to the Second Amendment. And a Seventh Circuit case was just ruled on, which may make its way to the Supreme Court, that indicated that Chicago had the right to pass strong gun safety laws. So we're not in a pure sense right here. The gentleman's bill from Georgia is a good intent, but it is after the fact. Prosecution goes after the fact. What we're trying to do now, and what the parents that Congressman Deutsch represents, and the families that Congresswoman Escobar represents, and we're trying to...
Ms. Jackson-Lee, can I just, but they were misrepresenting my bill. And I'll be happy to explain my bill to the gentlelady, but just don't misrepresent it.
Let me finish, and I'd be happy to have the gentleman clarify if I have time. But bills that deal with prosecution are after the fact. And I think the gentleman's talking about enforcement of the law, and I certainly support that. We're talking about getting to the point where those of ill intent, hatred, whatever their mode is, do not get 10 rounds. We're trying to say that civilians don't have those rounds to go against law enforcement officers who are rushing to the scene and who are trying to protect the innocent. We're trying to suggest that when you have 10 rounds, as the doctor who testified in our hearing just this afternoon indicated, a trauma surgeon, that when you see those kinds of bullets and rounds in a human body, you hold a child's heart in your hands who is bleeding to death on the operating room table. We're trying to suggest that Japan, yes, a smaller country than ours, has no gun violence and no guns. We're not that country. But we realize we want to be in the preventive mode to save lives. We want to ensure that the young man at Sandy Hook could not go into the closet of stored guns because they were not stored properly. They had a storage unit, but it was not locked without him having access to it, and had 30 rounds in Sandy Hook. So this issue of magazines is getting to the point where we don't have civilians walking around with weapons that are warlike or for law enforcement in case that they are in an issue or a situation where they're under siege. And I am, not often have I seen that having to be used, but just imagine if it's used against them or the community that they're trying to protect. These are weapons of war. The magazines are used in war. They're not used. And as a congressman said, Deutsch, who explained to me, he said the young man in Florida only was stopped because his gun jammed. and he had 10 rounds. So I'm interested in saving lives. And frankly, that's why we're going to go all the way through the night, we hope not, to get these bills passed to ensure that we have a federal statement and law about saving lives. I yield back.
Gentlelady yields back.
Mr. Chairman.
Who seeks recognition? The gentleman from California.
Thank you, Mr. Chairman. I think the question is not to speak to motives, but to ask, for what purpose does any person in our country need a 100-round magazine? Is it to hunt? Is it to shoot for sport? Is it to protect yourself and your home? Or is it to carry out mass killings, as we see time after time? And I think there have been some fair criticisms of the different pieces of legislation tonight, but what I see kind of reminds me of like a 100-piece puzzle. And if each piece represented a different gun safety reform, what my colleagues do is they pull out a piece and they say, well, this piece doesn't make sense. We don't know what this piece would do. And that may be true. There may be imperfections of each piece of legislation that we offer. But ultimately, when you put background checks, red flag laws, magazine capacity limitations together, and other reforms that I sense will be coming, what you have is a safer America. But if you're going to take each piece and say, well, this would not have prevented X, Y, Z shooting, then there's no reason for us ever to show up here and do anything on anything that affects our lives. But if we can just reduce one shooting, 1,000 shootings. It was predicted today by a doctor based on science that testified to a gun safety task force that over the next 10 years in America, there will be 1 million gun violence victims. What if we could protect just half of those people? The gentleman from Florida also made a fair criticism that this bill does not ban assault weapons. I think we should ban assault weapons. He also said that it grandfathers in approximately 250 million magazines that are out there that go beyond the capacity in this bill. That's true, and I think we should all seek to fund buyback programs through other initiatives in Congress to reduce the availability of those magazines on the streets today. But what this piece of legislation does is it gives us all, our constituents, a chance. A chance if someone comes into our church to have a few extra seconds because they don't have 100 rounds, they only have 10. It gives us a chance if someone comes into the theater to run for the exits. It gives us a chance if someone shoots up a concert to duck for cover. And it gives our children a chance when they're in school. If someone walks, God forbid, through their halls, just a few more seconds to spare their lives. It's not perfect. Upstream legislation, like prohibiting what can even be made, holding manufacturers liable, having licensing requirements and insurance requirements and background checks are a much better way to prevent shootings in the first place. But if somebody is going to do harm, this just gives us time. It gives us a chance. And it could happen to any one of us, any of our constituents, any of our children. And with that, I believe the gentleman from Maryland would like to seek time.
Thank you very much to the gentleman from Florida for yielding. The other gentleman from Florida made the argument that the mass killer in Mr. Deutsch's district used a 10-round capacity magazine. That may be right, but what I'm reading from is page 262 of the report done by the Marjorie Stoneman Douglas High School Public Safety Commission, which was given to the governor on January 2nd, 2019. And on page 262, it says, on September 30th, 2016, Nicholas Cruz was issued a Florida ID card that was needed to purchase firearms. Cruz used a single firearm during the shooting. It was the only firearm he had in his possession on February 14th, 2018. The firearm was a Smith & Wesson model MP-15 semi-automatic. A sling and bipod were attached to the rifle. The firearm was lawfully purchased on February 11, 2017 at Sunrise Tactical Supply in Coral Springs, Florida. 8 30 and 40 round capacity magazines were recovered from the scene. So I don't know what we're missing, but this seems to completely contradict the suggestion made by the gentleman from Florida that it was 10-round capacity. In any event, I mean, I'd gladly yield to him if he were here to see whether he would change his mind about the legislation given that fact, but I'm afraid, along with Mr. Swalwell, that it's kind of a game of three-card Monte. You know, if there's a mass murder that takes place and we say it was a weapon of war, they say it was mental health. We say let's have red flag laws to deal with that then they oppose the red flag laws and say it violates the Second Amendment, although it doesn't. So we're looking for real solutions, and this will move us forward, and I stand in favor of it. I yield back.
I yield back. Thank you.
Gentleman from Tennessee.
Thank you, Mr. Chair. The people in my district want this bill passed. Most of the people in America want this bill passed. Certainly the moms demand action, want this bill passed, and I want to commend them for what they've done to rally support throughout this country in rallies. The rallies we had in Memphis were strong against guns, and they were strong all over this country. And this is the time that we need to act. There is no real good reason to have high-capacity magazines except for sport. You want to have sport? Let the gun folks that rent out opportunities to go shoot and go play Rambo, but do it when you don't take it home with you, where you can take it to the movie theater or the school or the concert or wherever. So I'm going to vote for this bill. I'm proud to vote for the last bill. I'm going to vote to ban the AK-47s, AR-15s, whatever. You want to be Rambo, but not in the streets. Do it at a gun range. Or join the Army. Get on a boat. Go away. So thank you, and I look forward to voting for this bill.
The question occurs on the amendment in the nature of a substitute. For what purpose is the gentleman from Texas?
Strike the last word.
Gentleman is recognized.
Right. One of the things, like I mentioned, Sharansky said, is when you lose moral clarity, you fail to realize who your friends are, who your enemies are. There's nobody here on either side of the aisle that's my enemy. And I hope at some point you realize I'm not your enemy. And for anybody on this committee to think, I mean, you need to understand, growing up, I was very, very small. I got picked on. I had my nose bloodied more times than I ever care to think about. For 6 years, 7th through 12th, I was usually the smallest guy on the football team. You have no idea the things that I've done in my life with regard to a display or lack of display of courage. So for anybody on this committee to think you're going to intimidate some of us by basically saying what we heard in junior high, you're a security cat, that's not going to accomplish anything. The issue here is so serious, saying that we have a lack of courage and we need to get some courage. And with regard to Oprah Winfrey, one of the things people love about Oprah Winfrey, probably the biggest thing, she has an incredibly big heart. She loves people. She loves doing things for people. She loves helping people. But on the Judiciary Committee, we have to be about using our heads. That's the only way you're going to preserve this little experiment in self-government. So to say it's courageous, you know, I never got a thought for being the Republican leader on this committee because of the stands I've taken in my own party. That was not even a possibility. There were times during the second Bush administration, I wished some of my Democratic friends would have joined me in condemning the Justice Department in their abuses. but too often I was alone in doing that from either side of the aisle. But we got to be about using our heads here. And I know, and it plays on the heart well to say, if we can just save one life, when if you study the history of this country, there have been millions of lives laid down so that people would have freedom. And they would say, if you keep the freedom that we bought for you with our lives, then it was worth us giving the lives. So let's look in terms of how we preserve this experiment self-government and try to preserve as much freedom as we can for as long as we can without belittling each other. I understand we're all here wanting to do something good and noble. I just can't imagine saying, the Democrats are all cowards, because I don't believe that. So let's try to work together and not condemn people because we don't see things the same way in trying to keep this republic. I yield back.
Gentleman yields back. The question now occurs on the amendment in the nature of a substitute. This will be followed immediately by a vote on final passage of the bill. All those in favor respond by saying aye. Aye. Opposed, no. In the opinion of the chair, the ayes have it. The amendment in the nature of a substitute is agreed to. Reporting quorum being present, the question is on the motion to report the bill, H.R. 1186, as amended favorably to the House. Those in favor respond by saying aye. Aye. Those opposed, no. And the ayes have it, and the bill is ordered reported favorably. Roll call is requested, and the clerk will call the roll.
Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Ms. Jackson-Lee? Ms. Jackson-Lee votes aye. Mr. Cohen? Mr. Cohen votes aye. Mr. Johnson of Georgia? Mr. Johnson of Georgia votes aye. Mr. Deutsch? Mr. Deutsch votes aye. Ms. Bass? Ms. Bass votes aye. Mr. Richmond? Mr. Jeffries? Mr. Jeffries votes aye. Mr. Cicilline? Mr. Cicilline votes aye. Mr. Swalwell?
Aye.
Mr. Swalwell votes aye. Mr. Liu? Mr. Liu votes aye. Mr. Raskin? Mr. Raskin votes aye. Ms. Jayapal? Ms. Jayapal votes aye. Ms. Demings? Ms. Demings votes aye. Mr. Correa? Mr. Correa votes aye. Ms. Scanlon? Ms. Scanlon votes aye. Ms. Garcia?
Aye.
Ms. Garcia votes aye. Mr. Neguse? Mr. Neguse votes aye. Ms. McBath? Ms. McBath votes aye. Mr. Stanton?
Aye.
Mr. Stanton votes aye. Ms. Dean?
Aye.
Ms. Dean votes aye. Ms. McCarcel-Powell?
Aye.
Ms. McCarcel-Powell votes aye. Ms. Escobar?
Aye.
Ms. Escobar votes aye. Mr. Collins? No. Mr. Collins votes no. Mr. Sensenbrenner? Mr. Shabbat? Mr. Shabbat votes no. Mr. Gomer? Mr. Gomer votes no. Mr. Jordan? Mr. Jordan votes no. Mr. Buck? Mr. Buck votes no. Mr. Ratcliffe? Mr. Ratcliffe votes no. Ms. Roby? Ms. Roby votes no. Mr. Gates? Mr. Gates votes no. Mr. Johnson, Louisiana? Mr. Johnson of Louisiana votes no. Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. McClintock votes no. Ms. Lesko? Ms. Lesko votes no. Mr. Reschenthaler? Mr. Reschenthaler votes no. Mr. Klein? Mr. Klein votes no. Mr. Armstrong? Mr. Armstrong votes no. Mr. Stubbe? Mr. Stubbe votes no.
How am I recorded?
Ms. Lofgren, you are not recorded.
Aye.
Ms. Lofgren votes aye.
Are there any members who wish to vote who haven't voted? The clerk will report.
Mr. Chairman, there are 23 ayes and 16 noes.
The ayes have it, and the bill is amended as ordered reported favorably to the House. Members will have 2 days to submit views. The bill will be reported as a single amendment in the nature of a substitute incorporating all adopted amendments. Without objection, staff is authorized to make technical and conforming changes. Pursuant to notice, I now call up H.R. 2708, the Disarm Hate Act, for purposes of markup, and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 2708, to prevent a person who has been convicted of a misdemeanor hate crime or received an enhanced sentence for a misdemeanor because of hate or
Without
bias.
objection, the bill is considered as read and open for amendment at any point. I will begin by recognizing myself for an opening statement. With the sharp increase in hate crimes in this country, it is sadly important that the committee today adopt H.R. 2708, the Disarm Hate Act. This bill, introduced by our colleague, the gentleman from Rhode Island, Mr. Cicilline, would prohibit the purchase or possession of firearms by individuals who have been convicted of a misdemeanor-level hate crime or who have received an enhanced sentence on account of unlawful bias for certain misdemeanor convictions. The FBI reports that there has been a significant increase in hate crimes over the past 3 years, with more than 7,100 hate crimes reported in 2017 alone. This count is likely a substantial undercount of the total number of hate-motivated crimes that occur in communities throughout the country, as reporting of these incidents to law enforcement remains sporadic. According to the National Crime Victimization Survey, approximately 204,000 hate crimes targeting victims based on their actual or perceived race or ethnicity, gender, sexual orientation, disability, or religion are committed in the U.S. every year. Our country has been particularly devastated by a series of horrific mass murders motivated by hate in recent years. In 2012, a white supremacist attacked worshipers in a Sikh temple in Oak Creek, Wisconsin, killing 6 people and injuring 4 others. In 2015, a white supremacist murdered 9 worshipers during a Bible study at the Emmanuel African Methodist Episcopal Church in Charleston, South Carolina, an historic African-American church. In 2016, a nightclub in Orlando, Florida was attacked, leaving 49 people dead and 53 others injured, most of whom were LGBTQ and Latino. A total of 12 people were killed and 10 wounded during attacks at synagogues in Pittsburgh, Pennsylvania, and Poway, California, in recent incidents just 6 months apart. And just last month, the shooter in El Paso targeted Mexican Americans who were shopping in a Walmart store, killing 22. These horrible attacks have 2 things in common. They were all hate crimes, and they were all committed with a gun. As these tragedies and tens of thousands of other examples show, guns are a frequent tool of hate-motivated violence and intimidation. From 2010 through 2015, 46,500 hate crimes committed in the U.S. involved a gun. Despite these grim statistics, our nation's weak gun laws give easy access to guns for individuals seeking to do harm. Under current law, many of those who have been convicted of misdemeanor-level hate crimes remain free to buy and possess guns. These misdemeanor hate crimes include many types of threatening and dangerous conduct, including assault and threats or harassment of members of a protected class. Roughly half the states have misdemeanor hate crime or sentencing enhancements for which a conviction would not currently prohibit firearms possession or purchase. The Disarm Hate Act would address this dangerous gap in the law by prohibiting individuals who have been convicted of a misdemeanor-level hate crime or have received a hate crime sentencing enhancement from buying or possessing guns. The bill's prohibition extends only to those convicted of a misdemeanor hate crime or those who have had an enhancement imposed on them because of the use or attempted use of physical force, the threatened use of a deadly weapon, or other credible threat to the physical safety of a person. This qualifying language ensures that this added prohibition applies only to those convicted of underlying crimes that pose a public safety risk. This is a modest, common-sense measure that will help ensure that people with a demonstrated history of hate-motivated violence do not continue to have easy access to firearms. Each person who would be prohibited from purchasing or possessing a gun under this bill has been found beyond a reasonable doubt to have committed a crime of violence or criminal physical threats based on the race or sex of the victim. This bill sends a strong message that hate violence is dangerous and unacceptable, and that we will do everything in our power to help prevent hate-fueled attacks perpetrated by armed assailants. Therefore, I support this important legislation, and I urge its quick adoption today. I now recognize the ranking member of the Judiciary Committee, the gentleman from Georgia, Mr. Collins, for his opening statement.
Thank you, Mr. Chairman. And it's been a long day. I mean, this is another piece of legislation that really attacks at a different angle. It's a concern. I'm not decided that there was ever a non-hate-filled violent crime. I'm just not sure where you find that. Somebody who attacks somebody else, there's a hate motivation, there's a malice motivation there. And just by calling it something based on who they're attacking or not attacking is not making it worse. Crime is not somehow worse just because the identity and characteristics of the victim. Justice must be swift. It must be also blind. Murder is murder. Assault is assault. Mr. Chairman, we must remain faithful to our democratic principles as a nation. We are committed to free expression, free press, and blind justice. As I've stated earlier this year, governments that attempt to restrain people's hearts and minds for whatever reason pave the way to oppression and political violence. The First Amendment is not there for speech we like. It is there to protect speech that we abhor. It is not there for speech we like. And murder is murder, assault is assault. You don't make the crimes worse or less. It is just simply one human attacking another, and that is wrong and should be condemned at all costs. H.R. 2708 is an attempt to the Democrat majority to do just that. It would allow for future administrations to use vaguely defined hate crime as against individuals with whom they disagree by permanently depriving them of a fundamental constitutional right. We know that this is true because other things, legislation would apply retroactively to misdemeanor convictions to meet the bill's vague definition and may have occurred years or even decades in the past. Moreover, this legislation is unnecessary. Current law already contains robust protections to ensure dangerous felons are prohibited from possessing firearms, whatever the motivation for those crimes, and applying those now to a certain level because of a definition, again, is problematic. We're on an interesting slope here with this bill. It is the chairman's and majority's prerogative to pass this bill, which I'm sure they will, probably expeditiously. But please hear the warning of the minority, which is many times the one that is listened to later in life. Be careful what you're doing here as you go forward, keeping this vague, keeping this in a certain way of going back and retroactively applying. Hate is hate. Free speech, other things was once called that we may disagree with, we may want to suppress. But I respect the right of my colleagues to express views that I disagree with. That's the First Amendment. We don't need the First Amendment if we all agreed. We need the First Amendment protect. And when somebody attacks somebody, when somebody murders somebody, when somebody assaults somebody, when they go after somebody, whether they bully them or anything else, that is wrong and comes from a matter of hate. You don't have to call it what it is. It's already shown in the action. And this is just another misguided attempt on this legislation. But this is the decision of the majority. I say it's not good, but that's why the votes take place. And with that, I yield back.
I now recognize myself for purposes of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 2708, offered by Mr. Nadler. Strike all that follows after the enacting clause and insert the following.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered as base text for purposes of amendment. I will recognize myself to explain the amendment. This amendment adds a severability clause to the bill, providing that should any portion of the bill be found invalid, the remainder of the bill will stay intact. It makes no other changes to the bill, and I urge all members to support it. I yield back the balance of my time, and I now recognize the ranking member of the full committee, Mr. Collins, for any comments he may have on the amendment.
I've already made all the comments. I'll yield back.
Gentleman yields back. Are there any amendments to the amendment in the nature of a substitute?
Mr. Chairman.
Gentleman from Rhode Island.
Thank you, Mr. Chairman. I move to strike the last word.
The gentleman is recognized.
Thank you, Mr. Chairman. Thank you. I want to begin by thanking my colleagues who have participated in today's hearing and particularly acknowledge the leadership of Ted Deutsch, Lucy McBath, Debbie Mucarsel-Powell, who have taken very painful personal experiences both in their lives and in their communities and used it really to focus in a very determined effort to reduce gun violence in this country. And you have been an inspiration to all of us, and we admire you so much for all of your work. I want to respond briefly to Mr. Collins' concern that crime is a crime and hate crimes are, I guess, no different, and I couldn't disagree more. The reason that we have, in fact, adopted provisions both in federal and state law to make hate crimes more severely punished is because they are, of course, A crime committed against an individual because of their race, their ethnic origin, their religious affiliation, or their sexual orientation or gender identity, and it's intended to instill fear in an entire community. And so that's why we tend to treat it more severely rather than an example of someone who commits an offense that doesn't have that as a basis. And so what we know from the Southern Poverty Law Center is that they estimate there are 892 hate groups currently operating in the United States, a number that has increased by 14% since last year. And they also found that 59% of domestic terrorist attacks were carried out between 2009 and 2015 with a gun. So there's a real connection between guns and hate. The National Crime Victimization Survey revealed that between 2010 and 2016, there were over 56,000 hate crimes that involved a gun. And I'd ask unanimous consent for this report entitled Hate and Guns, a Terrifying Combination, prepared by the American Center for American Progress, be made a part of this record. What we know is on August 3rd, 2019, a gunman shot and killed 22 people and injured 24 others in a mass shooting that occurred in a Walmart in El Paso, Texas. The white nationalist gunman wrote in a manifesto that he drove nearly 10 hours with the intention of targeting Mexicans. What happened in El Paso is not unique. Jerry Wright was killed along with 49 others in the Pulse nightclub shooting in Orlando, Florida. Inspired by hate, a gunman opened fire on a Bible study group, killing 9 people at Emmanuel African Methodist Episcopal Church in Charleston, South Carolina. And in Pittsburgh, a gunman killed 11 people and injured 7 more people in a shooting at a synagogue. We have a responsibility to keep guns out of the hands of people who shouldn't have them. And this connection between hate crime convictions and subsequent additional violence is clear. Researchers have found, and I'm quoting from this report, researchers have found that individuals who commit hate crimes tend to escalate their conduct in order to ensure their message is received by the targeted individual or community. Jack Levin and Jack McDevitt, researchers from Northeastern University who specialize in hate crimes, explain the phenomenon this way. Defensive hate crimes are intended to send a message. For example, that blacks are not welcome on this block, or Latinos should not apply for that promotion. As such, these crimes they're intended effect very much like acts of terrorism, meant to send a signal by means of fear and horror. If the original criminal response fails to elicit the desired retreat on the part of the victim, then the offender frequently escalates the level of property damage or violence. A black family moving into an all-white neighborhood is first warned. If they don't heed the warning, then their windows are broken. If they still refuse to move out, their house may be firebombed or worse. There's pattern of escalation that has demonstrated the importance for preventing people who have been convicted of hate crimes, even a misdemeanor hate crime, from buying a gun. But many states do not have prohibitions against this. In fact, there are 23 states in the District of Columbia prohibit individuals convicted of specific misdemeanor offenses from buying and possessing guns, but the vast majority of states have not enacted laws. And so this would prevent people who are convicted of a hate crime with the research that shows there is substantial likelihood of subsequent violence with an increased likelihood of the use of a gun. This is a common sense proposal to keep guns out of the hands of people who commit hate crimes that are likely or have a propensity to violence that will help protect our communities from some of the worst gun violence that we've seen. I urge my colleagues to support this legislation, and with that, I yield back.
The gentleman yields back. Are there any amendments to the amendment in nature of a substitute? For what purpose does the gentleman from Texas seek recognition? Gentleman's recognized.
Thank you. Again, the emphasis on hate, the federal hate crime laws that were pushed through here, heralding the James Byrd case in Jasper, Texas as the poster case, were misdirected because James Byrd was horribly killed. And as I've said before, I wouldn't have had a problem if Texas adopted a sentencing where the victim's family in such a case could choose the way that he were to lose his life and the death penalty would be invoked, including dragging the perpetrators behind a truck until dead. But under our federal hate crime that was adopted by heralding the James Byrd case, see, this is why we need a hate crime law. The 2 most culpable of the 3 got the death penalty. That's why I want the El Paso shooter tried under Texas law and not under any federal hate law, because he can't get the death penalty under federal hate crime. And it is an absolute defense under the federal hate crime law if you come in and raise a reasonable doubt that, oh, I didn't actually hate any of those people. I chose them all at random. That's a complete defense. You're acquitted under our federal hate crime law. And I know, as my colleague said, it's terrifying to think of hate, somebody with hate and a gun. But from what I saw as a judge, most people were more terrified when there was somebody that was what used to be called psychopath, sociopath, now antisocial personality. They don't care. They want to hurt somebody and they don't care who it is. Those people are far more difficult to ever rehabilitate. There's plenty of evidence, if you study sentencing and rehabilitation, there's plenty of evidence out there of people who have hated, committed a crime with hate in their heart. They got a shot at being rehabilitated because they're not necessarily an antisocial personality. The people that choose victims at random, you're going to have a tough time ever rehabilitating them. And this is how misguided this whole emphasis on hate has gotten. You look here at page 1, term convicted in any court of a, not felony, misdemeanor hate crime. And that's defined as a misdemeanor under federal, state, tribal law, but it has to have as an element that the offender was motivated by hate or bias because, and we'll use the term here, because of sexual orientation, for example, or gender identity. And it involves the use or attempted use of physical force. We're not talking that somebody has used a gun or a deadly weapon, a knife, a machete, like the 800,000 or so that were killed with machetes in Rwanda. This is just any use of physical force, whether it's a noogie or the example that really got me back when the hate crime laws were passed, and it still is applicable in this scenario, and that is a woman and her little daughter walk up to a street corner. There's a guy there in a raincoat. He flashes himself because that's how he's oriented sexually. That's how he gets pleasure. The woman reacts by hitting him with her purse. She has just committed a federal hate crime. If a mom has taught her little girl that you be careful, beware of strangers, strange men, and she's in a restroom and a guy comes in and the little girl reacts, or her mom's in there and feels like she's defending her daughter who's freaking out, they've committed a hate crime. And in the case of the flasher, he's the victim, she's the hater. This is how strained this kind of law has become. We should not be taking away somebody's right to keep and bear arms, should not be infringing on that simply because somebody reacted to what used to be called a pervert and now is being called a victim. I yield back.
Gentleman yields back. The gentlelady from Texas, Ms. Escobar.
Thank you, Mr. Chairman. I move to strike the last word.
Gentlelady is recognized.
I cannot tell you how distressing it is for me to hear a dismissive account of hate crimes. 5.5 weeks ago, a killer drove to my community, one of the safest communities in the nation for decades, one of the safest communities in the nation. He drove to my community in order to slaughter Mexicans and immigrants. And he walked into a store, deliberately targeting us. I have 2 kids, one of whom is in the audience, my daughter. And I have to worry about the color of my kids' skin. Those who don't have to worry about hate crimes don't have to fear things like that. You know, in this country, there's two things that we're talking about today, and it's so right that we are talking about both of them on the same day. I was afraid that this bill was going to get kicked over into tomorrow, and I was hoping it wouldn't. Because we don't just have a gun violence epidemic in this country, we have a hate epidemic in this country. And it has been fueled over and over and over again with language that is racist and bigoted, language that is intended to divide the good people of this country, language that is intended to make us fear those who look differently, love differently, come from different places, language that has made us forget exactly what we have been taught. One of my colleagues mentioned a quote about losing our moral center. We have lost our moral center when we no longer see human beings with dignity and grace, the dignity and grace that they were born with, when instead we call them illegal, or we look for ways to separate them, or we look for ways to target them. Well, my people, my community has been targeted. We have had a target placed on our back because of the color of our skin. The day that your folks are massacred, then I can be lectured about hate crimes and how we should dismiss them and how they are meaningless. Hate crimes are not meaningless, or the designation of them is not meaningless. This is about accountability. This is about holding people accountable for the words that they say and the actions that they take. And I thank my colleague, Representative Cicilline, for bringing this legislation forward. I thank my colleagues here today on Judiciary who are standing with people who have been targeted. The best way for us to regain our moral high ground in this country is to begin reconnecting with our compassion and our humanity. And I support your bill, Mr. Cicilline. Thank you. I yield back my time.
The gentlelady yields back. Are there any further amendments? For what purpose is the gentleman from Florida seek recognition?
Move to strike last word.
Gentleman is recognized.
I yield to Mr. Gomer of Texas.
Yeah, I want to make sure that there's no more mischaracterization of what I had to say. For me to advocate for the death penalty for the guy that went to El Paso and killed all those innocent victims is hardly dismissive. That's unfair, and you weren't listening, and to say further would probably violate the rules of decorum, and I'm not going to do that. The people that commit violent crimes need to be punished, and I am someone who has punished them, and especially when victims were women, and that may shock some people. But to say that we're dismissive of people who commit violent crimes is just not accurate. They need to be punished. That's why I want the El Paso shooter that killed those innocent people to be punished under Texas law, and not because I'm dismissive, but because the hate crime law passed here doesn't do as much as the Texas state law does to punish such evil perpetrators. So I needed to set the record straight. Thank my friend from Florida, and yield back to my friend from Florida.
Does the gentleman yield back?
Not quite yet, Mr. Chairman, if that's all right. I just have to reject the notion that that the thoughts in the mind of anyone that would commit these heinous acts would be graded any less by consequence of who they were shooting. I mean, I think about, those kids in Parkland, and I don't think that they were targeted by virtue of their identity, but the person who killed them was no less evil than the person who committed those murders in Texas that we're all so sad about. I yield back.
Are there any further, does anyone else seek recognition? The gentleman from Arizona, Colorado, sorry.
Thank you, Mr. Chairman. Mr. Chairman, I believe this legislation is flawed. As a former prosecutor, I'm very concerned about the effects this legislation would have on the judicial system. My first concern is that this legislation is unconstitutional. This bill is not simply forward-looking, but rather looks backwards to long past convictions in order to impose additional legal consequences on misdemeanor offenders who have already paid their debt to society and in many cases rejected hateful ideology. This is the very definition of an ex post facto law prohibited by the Constitution. The fact that this bill applies retroactively to past misdemeanor convictions raises serious constitutional concerns. If this bill applied only prospectively to future convictions, it would be on much firmer constitutional ground. I am also concerned that this bill is unconstitutionally vague in terms of identifying which misdemeanor hate crimes will trigger a loss of gun rights. In the context of hate crimes, this bill does not offer police, prosecutors, or judges clarity. These officials will have difficulty understanding which hate crimes affect gun rights. Due to a lack of hearings on this bill, I don't think we have any idea of the magnitude or scope of what this bill might be asking law enforcement or prosecutors to take on. This will make it difficult to enforce the law and likely impossible to ensure equal application of the law. The third concern I have with this bill is a practical consideration. NICS does not currently contain information about past misdemeanor convictions such as hate crimes. State, local, and tribal governments do not report this kind of information. So this information simply does not exist in any meaningful way to guide federal firearms licensees or prospective purchasers. Does law enforcement have the resources to go back and review past cases to determine whether a conviction qualifies and whether it should be reported? Probably not. Even if a jurisdiction is inclined to go back and look at past cases, are the case files sufficiently detailed to make a fair and just determination so long after the case was originally adjudicated? What protections or redress does someone have if someone unfamiliar with their case incorrectly determines their prior conviction should bar them from possessing a firearm? There's already a long criminal justice backlog. For example, in DNA testing, applying this law to past cases will slow down the judicial process and further burden already overburdened law enforcement and prosecutors. We don't know many of the answers because we have not held hearings on this legislation. Until this committee engages in legitimate inquiry and genuine fact-finding rather than posturing and grandstanding, we won't know the answers to these questions. And until we have answers and understand exactly what this bill would do, we shouldn't pass it. I yield back.
The gentleman yields back. The question now occurs on the amendment in the nature of a substitute. This will be followed immediately by a vote and final passage of the bill. All those in favor respond by saying aye. Aye. Those opposed, no. No. In the opinion of the chair, the ayes have it, and the amendment in the nature of a substitute is agreed to. A reporting quorum being present, the question is on the motion to report the bill H.R. 2708 as amended favorably to the House. Those in favor respond by saying aye. Aye. Opposed, no. No. And the ayes have it, and the bill is ordered reported favorably. Recorded vote has been requested. The clerk will call the roll.
Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Ms. Lofgren votes aye. Ms. Jackson-Lee? Ms. Jackson-Lee votes aye. Mr. Cohen? Mr. Cohen votes aye. Mr. Johnson of Georgia? Mr. Johnson of Georgia votes aye. Mr. Deutsch? Mr. Deutsch votes aye. Ms. Bass? Ms. Bass votes aye. Mr. Richmond? Mr. Jeffries? Mr. Jeffries votes aye. Mr. Cicilline? Mr. Cicilline votes aye. Mr. Swalwell? Mr. Swalwell votes aye. Mr. Liu? Mr. Liu votes aye. Mr. Raskin? Mr. Raskin votes aye. Ms. Jayapal? Ms. Jayapal votes aye. Ms. Demings? Ms. Demings votes aye. Mr. Correa? Mr. Correa votes aye. Ms. Scanlon? Ms. Scanlon votes aye. Ms. Garcia?
Aye.
Ms. Garcia votes aye. Mr. Neguse? Mr. Neguse votes aye. Ms. McBath? Ms. McBath votes aye. Mr. Stanton?
Aye.
Mr. Stanton votes aye. Ms. Dean?
Aye.
Ms. Dean votes aye. Ms. McCarcel-Powell? Ms. McCarcel-Powell votes aye. Ms. Escobar?
Aye.
Ms. Escobar votes aye. Mr. Collins? Mr. Collins votes no. Mr. Sensenbrenner? Mr. Shabbat? Mr. Shabbat votes no. Mr. Gomert? Mr. Gomert votes no. Mr. Jordan? Mr. Jordan votes no. Mr. Buck? Mr. Buck votes no. Mr. Ratcliffe? Ms. Roby? Ms. Roby votes no. Mr. Gates? Mr. Gates votes no. Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes no. Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. McClintock votes no. Ms. Lesko? Ms. Lesko votes no. Mr. Reschenthaler? Mr. Reschenthaler votes no. Mr. Klein? Mr. Klein votes no. Mr. Armstrong? Mr. Armstrong votes no. Mr. Stubbe? Mr. Stubbe votes no.
Has everyone who wishes to vote, voted? Clerk will report.
Mr. Chairman, there are 23 ayes and 15 noes.
The ayes have it. The bill is amended, is ordered reported favorably to the House. Members will have 2 days to submit views. The bill will be reported as a single amendment in the nature of a substitute incorporating all adopted amendments. Without objection, staff is authorized to make technical and conforming changes. We now have 2 remaining bills, which are both uncontroversial and bipartisan, and I hope we can do them with dispatch. Pursuant to notice, I now call up H.R. 4018 to provide that the amount of time that an elderly offender must serve before being eligible for placement in home detention is to be reduced by the amount of good time credits earned by the prisoner for other purposes. For purposes of markup, I move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 4018 to provide that the amount of
Without
time...
objection, the bill is considered as read and open for amendment at any point. I will begin by recognizing myself for an opening statement. In the view of the lateness of the hour, I will insert my statement in the record, and I will simply say that H.R. 4018 is a bipartisan bill that would permit elderly and terminally ill offenders who qualify for early release under a Second Chance Act pilot program the ability to receive good conduct time credits. I now recognize the ranking member of the Judiciary Committee, the gentleman from Georgia, Mr. Collins, for his opening statement.
Thank you, Mr. Chairman. My friend Hakeem Jeffries and I worked tirelessly along with all on this committee last year to hold criminal justice reform legislation. This is part of that. I firmly support this implementation of this Good Time Act. And I do ask, Mr. Chairman, this is my moment to do this, please, 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 I have asked since January for us to have a BOP oversight hearing in which we could discuss First Step Act. I know we've been crammed with a lot of stuff, but this is something that's important that we should have an oversight hearing on the Bureau of Prisons and the First Step Act. I yield back.
Thank you, Mr. Collins. Without objection, all other opening statements will be included in the record. I now recognize myself for purposes of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 4018, offered by Mr. Nadler. Strike all after the enacting
Without
clause and
objection, the
insert the
amendment
following.
is in the nature of a substitute will be considered as read and shall be considered as base text for purposes of amendment. I will recognize myself to explain the amendment. This amendment simply changes the caption to Section 1 of the bill to more clearly specify that the changes made by the bill apply to the application of good conduct time accrued by the relevant prisoners. I urge all members to support it. I yield back the balance of my time.
Yield back.
I will now recognize the ranking member of the full committee, Mr. Collins, for any comments he may have.
Yield back.
The ranking member yields back. Are there any amendments to the amendment in the nature of a substitute? The gentleman from Florida is recognized.
Thank you, Mr. Chairman. I want to thank you. I want to thank the ranking member and Mr. Jeffries for all of your good work. Elderly prisoners are among the most vulnerable in the nation's prison system. As people age in prison, they become more susceptible to mistreatment by younger predators. By clarifying good time credits are included, prisoners can participate in the home confinement pilot program. It'll enable additional elderly prisoners to participate in the program. I am grateful that we're having a chance to vote in the Senate. I yield back.
The gentleman yields back. Are there any amendments to the amendment in the nature of a substitute? No. Seeing none, the question occurs on the amendment.
Move to strike. Move to strike.
Who seeks recognition? The gentleman from Arizona is recognized.
Thanks, Mr. Chairman. I move to strike last word.
The gentleman is recognized.
Thank you. Mr. Chairman, I asked that an article from The Hill dated July 19th, 2019 be admitted without
objection.
Without objection.
Thank you. The article features a 77-year-old murderer who had been released, and he was deemed to be too old to kill. He was later convicted of killing someone yet again. And this is the concern that we have. And I think it's noble what you're trying to do. I think the bill's trying to address this issue, but there are some people that ought not to be released back into society, and with that, I can't support this. Thank you.
Without objection, we'll admit that. I recognize myself. This bill does not affect violent criminals. We're talking about people eligible for good time. Are there any other amendments? If not, the question occurs on the amendment in the nature of a substitute. This bill will be followed immediately by a vote on final passage of the bill. All those in favor of the amendment in the nature of a substitute respond by saying aye. 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 Opposed, no. In the opinion of the chair, the ayes have it. The amendment in the nature of a substitute is agreed to. Roll call on the... No. A reporting quorum being present, the question is on the motion to report the bill H.R. 4018 is amended favorably to the House. Those in favor respond by saying aye. Aye. Opposed, no. And the ayes have it, and the bill is ordered reported favorably. Roll call is requested. The clerk will call the roll.
Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Ms. Lofgren votes aye. Ms. Jackson-Lee? Ms. Jackson-Lee votes aye. Mr. Cohen? Mr. Johnson of Georgia?
Aye.
Mr. Johnson of Georgia votes aye. Mr. Deutsch?
Aye.
Mr. Deutsch votes aye. Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Jeffries votes aye. Mr. Cicilline? Mr. Cicilline votes aye. Mr. Swalwell? Mr. Swalwell votes aye. Mr. Liu? Mr. Liu? Mr. Liu votes aye. Mr. Raskin? Mr. Raskin votes aye. Ms. Jayapal? Ms. Jayapal votes aye. Ms. Demings? Ms. Demings votes aye. Mr. Correa? Mr. Correa votes aye. Ms. Scanlon? Ms. Scanlon votes aye. Ms. Garcia?
Aye.
Ms. Garcia votes aye. Mr. Neguse? Mr. Neguse votes aye. Ms. McBath? Ms. McBath votes aye. Mr. Stanton?
Aye.
Mr. Stanton votes aye. Ms. Dean?
Aye.
Ms. Dean votes aye. Ms. McCarcel-Powell? Ms. McCarcel-Powell votes aye. Ms. Escobar? Ms. Escobar votes aye. Mr. Collins? Mr. Collins votes aye. Mr. Sensenbrenner? Mr. Shabbat? Mr. Shabbat votes aye. Mr. Gomer? Mr. Gomer votes no. Mr. Jordan? Mr. Jordan votes no. Mr. Buck? Mr. Buck votes no. Mr. Ratcliffe? Ms. Roby? Ms. Roby votes aye. Mr. Gates? Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes no. Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. McClintock votes no. Ms. Lesko? Ms. Lesko votes aye. Mr. Reschenthaler? Mr. Reschenthaler votes aye. Mr. Klein? Mr. Klein votes no. Mr. Armstrong? Mr. Armstrong votes yes. Mr. Stubbe? Mr. Stubbe votes yes.
The clerk will report.
Mr. Chairman, there are 28 ayes and 7 noes.
Oh, you haven't voted yet? The gentleman from Florida.
Mr. Gates votes no. Mr. Chairman, there are 28 ayes and 8 noes.
The ayes have it. The bill as amended is ordered reported favorably to the House. Members will have 2 days to submit views. The bill will be reported as a single amendment in the nature of a substitute incorporating all adopted amendments, and without objection, staff is authorized to make technical and conforming changes. Pursuant to notice, I now call up the final bill of the evening, H.R. 2426, the Copyright Alternative and Small Claims Enforcement Act of 2019, or the CASE Act, for purposes of markup, and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 2426 to amend.
The committee will come to order, please. Clerk Clerk will report the bill.
H.R. 2426 to amend Title 17 United States Code to establish an alternative dispute resolution program for copyright
Without
small
objection, the bill is
claims.
considered as read and open for amendment at any point. I will begin by recognizing myself for an opening statement. In view of the lateness of the hour, I will submit my statement to the record. I will simply say that this bill, H.R. 2426, the Copyright Alternative and Small Claims Enforcement Act of 2019, or the CASE Act, would establish a voluntary small claims court within the Copyright Office to hear copyright suits seeking $30,000 or less in total damages. I support this bipartisan legislation introduced by our colleagues, the gentleman from New York, Mr. Jeffries, and Ranking Member Collins, and I commend them for their hard work in getting the bill to where it is, and hopefully we will approve this bill and report it to the floor today. I now recognize the Ranking Member of the Judiciary Committee, the gentleman from Georgia, Mr. Collins, for his opening statement.
Thank you, Mr. Chairman, and I will be submitting my statement for the record as well. I appreciate the work that Mr. Jeffries and I have done. I wish this bill could have, it was not at the late hour because we could have talked a lot better about this. This is a one bill tonight, especially in other things we've done, but from affecting the creative community, this is a major step forward. I appreciate the partnership we've had. Yield back.
Thank you, Mr. Collins. Without objection, all other opening statements will be included in the record. I now recognize myself for purposes of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 2426, offered by Mr. Nadler of New York. Strike all after the enacting clause.
Without
and insert
objection, the amendment in the nature of a substitute will be considered as read and shall be considered as base text for purposes of amendment. I now recognize myself to explain the amendment. This amendment makes certain technical revisions to the bill and includes provisions that freeze caps on fees and monetary damages for 3 years, preclude waiver of petitioners' and respondents' rights under the Act, including the right not to use the small claims process, and makes clear that the petitioner's right to elect damages at any time before the board issues a decision cannot be altered by a scheduling order. Each of these provisions strengthen the underlying legislation, and I urge all members to support it. I yield back the balance of my time. I will now recognize the ranking member of the full committee, Mr. Collins, for any comments he may have on the amendment in the nature of a substitute.
I agree with the changes in the nature of substitute and agree with that, and I yield back.
Thank you. Are there any amendments to the amendment in the nature of a substitute? The gentlelady from... I recognize first the... for what purpose does the gentleman from New York seek recognition?
Move to strike the last word.
Gentleman is recognized. The gentleman who sponsored the bill is recognized.
Let me first just thank the Chairman, Mr. Nadler, for your leadership, and the Ranking Member, Mr. Collins, for your tremendous leadership, as well as Hank Johnson, the Chair of the subcommittee, all of the other distinguished members on both sides of the aisle who support this legislation. In light of the late hour, I'll just abbreviate my remarks, but I do want to note that copyright infringement, of course, is not a victimless crime. Photographers, illustrators, visual artists, authors, songwriters, and musicians all rely upon their protected work to put food on the table and support their families. When their copyrighted work is used unlawfully, that is the functional equivalent of a burglary. Unfortunately, many small creators victimized by infringement often find themselves in a tough spot. They have a right to enforce their work under the law, but are unable to do so in a practical sense. On the one hand, there is the notice and takedown process that is often inefficient, cumbersome, and as any creator will tell you, pointless. On the other, there's the Article III federal court system that can be expensive, time-consuming, and out of reach for many. The average cost of litigating an infringement case in federal court can be approximately $350,000, but the total amount of damages that can be awarded in a matter contemplated by the CASE Act cannot exceed $30,000. In that instance, the cost of litigating a case in federal court could be more than 10 times that of the damages at issue. As a result, many petitioners are functionally unable to vindicate their rights under law. These creators are given a right without a remedy. Article 1, Section 8, Clause 8 of the United States Constitution gives Congress the power to create a robust intellectual property system in order to, in the words of the founders, promote the progress of science and useful arts. The founders of this great country understood that society would benefit if we incentivize creativity and innovation. In doing so, the creative community will continue to share their brilliance with the world and experience some benefit from the fruits of their labor. That is what the CASE Act is all about. I yield back the balance of my time.
Gentleman yields back. Does anyone else seek recognition? The gentlelady from California.
It's their turn.
Gentleman from Texas, I'm sorry, I didn't see you.
Just, thank you. This looks like a great simplification. Appreciate the work on it.
Mr. Chairman.
Gentleman yields back. The gentlelady from California.
Mr. Chairman, I move to strike the last word.
Gentlelady is recognized.
I want to say that I fully support the goal of this bill. For many small artists and creators, there is effectively no remedy for the infringement of their work. As Mr. Jeffries has mentioned, the federal courts are too expensive for the small but vital claims these artists have against infringers. And so I think the creation of a small claims tribunal to adjudicate these claims is very important to these artists and their creative livelihood. And I understand that the artists, the vast majority of whom just want to have an effective remedy they can use in good faith, support this bill. The gentleman from New York mentioned the notice and takedown provision in the DMCA, and I was on the committee when we enacted the DMCA, and I remember at the time expressing the concern that if the DMCA were used not for its intended purpose, but by people who wanted to suppress free speech, there would be a problem because there'd be no incentive for the platforms to actually fight back in such an instance. So whereas the artists may have a legitimate, I think they do have a legitimate concern about the DMCA takedown notices, what they aren't seeing is the misuse of the takedown notices, and there's no effective remedy for that. So the point I'm making is we have received today, and I would ask unanimous consent to enter into the record, a letter from the ACLU, statement from Mozilla, a statement from the Internet Association and the Computer and Communications Industry Association expressing concerns about potential implications for free speech that are not intended by this legislation. This bill creates a wholly new and really novel tribunal. We've never had anything like it in the copyright arena. Only one other nation has it, Great Britain, and from all I can tell, it's worked very well in Great Britain. But I do think we need to have some further discussion and work on the issues raised by the ACLU and others. I had prepared an amendment to create a sunset for the bill that would give the committee a date certain to review how it's worked. But I was going to offer it and then withdraw it. I'll just say I was going to offer and withdraw it so we don't have to take the time to do that. I just wanted to create this issue and to say I want to work very closely with the authors of this bill, because unless these issues are resolved, this bill is not going to make it in the United States Senate. And I think that would be a shame, because I do think this is an important element for the creative community so that they can get justice and protect their work. So I would be happy to yield to the
Without objection, the letters will be entered into the record.
I appreciate the distinguished gentlelady's thoughtfulness in terms of an expressions of support as it relates to moving forward to try to find common ground. The bill has moved out of the Senate Judiciary Committee, passed on a unanimous basis, but of course we look forward to working together to make sure that we can reach a point where we know that this effort will result in a bill being signed into law. If you wouldn't mind, I also ask unanimous consent, Mr. Chair, that letters of support be entered into the record from the American Bar Association, the AFL-CIO, the NAACP, the Copyright Alliance, the Chamber of Commerce, the Association of American Publishers, the Authors Guild, Creative Future, Nashville Songwriters, as well as the Recording Academy and the Songwriters Guild.
Without objection.
Reclaiming my time, I will support this bill today, understanding that we will continue to work to address these issues that have been outlined to us, and understanding that there is tremendous interest in the country to provide for this remedy, but the Senate is a place where a single senator can bring something to a halt, and I think we have some work to do, and I'm hopeful that I can play a productive role in making this whole thing happen, I'd be happy to yield.
Yeah, well, and that is a sad state of affairs that a bill like this would have, you know, the threat of a single senator because of an interesting letter from some of these who have claimed not to be part of this process. This is really not even a process that has been out there. This bill's been out there for a long time. And I really would have liked to have seen the ACLU actually weighed in a little bit heavier on due process that was seemingly just overrun today. But they chose not to. They chose to get into the pocketbooks of creators, and I yield back.
Reclaiming my time, for a group that insisted that we could only have a trial and never have, well, I'm not going to get into it. I want to see this completed successfully, and I'm hoping that working with the authors that we can make that happen.
Yield back.
I yield back.
The gentleman from Colorado.
Thank you, Mr. Chairman. Mr. Chairman, I just have a quick question for you or someone knows more about this bill than I do, but this seems to me to be a markup of contradictions. 8 hours ago, we started with a situation where the majority moved a bill because forced arbitration was wrong. We argued that it would cost too much to go to trial. Now we are saying that it costs too much to go to trial, and so we want to look at an alternative. Why is this better than going to trial, and it's not?
Would the gentleman yield?
Sure.
Because this is not mandatory. The defendant has the opportunity to opt out of the system. The concern that's been expressed is that for small persons, $30,000 is a lot of money, and for an unsophisticated defendant, that they might be subject to an extorted smaller amount because of concern about the dollar amount. I'm not sure I have that same concern, which was why I thought the remedy of a sunset and let it see what will happen might be the best approach. But this is not mandatory arbitration, and I thank the gentleman for yielding.
I yield to the gentleman from Georgia.
I think you bring up an interesting point, considering it is a capped at $30,000. These are truly small claims that we're looking at here, and providing an alternative, which we all believe it should be an access to courts, and do it in a way that has both parties' interest in mind. It's really an interesting proposal here, but I think you bring up an interesting point that there was silence on other things here, but with this, in which you could find remedies for both parties to actually move through systems quicker, I think we find an interesting contradiction. But we'll get this bill passed, and I do appreciate it.
Thank you, and I yield back, Mr. Chairman.
Gentleman yields back. The question occurs on the amendment in the nature of a substitute. All in favor?
Aye.
Aye. Opposed? The ayes have it. The ayes have it. A reporting quorum being present, the question is on the motion to report the bill H.R. 2426 as amended favorably to the House. Those in favor respond by saying aye. Aye. Those opposed, no. And the ayes have it, and the bill is ordered reported favorably. The ayes have it, and the bill is reported favorably to the House. Members will have 2 days to submit views. The bill will be reported as a single amendment in the nature of a substitute incorporating all adopted amendments. And without objection, staff is authorized to make technical and conforming changes. I want to thank all the members and the few people in the audience who stuck it out for their patience and their fortitude in this lengthy markup. This concludes our business for today. Thanks to all our members. The markup is adjourned.